Sir. Very nice to meet you. Thank you very much. Mike Quinnen. Mike Quinnen. He moved to a different firm, so he's at Thompson McMullen now, and the group decided to retain our services. But he's doing quite well, and he's still practicing down in Richmond. Thank you very much. I'll pass along your regards.
How do we have this not indicative of the day?
Gloria, let me know when it's time.
We're good. I'll get myself figured out here at
Where's
some
my
point.
thing? I don't think so. My power, my symbol of power. Good morning, everyone, and welcome to the Delaware Public Service Commission meeting. Is it August the 4th? August the 4th. Unfortunately, Commissioner Conaway cannot be with us. She's not feeling well today, but she will be springing back into action for August 25th, and I'm sure she'll be well. And Commissioner Gray has had an unforeseen delay in his arrival. He'll be a few minutes late, and he's asked us if we have a quorum, which we do, for us to proceed. So I want to do that, but before I do, I think we're going to start with reverse order. We're going to do the administrative matters, which are going to be very, very brief. And we'll do the consent agenda as usual, I guess the minutes as usual. And then we'll go into the opening statements. So hopefully Commissioner Gray will be here at the very beginning. I just want to say at the outset that pretty impressed with the work done in this case. Commissioner Lawrence did yeoman work in terms of gathering all the record together and getting things accomplished. All the parties were terrific with respect to their input, and their exceptions were well explained. And I don't know who put together the issues document, but that was excellent, and it was very helpful to me. So I want to express my and our appreciation to it was a lot of work to get that done, and it's really pretty good in terms of encapsulating the arguments.
If I might, Mr.
It's
Chairman,
not a part of the record. Go ahead, sir.
I would just like to acknowledge the person who did most of the work, and if this was me, of course, I would take all credit. But Mr. Path, who did the lion's share of it, I too think it's quite good. I mean,
Thank
seen a
you.
few of these that I've done over the past, his is much better.
I thought it was excellent, so thank you, Mr. Path. Thank you so much. Okay, I guess if we could, we'll start with the reading of the meeting minutes of July 14th. Does any commissioner have any changes, corrections to the minutes of July 14th? And if not, we're going to have the unofficial by eye presence made on the record now. Commissioner Creel, you're here, present.
Hi.
That's a tough question, I know.
Yeah, I'm thinking. So I move that we adopt the minutes of July 14th.
And you agree you're present too, right?
Yes.
Commissioner Drexler, you're present, right?
I am present and I second.
And I'm present, and so we have a quorum, and Is there any discussion on the motion? Hearing none, all in favor signify by saying aye.
Aye.
Are there any opposed, any abstaining? Two absent. The consent agenda, any commissioner have anything that they wanted taken off the consent agenda and put on the regular agenda? Commissioner Drexler.
Motion to approve the consent agenda as presented.
I second it.
Is there any discussion? Hearing none, all in favor signify by saying aye.
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 Are there any in opposition? Any abstentions? The consent agenda is adopted. Administrative matters.
Thanks, Chairman Wenzel. So 3 items of note. We do have a hearing next week regarding a formal complaint involving Delmarva Power and Gwendolyn Scott Jones. That'll be August 11th here in Dover. On the 18th, we have a public comment session regarding the Veolia Suez matter. That'll be in Newcastle. And finally, our next meeting is on the 25th. And at that meeting, we will have a hearing regarding Delmarva Power's energy efficiency surcharge rider. Thanks.
Thank you, Mr. Hartigan. Now we're going to start into the hearings, and we have in the matter of the application of Delmarva Power and Light Company for an increase in electric base rates and other miscellaneous tariff changes. And I guess we have with us our counsel, Mr. O'Brien, and we have the parties all here. Everybody's represented, and I believe that we should start with Delmarva Power and Light because they're the applicant in this matter. Is it Ms.?
Thank you, Chair Winslow. My name is Courtney Schultz. Thank you so much for allowing me to be here with you today. If I may, I'd like to begin with the opening statement for Delmarva Power.
You may, and the record should reflect that Commissioner Gray is present.
Perfect timing. Shall we wait 2 minutes, let him get settled?
He's quick on his feet. He's no
Okay.
problem.
Great. Can everybody hear me?
Yes, ma'am.
Okay. Better? Okay,
Good morning,
great.
Mr. Chairman and the rest of the guests in the hall. I underestimated how long it was going to take me to tie my necktie this morning after 2 years. I apologize for being late.
Thank you. So, thank you again, Commissioners. I think it's important to start at the outset here and to just level set with what we're looking to do here. You've heard a lot in this case and in the recommended decision about the burdens of proof. And I just want to remind everybody, which everybody knows, in this case, on this application, it is Delmarva who has the burden of proof, but that burden is to show simply that the rate that they're seeking is just and reasonable. And reasonable in so determining focuses truly on necessity and cost to provide safe and reliable service to the customers. And so with this in mind, the Commission should assess and address each and every one of the company's proposed adjustments and the hearing examiner's analysis, or in some cases lack of analysis, for each independent issue. And I'm sorry, do you mind if I wait while that's, it's distracting. Okay, thank you, sorry. So we really should address each and every adjustment or cost or expense or rate-based item independently and on its own merits, based on the evidence in front of us. And so the goal in this case should really be to review the company's evidence and where, for example, expenses have been ordinarily incurred or have been determined on the basis of the company's business judgment and are reasonable, they should be approved. And when there are adjustments to certain expenses for known and measurable changes, those too should be approved, where those changes would better reflect the true cost of rates during the rate effective period. In other words, while Delmarva is not at all suggesting that it should, quote, be guaranteed the right to recovery, of its expenses, capital or otherwise, it does believe that it's entitled to set rates designed to produce revenues sufficient to recover its legitimate expenditures, especially where there's no finding or even suggestion in this case that any of those expenditures are in bad faith, inefficient, wasteful, or in an abuse of discretion. You'll likely hear a lot of comparisons today and tomorrow to docket 13115 and other prior Delmarva rate cases, but I want and would urge each of you to keep in mind, as you do, as to whether or not the evidence in this case is the same or different, and whether or not the circumstances present today are the same or different than they were in docket 13115, which is the last litigated case before the commission. In this case, Delmarva has made adjustments that are consistent with the law, consistent with the commission's regulations, and with precedent. And in many of these cases, the hearing examiner has disallowed without justification or analysis, in some cases, which even reverse longstanding precedent of this commission, many of these adjustments and expenses. And these departures from precedent or the law that result in disallowance must not be allowed to stand. They are improper, and this commission should correct those errors. Further, I would urge you not to be preoccupied by the size of the company's rate base. The company's rate base has grown organically over many years as a result of many different proceedings before this commission. This is not the appropriate inquiry or factor for the commission to base decisions upon. The DPA focused the hearing examiner's attention on this, and he used it on more than one occasion to disallow an otherwise reasonable, verifiable, and supported adjustment. You should not do the same. You should go item by item and evaluate these issues on their merits. I would acknowledge, as I think every party would and has in this case, that proceeding in accordance with precedents is important for rate-making consistency. But in cases where the facts are new or different, a change may be warranted. And the commission is bound to review and consider those circumstances when rendering its decision today. Additionally, I would like to just take one moment to disabuse you of the notion that Delmarva has been anything other than candid and transparent when it comes to this case. There have been a number of references to conspiracies, cover-ups, wild accusations of wrongdoing on the part of Delmarva, and none of it is true. All of it has simply been a distraction, I believe, to detract from the merits of the case, which are otherwise very, very strong. Similarly, there is no evidence whatsoever that Delmarva's employees and its directors are not acting on the daily with the best interests of the company's customers in mind. To speculate otherwise, as staff and DPA have done throughout references to Exelon's earning per share or the Exelon value proposition, are again another distraction from the merits of the case. What is true is that Delmarva has invested appropriately and reasonably, and not a single capital expenditure in this case has been challenged. In closing, I think it's important also to recall and remember that the regulatory environment in Delaware is critically important to how the company operates. Our customers have continued to receive safe and reliable service throughout the pandemic, as always, which was made possible by Delmarva's employees who live and work in Delaware despite the difficult circumstances that they themselves faced on a day-to-day basis. And still, Delmarva received top rankings from J.D. Power. Yet, if the commission were to accept all of the recommendations of the hearing examiner, the message that sends to Delmarva is that you've done everything right and you've made the proper investments for safe and reliable service for your customers, but you should only get 30 cents on the dollar for those legitimate and otherwise just and reasonable expenses. And I would argue that that's not the proper result here. And this protracted litigation is about reasonableness, is not about the reasonableness of the spend. In fact, no parties really dispute the reasonableness of the spend here. What is in dispute is, in fact, the rate-making treatment and the accounting treatment for most of these issues. And so with that, I would essentially just urge the commissioners, and thank you in advance, to carefully and thoughtfully considering the parties' positions on each and every adjustment, expense, and rate base item as they come before you over the next day and a half. There are important issues in this case. Some of them present issues of first impression before the commission. And it is critically important to Delmarva to be here today and to litigate these issues, to receive some guidance from the commission on what the appropriate rate-making treatment is in Delaware and what it should be doing going forward. Thank you very much.
Thank you, Ms. Schultz. Mr. McCormick?
Thank you, sir. Tim McCormick from the law firm of Christian and Barton, and may it please the commission. Here on behalf of the Delaware Energy Users Group, or DUG. DUG represents large customers of Delmarva Power and Light, and it's an honor to be here today. Very briefly, for the commissioners, DUG respectfully requests, consistent with the hearing examiner's recommendation, that the commission approve and adopt without modification the terms of the partial settlement as presented by the hearing examiner. The partial settlement represents a reasonable compromise of the parties' positions with respect to class revenue allocation, and the partial settlement resolves DUG's unique issues as filed in this case. As stated in DUG's filed comments regarding the other issues in this case, DUG generally supports the positions taken by the commission staff and the Delaware Public Advocate in advocating for a lower revenue requirement for Delmarva Power and Light, because doing so will keep Delaware businesses competitive. However, DUG does not take an express position on any particular adjustment or finding of the hearing examiner, except first, the endorsement of the partial settlement and concurrence with the calculations of the staff and DPA witness, Mr. Gorman. That's all from the Delaware Group this morning. Thank you.
Thank you, Mr. McCormick. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. It is a pleasure to be with you today. It's been a very long time since we've all been together. Hope everybody has been healthy. I'm handing out a packet of documents that are either excerpts from previous orders or excerpts from documents that were admitted into evidence in the hearing. Please ignore the number tabs. Unfortunately, I work for the state and they didn't have enough number tabs for me to give everybody once it said the actual numbers of them. So I do apologize. Hopefully it won't be too confusing.
Well, I beg to differ. I think it's fortunate you work for the state.
Thank you, Chairman.
Thank you.
I appreciate that. Thank you for the opportunity to provide this brief opening statement. In our exceptions, we predicted that Delmarva would try to scare you with dire warnings about how the hearing examiner's recommendations would result in financial disaster for it and would jeopardize its ability to provide safe and effective service. And Delmarva did not disappoint in that regard. It argues that the hearing examiner's recommendations result in it only being granted 32% of the $26 million rate increase that it requested. But that $26 million rate increase was an inflated request from the start. It included a 10.30% return on equity, which by itself tells you all you need to know. Capital has been the cheapest it's ever been for a decade now, yet Delmarva asked for a double-digit ROE. The request was ridiculous on its face, and the fact that Delmarva isn't accepting to the hearing examiner's recommended 9.6% ROE, 70 basis points lower than what its witness insisted was absolutely necessary to satisfy the Bluefield and Hope requirements for a fair return, and 10 basis points less than its currently authorized return, proves that. That alone was worth almost $5 million of Delmarva's proposed increase, which takes it down to about $21 million. Delmarva also sought a general non-labor operations and maintenance inflation adjustment. The DPA thought that particular issue had been put to bed decades ago, No utility has tried to include such an adjustment for 25 years. This adjustment was worth $600,000. And then there is Delmarva's inclusion of $30 million of post-test period plant and rate base worth about $3.8 million. The commission knows that Delmarva went to the General Assembly and secured a distribution system improvement charge, or DSIC, for electric and natural gas companies. And although Delmarva complains that it hasn't had a rate case in 3 years, remember that Delmarva agreed to a moratorium on filing a rate case until January 1, 2020, in order to get the DSIC. It could have filed a rate case before January 1, 2020, but per the statute, it wouldn't have been allowed to collect DSIC if it did that. So Delmarva made the business decision to collect a return of and on $3.225 million of eligible DSIC plant between the effective date of the DSIC legislation and the date that interim rates went into effect in this case. And Delmarva then filed this rate case a mere 2 months after that moratorium expired. But notwithstanding that the DSIC and the Commission's implementing regulations allowed Delmarva to file DSIC applications for DSIC-eligible plant added while this rate case was pending, Delmarva included the post-test period DSIC-eligible plant in rate base in this case. We'll explain during the argument on that particular issue why, as a matter of law, that adjustment should be rejected, but it's yet one more example of Delmarva enlarging its revenue requirement. Since docket number 13-115, Delmarva's rate base has increased by 50%, from $619.5 million to $910 million. This increase includes a period when the Exelon PHI merger settlement agreement limited Delmarva to a total of $225 million of capital spending between 2015 and 2019. And it also includes the period during which Delmarva vastly exceeded the reliability metrics established in that merger settlement agreement. But you may ask, why is that rate base increase important? Because ever-increasing rate base, the vast majority of which is plant and service, is Exelon's game plan going forward for its regulated utilities. And how do we know that? Because Exelon told its investors on a November 2020 earnings conference call that the Exelon value proposition included, quote, regulated utility growth targeting utility EPS rising 6 to 8% annually from 2019 to 2023, and rate-based growth of 7.4%, representing an expanding majority of earnings, end quote. And you'll find this in the excerpt of the document that is at the first tab of your package, at the first bullet point. And this is from a document that was admitted into the record as Exhibit 53. So we and you can expect to see more and more plant being added, and the DPA doubts very much that the DSIC is going to reduce the number of rate cases in the short run. Delmarva argues that nobody objected to any of the plant, but rest assured that will be coming in Delmarva's next base rate case, because the Commission's distribution planning regulations have opened a window into Delmarva's proposed capital spending that staff and the DPA have never had before. So when you are considering the contested issues, we do agree with Delmarva that you should consider them on each of them on their own merits. We ask you, however, to keep 2 things in mind. 1, Delmarva always says its entire proposed rate increase is necessary for it to provide safe and reliable service and to access the capital markets. And second, Delmarva always manages to provide safe and reliable service and access the capital markets, despite this commission never awarding it 100% of its requested rate increases. Thank you for the opportunity to provide our opening statement.
Thank you, Ms. Iori. Mr. Geddes, are you going to present evidence with respect to the agreement so we can get that on board and maybe behind it?
Settlement agreement, I was not gonna address it in my opening, but I'd be happy to.
Well, after your opening, how are we gonna handle that? We might as well get it done and accomplish something, right?
Well, the hearing examiner, with obviously comments from the other parties, he has suggested to the commission that they should approve it. There's an order attached to his report that would approve it, and if you'd like to take that separately, I don't know whether the other parties would object, but I believe all parties that are appearing before you today support the partial settlement.
Okay, well, why don't we, and when it's appropriate, after you finish your opening statement, why don't we get that accomplished and behind us?
Okay? May I begin?
Yes, please.
Good morning,
Good morning.
Commissioners and Mr. Chairman. It is nice to be back after 18 months being away. I believe the last time I appeared before you was February of 2020. A lot has happened in everyone's lives since then.
Excuse me, Mr. Geddes. All those who are calling in, would you be kind enough to check and make sure you're on mute? So if you're out there, don't put us on hold. Because it adversely impacts our program here.
I hope this isn't being taken away from my time.
Oops, where's the agenda? Oh, you got it? Okay.
The conference room.
All of those who are out there listening in on the Public Service Commission meeting, please check your devices and make sure you're on mute. Thank you very much. And also, please don't,
Code has been detected. Please hold for the next available operator.
Matt, it says no password has been detected. Is there a password you're supposed to put in? Okay. Mr. Geddes, we're going to proceed and try to fix the phone situation as soon as we can.
I'm sorry, I missed that. Are we ready to go? or
Please
not?
proceed.
Okay. Actually, it's funny, because of that little, shall we say, technological problem, I was remembering the first time that I appeared before this commission and being involved in a case called 8222. And I wrote that time for the commission a very pithy 10-page opinion with no date on it. One of the references that Ms. Iori made, and I believe Counsel for Delmarva made, was to the last litigated case, which had a date on the first page and was 156 pages. Now, you can take from that whatever you'd like, but things have changed a little bit, including our ability to communicate and to attend hearings before the commission. First slide, please. Technology is great. First slide, please. I know you were doing something else. All right. So, again, to set the table and also to follow up on what the hearing examiner said as he reviewed this case. And I believe Counsel for Delmarva suggested that the burden is on the company, and that is true. And the burden to establish just and reasonable rates is on every component, as set forth there, of the rate request, as the hearing examiner mentions on page 25. Against that is the template of precedent that the commission is well aware of, which is assets have to be used and useful, expenses have to be known and measurable, and for rate-making purposes, the commission should adopt the latest available book entries for the utility if they accurately represent the condition of the company. And as you know, staff and the DPA and other parties attempt to investigate filings and application and to obtain books and records that the company has exclusive use of, and to try to give the commission enough information so the commission can make an informed decision on the application. And in this case, I believe there are 20-some uncontested adjustments and some 30 contested adjustments. So not everything that Delmarva proposed was something that the staff or the DPA objected to. But there were some significant issues, as Ms. Iori pointed out in her opening, that were not agreed to. All staff is seeking in any of these cases is a fair opportunity to present to you what we believe are important issues so that you can do your job. That's all we're trying to do here. And in some cases, it gets a little heated, and sometimes some of the parties become upset. But we're trying to do our job, and that's all we're trying to do. Second slide, please. So in this proceeding, these are the following facts on which to judge the just and reasonable rates. The company asked for the first, well, I guess in 17, that was partially forecasted, but historically, in the last several cases before the 17 case, the companies used historical information and then adjusted it for known and measurable changes. In this case, they suggested that 3 months of the test period be forecasted. But when they did that, they then opened up Pandora's box, because when asked to provide actual information, which they had for the post-period last 3 months of the test period, we were met with non-cooperation. We filed a motion, asked for the information. The company opposed it. They did give us the O&M information updated, but they didn't update all the accounts, notwithstanding the fact that they are asking you to approve reliability investments up through September 2020, 6 months after the test period ended. As DPA witness Watkins indicated in his testimony, page 20, the forecasted plant additions for just that last 3 months of the test period were almost twice what the company actually put in service for that period. So the question is, and the hearing examiner, I believe, fell into this trap, when do you use forecasted information and when do you use actual information? Going back to the prior slide, if you have book entries and you know what that is, that should be used. You shouldn't use a forecast if you have something better. Now, there needs to be balance, but the idea is, well, we don't have to provide it is not the answer to that question. Next slide, please.
Pardon me, Mr. Geddes. Am I allowed, Mr. Chair, to ask a question for clarity?
You are, but I'd prefer if you wait till he finishes.
All right, that's fine. Thank you.
If you look at the next slide, this is an example of what we've called mix and match and inconsistency. And unfortunately, hearing examiner, I believe, respectfully, did not apply his principles that I articulated uniformly. The customer count, which was an issue that DPA brought up, which affects revenues for the test period, the hearing examiner agreed with the DPA that the forecast was not as reliable as the actual numbers, which was in their testimony. And so he granted that based on the fact it was known and measurable and was more accurate than the forecast. But when it came to O&M expenses, which Delmarva's own witness admitted for the last 3 months of the test period were $3 million more than the actual expense, and the DPA witness as well as our witness wanted to make some adjustments to actual numbers. Actually, the DPA wanted to adjust the whole thing to actuals. The hearing examiner didn't agree with that, and the company didn't agree with it. They, in essence, my paraphrasing, it's close enough. Well, it's not close enough. That's $3 million of ratepayers' money that's going to be charged out of their accounts collectively for a forecast that everyone knows is wrong. And the company even admitted it. So as you go through these various adjustments, I hope you think about some of the inconsistencies, and when we are arguing about some adjustments that should be based on actual information, known and measurable, rather than forecasted information, I hope that you will consider those arguments. Finally, the hearing examiner in supporting this particular position states that there are no issues with Delmarva's forecasting model. With all due respect, I don't think he read Mr. Watkins' testimony, pages 17 through 20. And if you want to understand some of the specifics that both staff witness and the DPA's witness had with the forecast, they are articulated there. Forecasts are difficult. Jim Watine once told me in the 1990 case, the only thing about a forecast that you know, it's wrong. The only issue is whether it's wrong high or wrong low. And in this case, when you have actual information that shows that the forecast is wrong to the high side and to the detriment of ratepayers, I mean, I suggest respectfully that we should use that actual information. And so I hope that you will be cognizant of that, those disconnects as we go through the various issues that we will discuss. Thank you for your time.
Thank you very much, Mr. Geddes. Commissioner Gray?
Thank you, Mr. Chair. Mr. Geddes, you mentioned something about the reliability through September.
Wait, I'm sorry, Bill, yeah, okay, sorry, I was just trying to see you.
I'm sorry.
No,
Okay.
no worries.
You mentioned something about the reliability through September. I was just curious, are those actual numbers or forecasted numbers in this context?
They were forecasted at the time they were presented. By the time the case was tried through the rebuttal phase, they were actual.
Was there any significant difference in, you say it's wrong, right? In which way was it wrong?
Well, my issue was with regard to the original filing of the case. And the filing based on forecast was higher, almost double, than what the actual numbers were.
Okay, thank you.
Mr. Geddes, do you want to present the basis for the acceptance of the partial settlement agreement?
I'm sorry, Your Honor.
Who's going to represent the parties and present the partial settlement agreement?
I'd be happy to, Your Honor, since there
Thank you.
seems to be some reticence. This, on the other parties.
Ms.
I know that the attorney for DEUG is very interested in this, and I believe the other parties are as well. We were able, through negotiations with the various parties, to come up with a partial settlement. It is highlighted in the hearing examiner's report. He's issued an order. I don't think anyone has taken exception to it, and I would move on behalf of staff and the other parties that you accept the partial settlement agreement and adopt the order as written. Thank you.
Any other party have any comment to make? Hearing none, any commissioner have any questions of any of the parties with respect to the partial settlement agreement? May I have a motion? Commissioner Gray?
Mr. Chair, I move that the partial settlement agreement be adopted as submitted.
I second the motion.
Is there any discussion on the motion to approve the partial settlement agreement? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any in opposition? Are there any abstentions? There is one person absent. The motion has been passed. Now, I want to thank you all for your opening statements. I just want you all to know that this group of people up here, it's a rather mature group of people, to be kind to us. And we assure you that we don't feel threatened, coerced. We're not concerned about statements made on calls outside of the record. We're just here to hear the issues one at a time, and we're going to do it use our best judgment. And I'm absolutely positive we're going to make everyone in a room upset because we're not going to agree with any party all the way down the line. I'm sure of that. So what I'd like to do is go with issue number one, and I think it might be good if each party will give like a minute. I mean, after all, and you don't have to even say anything because there's been a really nice issues list produced. So if you have nothing to add to what's written, your silence would be appreciated because Mr. McCormick, his issue is already over with, and he might want to leave soon, but he doesn't want to stay here through Friday.
Thank you, sir.
And his client doesn't want to pay him to stay here through Friday. So let's start, if we could, with the summaries of contested issues. And we'll start with page number 3, and it says actual revenues versus forecasted revenues. And the only comment I make as a precursor is that, having heard the opening statements and read the materials, is it speaking for myself, where you're going to advocate for forecasted figures over actual figures. Kindly, as part of your presentation, tell me why a forecasted figure would be more just and reasonable than an actual figure. So number one is, as I said, actual revenues versus forecasted revenues. We'll start with the company.
Chairman Winslow, one point of order. That issue, this is my fault when we were putting the final issue sheet together. That actually, nobody has taken exception to the hearing examiner's recommendation on that issue. And unfortunately, I forgot to delete that page. So I don't know that anybody disagrees with the hearing examiner's recommendation on that. So we could probably just skip to the next issue.
Or I think we should vote on this issue, or not. Go ahead, Mr. Geddes.
You asked Delmarva to go first. If council defer to me, there is a point of clarification I'd like to make here.
Why don't you go ahead and make your point of clarification, and then I'll see if it's any needed, John.
This is only related to the customer count specifically. It's illustrated by other information, but specifically, as I understand it, that the customer count issue, which the DPA raised, and which the company originally objected to, when the hearing examiner resolved it in favor of the DPA to use the actual information for the fourth quarter of the test period, January through March, the company then agreed to use that information, which would increase revenues. But that issue doesn't resolve the overarching issue that you, Mr. Chairman, raised, which is on other issues using actuals versus forecast. But on this particular issue, the DPA and the company have agreed that the actual customer count for the fourth quarter of the test period, January through March, would be used for the purposes of establishing rates. Thank you.
Commissioner Drexler, would you make a motion, please? I'm sorry.
I'm sorry. I just wanted to make one point of clarification myself. Yes, Delmarva did elect not to take exception to this limited issue, and this issue simply replaces the residential customer count for the 3-month period. It does not replace anything else. It was the only issue raised by the DPA with respect to the revenue component of the forecast versus actuals. Residential only. All other customers are still using forecasted 3-month numbers. It is simply the residential customer count.
Thank you very much. Commissioner Drexler?
Yes, I would like to make a motion to accept the hearing examiner's recommendation that the count for the residential customers be the actual count to be used for the period of January 20th through March 20th.
Second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Are there any opposed? Any abstentions? Issue number 1 has been resolved as...
Mr. Chairman, sorry for the interruption. With respect to and related to the company's decision to acquiesce on this particular issue with regard to the residential customer account, and you raised this question, I think, when you first started your opening statement, and I'm just wondering, as an overarching principle, if the company acquiesced in this case, can I ask why? And therefore, why not acquiesce to actuals in every other case as we walk through this?
The only comment I'd make on your comment is that I think the company is in a situation where they've had advice probably from lawyers and have made company decision, and that decision-making process is probably something they don't want to reveal. So I don't know if you want to reconsider that question, but we're going to be addressing this issue on more than one occasion as we go through the individual issues.
Fair enough. I just was seeking an overarching principle as we move forward that might streamline the decision-making process. I yield back, Mr. Chair.
Yeah, I think that everyone has got sort of like the die is cast. The company has a position, all their parties have a position, and we need to go through it one at a time and make decisions, and we're going to go to number 2. And I believe I've got number 2 here. It's actual expenses versus forecast expenses. And we'll go with the company, please.
Thank you, Mr. Chair. So you asked why the forecasted figures should be used in lieu of the actual figures for the 3 months during the test period. And the answer is very simply that the regulations speak to how the company may file its case. The company may file using a fully historic test period. It may file using a partially historic, partially forecast test period. In this case, consistent with the MFRs, the company elected to file using 6 months historic, 6 months forecasted data in its test year. What the MFR requires under that circumstance is that the company, within the course of the case, update 1/4 of that data before the conclusion of the case. And so that is what the company did when it updated the 6+6 forecast to the 9+3. And so as permitted by the MFR section 1.2.3.1, when the test period was other than the test year, we updated the actuals for that quarter. That was all that we were required to do. There is nothing in the MFRs that says because you filed a 6+6, you must file a 12+0. Staff did in fact file a motion to compel in this case, to compel the company to update its entire case from 9+3 to 12+0. There was a simultaneous order in the then pending gas rate case that was resolved in Delmarva's favor, and staff withdrew its motion in this case, which is why the company did not update all of its data to 12+0. However, staff had a discovery request to the company that it had asked for the company to update its O&M expenses. The company gave staff, in good faith, the updated 12+0 O&M expenses only, so that staff could evaluate the reasonableness of the forecast that Delmarva had put together. And when that information was provided, it yielded what the hearing examiner found to be a reliable, reasonable, and verifiable forecast on 3 months. That was merely 2.21% higher than the actuals. And that's on over $100 million worth of expense. He found that to be more than reasonable. And coupled with the fact that the company wasn't required to do that update, found this to be an appropriate basis upon which to use forecasts. The corollary to this is also to remind you that were you to determine that the company was required to use the actual 3 months here, it is going to unfairly reflect in other areas. Because the company was not required, based upon the withdrawn motion to compel and the MFRs to update the entire case to 12+0, there are other elements of revenues and other aspects of the case that are not going to be updated, that had they been updated, may go in the customer's favor, may go in the company's favor, but we don't know, and we can't know on the basis of the record in front of us. And so that's why it's Delmarva's position that the hearing examiner's recommendation in this regard was correct and that the commission should adopt it.
Ms. Schultz, I'm required to reconcile my checking account every month, and I do it. And I just push the button. Go reconcile now, and I push the button, and it pops up and shows I miscalculated by something, or it says 0, and I'm done. Is it a burden on the company to use actuals under the circumstances of this case? I mean, don't you have pretty sophisticated accounting, and aren't you able to keep track of your expenses and your income on a monthly basis?
I wish it were that simple. I wish it were that simple that I could push a button and reconcile my accounts, but I do it the old-fashioned way. I'm not suggesting to you the company does it the old-fashioned way, but there are a lot of inputs within this case. It's not simply a matter of updating an expense and updating a revenue. It's, you'll hear later, updating billing determinants. What should we use? When do we update? If you change one, you have to change them all. There are invariably hundreds of thousands of inputs that go into this. It's not a simple, I can put the number in, push the button, and it spits it out. There's also hundreds of man-hours for individuals who need to do these things. It's not completely a computer that can do it. And there's a lot of cross-checking that goes on, because if you change one thing, it may impact another expense or a deduction on the other side of the line, which is not an automatically generated process. So if it were as easy as you suggest to push a button, I would agree with you. Absolutely, we should always do it. But it's just not that simple. And in the context of these cases, which I'm sure you can appreciate, where Delmarva is, after it files the case, dealing with hundreds of thousands of subparts of discovery questions and trying to respond to all the different requests for information and generation of different data reports for staff and DPA to help them understand what is in the application, to then require them simultaneously to go reconfigure the entirety of the case to update every 3 months or until they hit an actual is not realistic. And it's also not in line with the MFRs that doesn't actually require that function to be performed.
Well, I think the company has obviously benefited from the MFRs and from forecasts, and I don't begrudge them that. I think it's appropriate. On the other hand, when we have actuals, or should have actuals, I feel pretty strongly that actuals should be used, because that's more accurately reflects to the benefit of the company or the benefit of the consumer. I mean, that's just my personal opinion on it, and I don't know how my fellow commissioners feel. Mr. McCormick, you don't have any comments, do you?
No, sir.
Okay, I'm going to ignore you. Please don't feel personally offended. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. I will keep my comments brief per instructions. You asked why Delmarva didn't update, and basically the answer that you got was, we don't have to under the MFRs. You heard Ms. Schultz talk about the hundreds of thousands of discovery subparts. That is more than an exaggeration. While there may have been hundreds, there weren't thousands. But here is what all you need to know. They had the actuals. They provided them to staff. They could have used them in rebuttal. What they did do in rebuttal was update their rate base items, or at least some of them, particularly the post-test period plant in service, to actuals. So that it may take time to do it, we do not deny that. Of course it does. But the fact of the matter is, they did do it. They had the information. They could have done it. They relied on the MFRs saying that they didn't have to, and the hearing examiner in the gas case agreed with them on that.
Thank you. Mr. Geddes?
A short follow-up. As I said in my opening statement, and as a hearing examiner acknowledged on page 25, the company has a burden on every component. So when the staff or the DPA challenges the company and says, all right, let's just take O&M, which was slide 4, and we think that that forecast is, we'd like to get behind that forecast, that's exactly what happened in this case. They, as a part of resolving the motion to compel, because we wanted all the data, they agreed to give us the O&M for the fourth quarter. And you saw the slide. It was $3 million higher than the actual number. And if you take the 2.21% and change the denominator, it's more like 9%. That's a hypothetical. The evidence before you is that for the last quarter, it was $3 million more. And that's exactly what the staff and the DPA are supposed to do. if they challenge an adjustment or they challenge a book entry, remember the company's got all the books, then the burden of persuasion is, or proof is on the company once it's challenged. And I don't think that slide and the hearing examiner's analysis and Mr. Watkins' commentary about the difficulties with the forecast on page 16 of his testimony should give you much credence that if this was further looked into, like we had all the actuals, there might have been other adjustments. They may have gone the other way. Nobody knows. There's no evidence on that. What we do know is that for the O&M expenses, the forecast was off. Now, whether you believe that's just and reasonable or acceptable is up to you. Staff and the DPA believes it's not, and we will, as we go through this case, establish some specific adjustments that we made. And then on page 58 of their opening, they say, oh, well, staff's being selective because we adjusted some of the OM and we didn't adjust all of it. Well, again, we adjusted it. It's there. We know it's over forecasted based on actuals. We changed FICA and we changed regulatory expense. And then they challenged us and said, well, we're being selective. Now, that to me is a little difficult to contend with, I think is the right word I would like to use. Thank you.
Ms. Schultz, do you have any rebuttal?
I would simply respond by saying, I think that the hearing examiner made the decision that he made to find that the 2.21% variation was reliable, reasonable, and verifiable in light of the fact that he felt constrained by the fact that the law is what it is and the MFRs say what they say, which is that the company has done what it was required to do. And I'm not saying that having actual data might not be helpful, but in this case, that actual data served to prove the reasonableness of that forecast, which I think the hearing examiner realized and appreciated, you know, for taking a look at the period of time that we're dealing with in this case was the right thing to do in terms of what the MFR permitted him to do.
Thank you. Commissioners, any questions of the parties? Commissioner Correa?
You had mentioned that there are hundreds and hundreds of items that go into O&M, and I agree with that. But at the same time, we have a huge technology. At home, when we reconcile, we just push the button. It's simple. But then our technology at home is this much, and your technology at the company is this much. So it should be not as difficult as you are projecting it. It should be simpler because it's available. And other side of the coin is that you publish your quarterly results for your shareholders, bondholders. So most part is there. And therefore, I believe that that point about hundreds and hundreds of items is, to me, doesn't look acceptable.
I mean, I guess the one thing I would say is, you know, we may all have conceptions about what we think the company should have or what it does have as compared to what we have. But all I can tell you is that it really is not as simple as pushing a button. And the information, the quarterly information that's being provided to investors and the public, I mean, this is a broader scale. You're really drilling down into the details and going into hundreds and hundreds of individual items on expense and then on the revenue side. And so, you know, that's why we believe that the forecast was reasonable for the last 3 months. And based upon the fact that we don't have actual data for all of the other items in the test period for which forecasts are being used, we don't think it would be appropriate to update solely the O&M items for the actual.
Mr. Chair.
Commissioner Gray?
So it appears so we're going through each of these contested items one by one, as opposed to as an overall blanket decision. And I understand it may not be easy to get to all of the details, but it sounds from what I've heard as though there are two known facts. There's the known fact of the forecasted O&M, and there's a known fact of the actual O&M at this point on the table. And I appreciate and understand the fact that the company is looking at the MFR, but I'm trying to look at it from the customer ratepayer point of view. And my inclination would be to use the actual, so that if that pans out that $3 million is not going to be disadvantaged to the customer in this case, some other disadvantage down the road will balance out. But my inclination, as far as a ratepayer is concerned, is if you have actuals to work with, actuals is what we should use.
You want to follow up your inclination with a motion, please?
Mr. Chair, I'll move that the commission adopt the staff and DPA's recommendation that O&M expenses be updated to actual amounts.
I second the motion.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Any opposition? Anybody abstain? We have one person absent. Next item is reflect post-test period reliability closings, April 2020 through September 2020. We will have the company proceed first.
Thank you, Chair Winslow. If we're keeping with the statement that Commissioner Gray just made about actuals, then that should take care of this one pretty quickly. These are actual post-test period reliability plant additions that were placed in service between April and September of 2020. These plant additions were forecasted at the outset of the application. They were updated to the actual numbers in the company's rebuttal testimony. Staff agrees with the company and supports the hearing examiner's recommendation to include this post-test period plant in rate base on the basis that these numbers are actual. This is consistent with the MFRs. It is consistent with this commission's precedent in docket numbers 13115, docket 09414, docket 05304, where consistently post-test period plant additions that are actual in service, serving customers, have been allowed to be included in rate base through the rate case. The hearing examiner recommended approval of this despite DPA's arguments that it should be disallowed. DPA argued it should be disallowed because the DISIC statute exists and because Delmarva can take advantage of recovery of capital investments between or during rate cases. However, the fundamental flaw in DP's argument, which is what the hearing examiner relied upon in his decision, is that the statutes don't require Delmarva to put plant into the DISIC. And so Delmarva chose to do what it has always done, and during the rate case, take this plant, put it in a post-test period adjustment, and put it in its rate base through that mechanism. There's nothing wrong with this approach. It's not prohibited. There's nothing that required it to do anything else, and there is no reason that this commission should overturn the hearing examiner's decision in this regard, because this is not plant that was in any way contested in this case with respect to its usefulness or its necessity. So there really is no reason to make the company delay for recovery on or of this investment, which is currently used and useful and serving customers and is fully compliant with the statute, the regulations, and precedent.
Thank you very much. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. No, it's not going to be over as quickly as Delmarva would like. We don't, just to get one thing out of the way, assuming, whatever happens with this adjustment, if the commission decides to include it, we don't take any issue with the use of actuals. That was kind of our point all along. You should be using actuals if you have them. But we expected that this issue was resolved once Delmarva got the DSIC for electric and natural gas operations, and we were obviously wrong. Despite having the DSIC, Delmarva still included 5 months of post-test period DSIC-eligible plant in the rate base. And it has two arguments that the hearing examiner apparently accepted. One, the DSIC is permissive, not mandatory, and two, it had to include this plant in this case because it would have had stranded plant if it didn't. But both of those arguments are wrong, and the hearing examiner's decision to allow this post-test period plant is likewise incorrect. First, don't be taken in by any claim of stranded recovery. There isn't any, because Delmarva will be able to include this property, this plant in rate base in its next rate case. But more importantly, Delmarva alone is responsible for any delay in recovering this plant now, because it made the business decision not to use the DSIC mechanism for which it lobbied. Remember why the General Assembly enacted the DSIC for water companies. It was to allow them to recover needed non-revenue producing reliability investments in between rate cases and during the pendency of a rate case. It was intended to reduce the effects of regulatory lag. And that is why the Commission has previously allowed utilities without a DSIC, i.e. Delmarva, that used historic test periods to include some amount of post-test period plant and rate base. Now, the third tab of the package that I gave you contains an excerpt from your order in docket 13-115, the last litigated rate case. And you stated there in paragraph 62, quote, "In recent rate proceedings, we have recognized that under appropriate circumstances, an historic average test period may, if properly supported, be adjusted for reliability investments where it is likely those investments will not generate additional utility revenue," end quote. That distinction, when the utility uses an historic average test period, is important here, because in this case, Delmarva used a partially projected test period, not an historic one. So it was already including projected additions in its test period. The inclusion of 6 additional months of post-test period plant additions essentially resulted, at the time Delmarva made its filing, in a fully forecasted test period for this item, and the Commission's MFRs don't permit fully forecasted test periods. But in this case, it was unnecessary for Delmarva to include post-test period reliability plant additions in any case, because all it had to do was file DSIC applications to recover this plant during the pendency of this case. That is what the DSIC statute and the Commission's DSIC regulations envision. The water companies have had a DSIC since 2000, and they have figured out how to file rate cases without stranding, and I put that term in quotes, any recovery. Now, Section 2.6 of the Commission's DSIC regulations, adopted in 2012, specifically provide that utilities may file DSIC applications while a base rate case is pending. Now, we have provided the DSIC regulations at the 5th tab of the package, if the Commission wants to review those. The only plant Delmarva was required to include in rate base in this case was the plant that it was already recovering through the DSIC. And again, Section 2.6 of the DSIC regulations state that when the rate case application includes eligible DSIC plant that falls within the utilities test period in the rate case, that is April 1, 2019 through March 31, 2020, the utility must demonstrate in subsequent DSIC applications that the plant isn't already included in the rate case plan, or in rate base, I'm sorry. So how would that have worked here? Let me walk you through it. The DSIC is a trailing recovery method, and it's based on actual spend, not projected spend. So pursuant to Section 315B3 of the DSIC statute, and the DSIC statute, I also provided that at tab 6, or the 6th tab, for your convenience. The effective dates of new DSIC rates are January 1 and July 1 of each year. And pursuant to Section 315B4 of the statute, a utility must file its application for a change in the DSIC rate at least 30 days before January 1 or July 1. In Section 2.3 of the Commission regulations, the deadline for filing a DSIC application for a January 1 effective date is no later than December 1, and the deadline for filing a DSIC application for a July 1 effective date is no later than May 31. The application covers the preceding 6 months. So the application for a January 1 effective date includes plant added from the previous November 1 through April 30th, and the application for a July 1 effective date includes plant added from the previous May 1 through October 31. Delmarva filed its rate case on March 6, 2020, and its test period was the 12-month period ending March 31, 2020. Its test period consisted of 6 months of actual data and 6 months of forecast. Under the Commission's regulations, this meant that Delmarva had to include in the test period rate base all of the DSIC plant that it was currently recovering through the DSIC. But the timing requirements in the statute and regulations do not require Delmarva to include post-test period plant, because Delmarva is required to recover that plant during subsequent DSIC filings that it would file during the pendency of this rate case. Now, Delmarva knew in early September 2020, when DPA's direct testimony was filed in this case, that we were taking the position that the DSIC statute required Delmarva to use the DSIC to recover this post-test period plant. And it had plenty of time to recover that plant from this case and recover it in the DSIC. So why didn't they do so? Simply because Section 315B7 of the DSIC statute limits how much plant a utility can recover through DSIC. It provides that, quote, "The DSIC rate applied between base rate filings shall be capped at 7.5% of the distribution base rate amount billed to customers under otherwise applicable rates and charges. But the DSIC rate increase applied shall not exceed 5% within any 12-month period," end quote. And what that means is that either or both of those limitations are reached, the utility either has to stop adding plant to its DSIC calculation or file a rate case to roll that DSIC into rate base and reset the DSIC rate to 0. Now, the Delaware Supreme Court instructs that the legislature is presumed to have inserted every provision into a legislative enactment for some useful purpose and construction. The reason the Delaware General Assembly included Section 315B7 was to put a brake on how much DSIC plant a utility could recover and earn a return on in between rate cases. Otherwise, that section was unnecessary. So if you accept Delmarva's argument and the hearing examiner's recommendation, you are essentially writing Section 315B7 out of the DSIC statute. Now, what Delmarva did here is an end run around that limitation. Including post-test period plant in rate base in this case does 2 things. 1, it increases the distribution base rate amount that serves as the basis for the 7.5% cap. And 2, it avoids adding plant into the DSIC, which slows the rate at which Delmarva will reach the 7.5% or 5% caps. And this is expressly demonstrated by the DSIC applications that Delmarva did file during this rate case. The document that is at the 7th tab in your package is an excerpt from Delmarva's May 2020 DSIC application, which was admitted into the record as Exhibit 59. Paragraphs 14E and F of that application state respectively that Schedule 2 reflects the fact that this application does not include any projects placed into service or retired during the recovery period beginning November 1, 2019 through April 30, 2020. And Schedule 2A reflects the fact that this application does not include any new projects placed into service or retired during the recovery period beginning November 1, 2019 and through April 30, 2020. And there is no additional depreciation expense related to the net additions to plant and the accumulated depreciation reserve in this filing. They properly took out the DSIC that they were collecting through March 31st, 2020, and put that into the rate base in this case. That was required. They could have, in this May 2020 DSIC application, included the April 2020 DSIC plan. They did not. But that's where it belonged, not into rate base in this case. The document at the 8th tab of your package is an excerpt from the company's November 2020 DSIC filing, and that was Exhibit 58 at the hearing. And in paragraphs 9 and 11 of that application, it states that it included post-test period plan from April through September 2020 in its pending rate case, and so this application only reflected DSIC eligible plan for October 2020. But the May through September 2020 plan belonged in this DSIC application, along with the October plan that Delmarva did include. If the company had not included the post-test period plan in rate base in this case, but rather had included it in the DSIC applications due in May and November 2020, it would have increased the DSIC rate above the 1.29% that Delmarva calculated in its November 2020 application. So the net $30 million of post-test period reliability closing included in rate base in this case should have been included in the May and November 2020 DSIC applications, and if it had, Delmarva would be that much closer to the 7.5 or 5% limits of Section 315B7. So that's why we say that what Delmarva does here is an end run around the statutory the caps on additions, and that's clearly not what the General Assembly intended. Delmarva alone chose when to file its rate case, and it alone chose what to use as a test year and test period. And it alone made the decision to include this plan in rate base, even though the DSIC that Delmarva lobbied for is the General Assembly approved vehicle for recovering such plan in between rate cases. If the commission approves Delmarva's request and the hearing examiner's recommendation here, I promise you, you'll see this from every utility coming in for a rate case in the future. Allowing utilities to include post-test period plan in a rate case when they can and should file DSIC applications to recover for that same case plant while the rate case is pending eviscerates the General Assembly's intent in establishing the DSIC caps. It is wrong as a matter of law, and the commission should not condone it. We made other arguments in our exceptions, which we think are important, but we won't go into here. We hope the commission will give them due consideration, and we respectfully request the commission to reject the hearing examiner's recommendation. Thank you.
Thank you, Ms. Iori. Mr. Geddes?
Mr. Chairman, members of the commission, we did not take an exception to the hearing examiner's report. We, in essence, kicked the can down the road. We agreed with the DPA's arguments with regard to DSIC. It needs to be part of the process to recover post-test period investments. And the interrelationship between DSIC and reliability investments has not really been parsed out. Ms. Iori has given you the chapter and verse on how she believes and the DPA believes it should be done. Staff's position is it needs to be addressed because at the moment it's just hanging out there. And we support the DPA's position on how it should be done going forward. But in this particular case, when staff witness was asked, well, how is this different than 13115, it does look like that adjustment, i.e. reliability investments out through a certain period of time, in the context of that case, was allowed. Now, Ms. Iori has articulated why that case shouldn't be precedent, but staff and its testimony, basically direct testimony on the stand, said 13115 looks like a precedent, and we didn't take an exception to the hearing exam's resolution of this. But we did say on page 27 of our exceptions, staff urges the commission to adopt the DPA's arguments and to require Delmarva to use DSIC as part of the process to recover post-test period investments. So we are with the DPA going forward. We are just, in this particular example, weren't sure whether that should be imposed in this case, because it's unclear how it should work.
Thank you, Mr. Geddes. Ms. Schultz?
Sure, I would simply summarize it this way. I agree that nothing can really be done in this case. In this case, the company should get recovery of this and these post-test period additions because precedent dictates that it does, and the MFRs allow it. If the commission is concerned with some sort of end run around the cap, number one, the fact that the legislation, as is written, doesn't dictate that the company has to put capital investments into the DSIC. It merely provides one mechanism by which they can do so between rate cases. Delmarva is in a rate case, and so to Delmarva, it made the most sense to include these in the rate case that was currently pending, as it has always done. If the commission feels as though it should not have done that, and it should place them in the DSIC going forward, then that is something that I would argue needs to be addressed through a change to the MFRs, because the MFRs are really what specifically allows the company to put this post-test period known and measurable actual plant into this case, because those numbers are known and measurable and actual before the filing of its rebuttal. And that is the basis upon which every prior case has been determined insofar as allowing post-test period reliability plant. I could get into the stranded plant, but you don't want to hear that, and it's very complicated. So if you were concerned about it, I'm sure you read all the examples in the briefing. But we believe that the hearing examiner's recommended decision in this regard should be adopted by the commission.
Thank you, Ms. Schultz. Commissioners, do you have any questions of the parties?
Yes, Mr. Chair, I have two questions, please. First question is utility allowed to earn a return on the equity on DSIC assets?
Yes.
Does anybody? Yes, while it's in the DSIC?
Yes.
Okay. And I listened to Ms. Iori's argument. What, if any, remedy does the company have to go back and file for these assets to be placed within DSIC at this point?
It doesn't.
It does not?
It does not.
Okay. Is it fair that the company does not get a return on those assets?
I think it's fair because they made a calculated business decision to do it that way. The DSIC was available to them at all times, and as I pointed out, even after we filed our direct testimony in September, months after the company had filed its case, and when it could have filed a DSIC application for the vast majority of this plant, it still didn't do so.
Yeah, I'm a little bit troubled. I don't want to handicap the utility, on the other hand, or diminish the incentive to make an investment, if especially there's some question about a historic case where this perhaps was handled differently. No other questions, Mr. Chair.
Well, from my perspective, I think that the DPA really hit it on the nail. I mean, I think going forward, as Mr. Geddes says, that there should be no doubt in anyone's mind that the DSIC should be used. I think it was great credit of Delmarva Power and Light and also the public advocate that this legislation came to be. And I'm a little surprised to find ourselves in this situation. But as far as, like Commissioner Gray mentioned, and as Mr. Geddes mentioned, I do think there's some reason why we're in this, and it's not necessarily because the company is gaming the situation, although my math is not too good. I know there's a difference between 9.6 and the 7.5. But I come down with staff's position to make it clear for the future for all utilities that this is not going to happen again, that the DPA has it correct. But in this particular situation, to let the company and the hearing examiner's opinion prevail. And so I guess I'm not sure if it's Robert Rules of Order or correct here or not, but I so move what I just said.
I'll second that motion.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Are there any opposed? Any abstentions? The motion carries.
Point of clarification, Chairman Winslow.
Yes, ma'am.
In your motion, you said adopting the hearing examiner's recommendation, but it appears that you're giving a different reason. Am I understanding that correctly?
Well, I'm agreeing with staff's position with respect to the resolution, but adopting the hearing examiner's bottom line.
Okay, thank you.
Okay, my pleasure. By the way, we're going to break around 11:30, and if any party or anyone needs a break at any time, please just let me know. We have adequate time, I think, set forward for this matter. Okay, let's see, what's next?
Adjustment
Annualization?
15, I believe.
Okay. Yes,
Page 8.
annualized test period DSIC reliability plant.
Okay, thank you, Chair Renslow. So this is adjustment number 15, and through this adjustment, the company has requested to annualize only its test period DSIC reliability plant and related depreciation. So we just talked a lot about what's in DSIC, what's not in DSIC. And for purposes of this adjustment, I just want to make it very clear. As you're aware, the company was required to transfer the reliability plant that was in DSIC into base rates as a part of this case. That plant was in the current DSIC charge. The company was recovering on that plant. While that plant is situated in the DSIC, that plant is annualized. That is the rate-based treatment that it receives. It does not receive average rate-based treatment. It receives year-end or annualized rate-based treatment. And this is why the company's request to treat this test period plant should be adopted, and the hearing examiner's recommendation to disallow it should be rejected. In 13115, this commission considered a request by the company to annualize all of its test period plant. Relatedly, in connection with that, if you've read the order, there was a separate consideration, well, should we annualize only reliability plant? Ultimately, the commission came down and said, no, we don't find any compelling reason to treat one component of plant differently than the other in the rate base, giving one annual treatment, one average treatment. Here, that's what makes this case different from 13115, and that's what provides you with your compelling reason to treat this particular plant differently than the other test period plant in the company's rate base. This plant is already being annualized, and so it should be able to retain the treatment that it currently has. This is a new and a different fact that is different than when the commission last addressed this issue and declined to find in favor of annualization of this plant. Affording year-end treatment to this test period reliability plant is consistent with Delaware law. It's consistent with the commission's MFRs. Nothing in the law prevents gas or electric utilities from annualizing rate base. As to the regulations, this commission has so held, and I quote, nothing in the MFRs prevents a utility from using year-end rate base. That's straight out of 13115. And so, despite what you've read or what you may have heard, there is no policy against annualization of this commission, nor should there be. Delmarva's reliability plant already receives different treatment, in fact. The average versus year-end, depending on the day it closes. Test period plant, even the test period plant that is not DSIC plant in this case, will receive average rate-based treatment. The post-test period plant that comes into this case will be annualized. That is part of the company's adjustment, which the hearing examiner adopted and this commission adopted as well. And that has historically been done, and no party has contested that. So I think it's important to recognize primarily that there is a distinction here. This DSIC reliability plant is already being annualized, and the only evidence in the record as to the rate impact of this adjustment is that it is rate neutral for the customer. This plant is simply being taken from the DSIC and rolled into the base rates, and if you don't annualize this plant, the impact is that the company now gets 60 cents on the dollar for a plant that was already reviewed and approved in the DSIC. And now, just because it's being rolled into base rates, it's worth less. So it doesn't make any sense. It is not required under the law, and we really think it presents a compelling reason to afford a different treatment to this particular component of plant.
Thank you, Ms. Schultz. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. If we were writing on a blank slate, we might agree with the company regarding year-end rate base. Unfortunately, we are not writing on a blank slate. Delmarva argues that the existence of DSIC changes what the Commission's proposed rate-making treatment somehow, because using average rate base for something that is currently collecting the full return denies it recovery. Delmarva is interpreting the DSIC as a tracker, and the Commission has already rejected that argument when it put the kibosh on Delmarva's attempt to reconcile under collections related to plant transferred into rate base in the rate case. The DSIC is not a tracker, and there is nothing in the DSIC statute that suggests it was intended to replace how the Commission treats rate base items for rate-making purposes in a rate case. And the hearing examiner so found. He correctly observed that the reason that water utilities get to use end-of-test period rate base is because of Section 302, not because of the DSIC statute. Now, Delmarva claims that its proposal is rate neutral, but it isn't. It only annualizes the test period reliability plan. It is not annualizing anything else in rate base. But if you had used year-end rate bases for all rate base items, Mr. Watkins testified that its year-end rate base would have been lower than the amount it seeks because of the effect of deducting year-end accumulated depreciation from year-end plant in service. And the overall rate base on which the return would be earned would have been lower. And he also accepted the DPA's argument that because taxes are not a one-for-one exchange, the amount by which taxes would decrease is not equal to the amount by which rate base would decrease. And so ratepayers would still have benefited from the lower rate base resulting from using an average for all of the rate base items. So in this case, as I said, if we were writing on a blank slate, we might agree with the company regarding year-end rate base. But we are not. This commission has this commission has for several years now mandated average rate base for this company. And so we think the hearing examiner's recommendation is both legally and factually supported and should be accepted. Thank you.
Thank you, Ms. Iori. Mr. Geddes?
Next slide, please. See if somebody's awake. Let me not misinterpret what counsel for either party has said. Let me just say what I want to say, which is that this commission has used average rate base for several cases. If you look at paragraph 36 of your decision in the last litigated case, sorry, Gloria, we agree with the hearing examiner that average rate base should be used to develop rates in this proceeding. Generally, this has been the way we have set rates for this utility in the last several cases, and there's nothing produced in this record that would make us want to change the general practice. Now, before you is actually the conclusion of that analysis, which, no, I don't want to do that because I'm afraid I'll have the wrong commissioner. One commissioner suggested, I think it was Commissioner Gray, but I might be wrong on that if there was no compelling reason to take one component out of rate base to the exclusion of others. This is what Delmarva is trying to do. And they're trying, again, I'm trying to be respectful here, but they're trying to have it sort of both ways. Ms. Iori, on behalf of the DPA, said, well, that should have been in the DSIC, and it shouldn't be in this rate case. And the company should be, it was their choice, should be penalized. Commissioner Gray said, you know, we understand, but in the future, that's the way to do it. But Delmarva is asking for this to be in rate base, which traditionally the commission has used average. So now they're saying there's a compelling reason to put this asset, which they chose not to use the DSIC for, into rate base and saying it has to be annualized. Well, if it's in rate base and the commission's normal approach is to use average rate base, well, it's in rate base. That's what you wanted. And average rate base is what we use. And so I think it is difficult to put those two concepts together. It's in rate base, everyone agrees. Commissioner Gray says, what are the facts? The facts are it's in rate base. What are the other facts? The precedent of this commission over the last several cases that we use average rate base. Therefore, ipso facto, we should not we should not annualize the DSIC, and we should support the hearing examiner's adjustment on this, or finding on this. Thank you.
Thank you, Mr. Geddes. Ms. Schultz?
So if I may, I'll first respond to Mr. Gettes's point, and that is just to very clearly articulate to this commission. He mentioned Delmarva's argument about what should or shouldn't be in this case vis-a-vis the DSIC. What we were just talking about before was post-test period additions. What we're talking about here is what's already in the DSIC. This is test period plant that is moving from DSIC into rate base. So there's no question about whether it should or shouldn't be coming into this case. It's required to come into this case under the DSIC statute. The rate has to be reset to zero. This plant has to move in. The only question here is whether this commission finds it compelling that this plant that is already in rates through the DSIC that is being annualized should simply retain that treatment when it moves into the rate base. And that's what Delmarva is arguing should be the case. The DPA has referenced what would happen if all of the rate base was annualized in the test period versus average rate base treatment. None of those calculations were done in this case by the company because that's not the adjustment that the company proposed. And so I guess finally I would say, you know, this is the first time I've heard argument about a tracker, so I'm not really sure what that's all about. But in essence, what it boils down to is that precedent of this commission has been to apply average rate base consistently. However, we strongly believe that this is one instance in which there is now new evidence, and this is a novel and new and precedential issue before this commission on facts which are different than they have ever been before. And for that reason, we believe that the hearing examiner got this one wrong, and that the commission should find that the fact that this particular plant is already afforded annualized treatment while in the DSIC should control, and that should follow this plant into Delmarva's rate base in this rate case. And we believe that the commission should reject the hearing examiner's recommendation in this regard and approve the company's adjustment.
Thank you very much. Commissioners? Commissioner Drexler?
I think I'm directing this question to Mr. Geddes. Why understanding that the reliability plant has to be moved into rate base, understood, and that rate base treatment is average versus annualizing. And so that makes sense, and keeping it consistent within the rate case and within the rate base it makes sense to me. But why is the treatment different? While that reliability plant is in the DSIC, why is it treated differently and allowing annualization versus when it is moved into the rate base, it's all of a sudden now averaging? And so the difference is, if Ms. Schultz is correct, it's now 60% on the dollar, 60 cents on the dollar versus the treatment that it was receiving. Why is the treatment different?
Because the statute says how the plant that is eligible for DSIC should be accounted for. And remember, this is something that requires ratepayers to pay for assets between rate cases. And so now they're saying, well, notwithstanding you're doing that, they want you to adopt annualization as well, which would be more money for in the base rate case, more money that ratepayers would have to pay. Our point is, DSIC is out here, rate base is here. We consistently, the royal we, the commission consistently uses average rate base. In the last case with reliability, post-test period reliability investments, the commission specifically said, paragraph 37, we are not going to take one component out of rate base and treat it separately. And under this proposal, those DSIC plan is going to be in rate base. And so we believe that in that construct, that the rate base should be treated the way you have historically, and you should use an average rate base rather than a year-end rate base, or test period, year-end test period rate base.
So I'm hearkening back to when the DSIC, or, reading through 13115, or when DSIC was approved. Why is there a disconnect between how this plant is treated under DSIC versus how it's treated in rate base?
Because you're putting apples and oranges together. You've got rate base, and you have a historic way that you treat that. And now you're taking this plant because of the filing, and you're putting it in and trying to treat it as rate base. But it's really something different. It has its own rider mechanism. I won't use tracker. I'll use the word rider mechanism. It is collected differently. And now we're trying to put the two together. And I'm saying, or at least on behalf of staff and behalf of ratepayers, when you meld those two things together, the majority should rule, and that is average rate base.
Ms. Schultz, any final comments, since there's been a long discussion there?
I guess I would just say in response to Commissioner Drexler's questioning then, I would agree with what Mr. Geddes said in that it's annualized because that's what the statute and regulations say that it gets when it's in the DSIC. But when transferring it back, neither the statutes nor the regulations say that it has to be average, because they don't say that the utilities rate base has to be average. So I would urge the commission to consider that.
Any further questions, commissioners? Has lunch arrived?
It has.
Any comments, anybody?
So I
Mr. Correa,
I
Commissioner
move
Correa.
that we adopt the hearing examiner, DPA, and staff recommendation and deny the adjustment.
I second the motion.
Is there any discussion on the motion, which is to uphold the hearing examiner's order as supported by DPA and I guess staff as well? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed? Any abstentions? The motion carries. What's the consensus in the room? You want to just keep on going for a little while longer? Or do you want to, the food is here, I don't know.
I'd rather break if it's okay.
No, that'd be fine. How long of a lunch break do people want?
Half hour?
Is that going to be okay? 30 minutes? Why don't we make it 12:15? Come back?
Sure.
We're adjourned. Thank you very much.
Yeah, I mean, I think that we've got, I think my client kind of discussion.
Yeah, let's just go back to conference room. Yeah, I'm just looking at your stuff.
I don't know if the circumstances are argued.
Yes. The lunch is across the hall. Oh, we have to grab it and bring it up?
Yep. Whittine, W-I-T-T-I-N-E. You don't remember Jim Whitting, big tall guy, maybe you don't. Yeah, big tall guy. He was their big
Stay that can
policy.
stay.
So we always
Keep my, this should go.
one of my favorites. James Whitting.
No, what we said, is pissing everybody off.
Okay, good.
I didn't write it. I actually, I just speak it. I don't actually type it up. What, if you had a specific question into the beginning, the best I could give you is, let me just see here. Hey, Bill, I got interrupted in the part where I was talking about that the commission should assess and address each of the county's performance adjustments and the hearing examiner's analysis or lack thereof, any pertinent merits, like one by one. That's where I was getting interested, so try something along those lines. If you have questions when you come, you can.
Because the kind of like 2009 was the calculation piece, 2005 was what's called the substance piece. And it's our understanding, my understanding from Brian, that only a few of those provisions are wrong. So it might make sense. I think it's better to attach it. And ideally, what we would do is call out, say, provisions X, Y, and Z are no longer included in here. I think that might be the best way to do it, rather than try and, unearth all of this information for 2005, package it into the minutes on it. Because I just think it's just going to be a heavy lift for someone, and I just don't know that it's worth it.
Unless I drive 90 miles an hour, but I'll do it.
Yeah, I'll talk to Gina about it. Obviously, she's not as busy, but do you know if Gina likes to say die in a ditch? I like that. That's my Gina-ism. I'm not going to die in a ditch over this one. So I don't know if Pam, because I think, was it Pam that originally drafted the amended settlement agreement? I don't know, it would be helpful if she could identify maybe which clauses from 2005 need to get stricken, so that we can either identify that, or if she's dying in a ditch or she doesn't know. Okay, because Brian doesn't know. Brian's like, it's just gonna be a heavy lift to go back if Pam's already done the work.
This one prevails.
Okay.
But it doesn't say what that is.
Right.
So notwithstanding that, it's just like
Yeah, I got you.
So again, when we put that language in the 2021, then people are going, well, what is this?
Right.
Why do we know that? And I think that's a good question.
Or people are like, Pam, hopefully Pam knows. I'm like, I don't know. Okay. So it sounds like then and then, luckily we have time, but I'd like to get it on the 25th. I'm hoping that we can just agree to this, but I'll hit you up on this after the fact. I just wanted to get your sense. Well, but I think it was, now knowing after speaking with Brian and going back and email thread, this is what Bill's been saying all along, which is what Pam has been saying all along. I now get it. And I think I understand where Gina's coming from. She wants it all. I would like it to stay on. It's cleaner. It's cleaner, but under the circumstances, it's just going to be more trouble than it's worth. Brian was like, we really just wanted to clean this up. This was supposed to be about 2009, not about 2005. So, all right. I'll work on Ms. Iori later. We were just talking RARM, not now.
I don't know, this might be the best time to get me, I'm eating.
Does that have cheese under it and raspberry, or is that just raspberry?
I think it's just raspberry.
It looks delicious. I'll hit you up on this issue later. I know that this has been a back and forth on us, but no need to do it now.
What about it? Didn't see you, Bill. What about it?
So, and basically, after talking with Brian Talley, who was out when we were having the communications, it's my understanding that the 2009 agreement is the calculation agreement. The 2005 agreement is the substance agreement.
Okay.
And what needed fixed was the 2009 agreement. The 2009 agreement says whatever's left over in 2005, basically everything, that we're understanding now from talking to Brian Talley and to Pam Knotts, pretty much everything from 2005 still exists. So when we're using this amended settlement agreement, we're really doing it to replace 2009, which was the calculation piece. Because that's what's broken, basically, is the calculation mechanism between the parties, between staff and DPL.
Okay, so let's just get a Word copy of the 2005 and dump whatever needs to be dumped into it.
We could do that, or we could just say, as we did in 2009, to the extent that anything in 2005 contradicts this 2021's amended keeps up. I feel like, per Brian, he's like, I think we're making this a bigger deal than it needs to be, because really 2009 is the only thing that was a problem. And Bill did send it.
I understand that,
Yeah.
but what I'm saying is, in 2009, had I had a say in that, which I did not.
Yeah, nor did I.
Right. I would have said carry it into.
Okay.
Just because it's easier to go to one document than to have to go.
I agree with that 100%, but I think because they serve different purposes, it's kind of like, well, we're creating all this extra work, because Pam, when I asked Brian, I said, what changed from 2005?
But if I do it, who cares?
That's true. All right, so I'll go back to Brian and I'll let him know we talked about it. And that other stuff, I'm sure we can agree to the other things, so hopefully it can just be on consent for August 25th. I don't think we're gonna have any beef with that. I'm not gonna die in a ditch over it, as Gina likes to say.
Well, I got that from Jim.
I like that, that's a good one.
What are you eating? Why are you eating here? Just to be alone?
No, I just took it out and I was talking to people and. What did you guys get? Chicken capriati.
But there's plenty in there.
Well, I'm full now.
Yeah.
These are,
Would you have another one?
no.
What's this?
This is these, this is the vegetables.
I thought it was appropriate.
All right.
For the big one.
Coming up next.
Welcome to the conference center. Please enter your moderator code or your participant code, followed by the pound sign. If you have Your passcode has been confirmed. Please wait while you are joined to the conference. You are the first caller to the conference. Please wait while others join.
Hey, Donna.
Hey, I guess it's good.
Yeah, can you hear okay?
I'll have Ronette, she's coming in to put that note up on there.
Okay. I think I'm gonna put the phone like in the center of the room.
Okay.
Okay, thanks.
All right, thanks, Matt.
Thank you.
I don't have another room. Those Virginians,
What part of town did you settle in?
Over in the museum district?
Oh, okay.
Yeah.
No. Like it okay?
No, it's great. You can walk to all those new breweries down in Scott's Addition, and you can walk down Carytown.
Yeah, I lived down there, first year in Richmond, 1980. I was running Grove.
neighborhood. It's got when we moved in, I think we were one of two couples that were under, probably 70 or 80.
Yeah, right.
Bought it. And then I think a lot of people, as they're moving down to Florida, they're moving to all the other kind of places, so there's big turnover. So a lot of people, kind of late 20s, early 30s. And it's great because my wife's pregnant, and then so's the people 2 doors down, so's the people across the street.
Must be something in the water.
Yeah, exactly.
Well, damn, Andrea, I was looking forward to having dinner with you or something.
Well, it's gonna be on another trip. Yeah.
All right.
It was all news to me last night.
I'm sorry?
It was like 9:30 at night, I got the text.
Oh.
I'm taking the 2 days off and going, and the girls are taking a road trip. Okay.
Where
It'd
they
be
headed?
nice to have the extra hands.
Where they headed?
My daughter is going to Salem College in Winston-Salem. And move-in is the 20th.
Great.
We went shopping last night, went shopping a couple of nights ago. We're gonna need 3 vehicles, I think. I haven't bought the refrigerator yet. Although she does wanna get, she wants, that's the thing that's going to do. She wants to get an ice maker, which is very smart.
How you gonna do that?
Because they're just little tabletop ones, and you pour the water in, and it makes ice, and then she can like sell it to them. Did I tell you how she ended up doing that school? Well, I'm looking at, so she applied to University of Arkansas, and I said, no, because that's like 14 hours to get there. She applied to the Salem College, and I'd never heard of it before. I said, what made you apply to this school? She goes, well, I thought it was the other Salem, like the one in Massachusetts.
Oh, that's funny. That is so funny.
So I said, well, we'll ride down and take a look, so on spring break we'll go down and look. I'm very impressed.
It's a nice area, though.
It is.
It's a nice area.
I gotta tell you, I was honestly expecting a bunch of rednecks and, just, it was very, not at all what I expected.
No, if you want the rednecks, you go further west in Carolina. What's the name of that school? Elon. May not have ever heard of it.
No,
I'll
Wake
drive
Forest.
pickup trucks and
Yeah, well, you can't, we went to one of the little,
Confederate flags waving.
we went to one of the little suburbs, little community suburb towns, I guess, right outside of Main City. That was a little more, got a little bit more of my expectation. But Wake Forest is right there. I mean, who knew? I guess all the tobacco families, and Haynes was big there.
What?
Haynes, Textiles, Haynes Company.
Yeah, that area used to be tobacco, textiles, and furniture.
Well, we gotta find it for a surfer day.
There's a lot of factory outlets right around Winston-Salem. Yeah.
Because I'm looking
A
at
lot
the
of
place.
manufacturers are still there.
Real good furniture shopping.
But moving into our new house, we buy new furniture. Cost a freaking fortune. It's like, I don't like it. Been around one of the sectional things, L-shaped. And it's uncomfortable as hell.
Thank you. Good head up. Huh? Good heads up.
Yes, I just heard your whole story.
You can't mute the mics, so I was gonna say. It's not well recording right now. It's not being recorded right now.
No, no, it's just being broadcast.
Oh, across.
Whoever's listening.
reserves?
Mm-hmm. Yep.
Didn't want you to think
You have
you're
to do summer camp and
alone
all
with
that?
this talk strategy, because
Yeah, I did my first week of duty. I mean, I've been doing my duty remotely because I'm stationed out in the Pentagon, and during COVID, they're like, no,
Right.
not letting anyone in. So I was having to do all my work remotely.
So you're still doing legal work? Or
Yeah, I
in
do.
the infantry or?
I sometimes wish I could go shoot the big guns in like my old artillery days, but no, I'm doing lawyer work.
As they say in the Marines, a Marine, every Marine is first and foremost an infantryman.
Yeah, every Marine's a rifleman. Easy to forget sometimes when you're. Yeah, I mean, I had 13 years on active duty. I'm like, I can cut it out in the reserves for another 7, no big deal.
You get your retirement? Yeah.
you look old enough.
Well, thank you.
You know, Mike Thomas, I think he got 30 years in it. The hearing examiner in Virginia.
Yeah, I think I did. I think I
He
did.
was a full bird.
Yeah.
See, I believe it was Marine Corps. I could be wrong.
I believe that's right.
I believe so.
In terms of a part-time job, pretty good. You know, it's a pretty good one. Pays pretty good. You know. My wife likes it because it means I have to shave. I have to shave my face at least once a month.
How you like your new digs at the office?
Oh, it's great. Have you had a chance to swing by? Well, we'll get you to come by. We don't live in that. We're not in that old.
Wait a minute, where the hell did you move? I can't, Liz told me.
Yeah, we moved across the street. You know, the James Center, like you know the one with like the sailors outside. Like,
Yeah, James Center too.
Yeah, James Center too. So yeah, we're up on the 17th and 18th floor of that. I mean, it's fancy new
Is
digs.
that some of Hunter Williams' old stuff?
I think it
I mean,
used to be.
Warren Woods.
Yeah, it used to be Warren Woods.
Yeah, before I was in James Center for 21 years. We were in James Center 3.
Yeah, that's the taller one, right?
Actually, it's a shorter one. You know what? 3 is the one in the back with the YMCA.
Oh, okay. I must be thinking of one. Got a tour of Richmond geography.
His law firm was in this office building probably back in the 40s.
I mean, I think it was the 30s.
It was decrepit.
It was-
It was
it was-
really decrepit.
And I think we were like one of the original tenants. Like our firm had been there for like 80 years, and we were the only people left in the building. Clearly because the landlord was trying to squeeze us out, because they wanted to turn it into like a hotel or apartment buildings or something else like that. And we're like, nope, we got a real long lease. So we stand there, and then they just stop fixing the air conditioner. You know, they don't only have one elevator working at a time. We're like,
So they converted it, or they working on it?
well, I think converting it to a hotel seemed like a grand idea until COVID.
Yeah.
Downtown Richmond's a little bizarre. It does not have much in the way of hotels. And I think, and our office
Within
building.
walking distance,
Yeah.
you know, the.
Yeah, of the Capitol. You know, and like, so the Capitol of Virginia's right there. And this place, our old office building is directly across the street. So I think they're like, oh, well, all these lobbyists are going to want to come there. And unfortunately for them, everyone's figured out how to work remotely.
Is Virginia losing people? We're moving from Richmond, and they're moving out of the city?
No, I think a lot of people are moving to Richmond.
The Richmond area.
Yeah,
The Richmond area.
yeah, they're to the Richmond area. I mean, we've had, in my block, that, you know, that kind of influx of people in their kind of early 30s. We is they just said, well, my job will let me work remote from now until Judgment Day, so keep that Manhattan salary, move down to Richmond and buy yourself a house. I wouldn't buy anything in Manhattan, certainly.
I live in Hanover, and you get on 301, I mean, there's still neighborhood after neighborhood, building going on right now.
I have so many friends in DC. No one can afford to live there. Like even lawyers and professionals, people who are making six figures, they just can't afford anywhere close to downtown. So a lot of people would just say, yeah, forget it. I'll move to Richmond. I'll move to Baltimore. Make some similar amount of money and have a much better lifestyle.
I don't go to DC as much as I used to, but I used to go a lot. And, you'd be surprised the number of commuters that live in Richmond and especially Fredericksburg. That's a long drive every day.
I had an uncle who worked at Fort Meade, between DC and Baltimore. Lived in Gettysburg, Pennsylvania.
Right.
You're like, man, how on earth do you get that far? But he did it every day because there are these commuter buses that'll just they'll pick you up in the morning and then they'll just drive you right to.
Oh, really?
They'll drive you there, and with the federal people, you can do these kind of off-hour things where you'll come in at like 6 and then leave at like 2:30 in the afternoon. So people find a way to make it work.
Listening to a radio program this morning. They were saying there was a survey, and I think some huge number of people would be willing to take a pay cut to stay at home.
Yeah, I think I
And
saw
then other
that.
ones, give up all their paid days off, just to stay at home all the time and not go back to the office. So it's gonna be an interesting dynamic that happens in the next couple of years.
I mean, my wife's an accountant for Deloitte, and she was out of the McLean, Virginia office for a long time. And she took a position before COVID happened. She took a position that was a 100% remote position, but she just moved down to Richmond and basically didn't tell them, like, well, you can keep paying me my DC salary. I mean, they know it's not like a secret, but like I think a lot of people are just going to find that they can afford to pay people. They can afford to pay people less, and as long as they don't have to live in.
The cost of going to work, going into the office, the fancy shoes and the
My
car.
daughter-in-law, she's a loan mortgage processor. They just say permanent at home, and she's it depends on the person, but she's more productive at home than in the office.
See, I came in every day during COVID because I can't work from home. I'm not one of those people.
I'm
I'm easily distracted.
I'm more productive in the office. My wife loves when she's just.
I'm getting my downstairs remodeled, so I'm hoping that I'll have a new office that I can be able to sit in.
We're getting our basement done as well, and it's been frankly, working from home's been completely necessary just because contractors come, they gotta, I gotta ask you a quick question about this. Get back from
For their signatures.
right upstairs, make it.
And your house gotta go out unless you want me to
I
stay,
just want my outside.
which I don't have a problem with either.
They got the outside done, and all landscaping and
Signature on what,
paver.
The orders, because they've already voted on the orders.
okay.
They're gonna go level by level, 3 levels, start from the downstairs, except for the basement.
And soon that we're supposed to be keeping track on what
What's
they
that?
vote for each month.
Yeah,
I've been keeping track of that.
okay. So you just kind of watch from your office?
Yeah. I mean, I can stay in here, so.
Oh, whatever you want. That's fine.
please enter your moderator code or your participant code, followed by the pound sign.
Your passcode has been confirmed. Please wait while you are joined to the conference. You are the first caller to the conference. Please wait while others join.
Very well, good family.
And do we have another number for tomorrow? Already set up? Yeah, that's true. Can I bother you for your signature?
On buildings like partial agreement.
Yes. No, yes, no, that's the consent agenda.
Oh,
items.
yeah, yeah, I know, yeah. Yeah.
And then I have the one for the partial agreement too.
Okay. So you have.
How are you?
How do we start?
Nice to see you.
Yes, I'm gonna start with you.
Yes, yes.
Kansas City, right?
Yeah, yeah, I came up yesterday.
How have you been?
I have been very fine. And you, and how are you?
I'm good.
Yeah. You are doing a fine job.
Thank you.
Every time I get something, I mean,
Yeah,
it's well organized, well.
You heard
It's
from Raj?
it's well done.
Yeah?
I try to, thank you.
Do you have a decent?
Yeah,
Okay.
Yourself?
I'm all right. I said I already won on mine.
Yeah. Fortunately, yours were in a settlement.
Yeah, exactly. Yeah.
Very good.
I think the only local commission Raj hasn't worked for is New Jersey.
Not saying it wasn't easy.
We have Pennsylvania, Maryland,
So you're out of Philadelphia, right?
Massachusetts.
Yes, though I've been working
So right here.
from
Thank you.
but working from home.
I know he's commuting from, I guess he is, yeah, because he's still in train station's right there, it's gotta be somewhere.
Yeah, and with this town, we got
Oh, yes, oh. I
so-
did not know that.
Thank you. Usually I'm pretty good. She hasn't said anything. This looks like it's such a slow chance.
I'm taking my youngest to college on 19th. That's my PSC baby. I don't know when I work with this commission.
So that means no kids in here?
Just me and the dog. It's enough work as it is.
You get along with the dog, right?
Yeah.
Does this belong to
He tolerates
somebody?
me. That might be good.
Oh. I was gonna say, I know it doesn't belong to me.
And I've been on the 50-yard line of the Ohio State football stadium, yeah.
That is a city unto itself.
Yeah, yeah, yeah.
Thank you. Thank you. Thank you.
Can I have one of your waters? Are you gonna drink both? Cool.
I had brought one of my own as well.
Let's throw this one.
Tim, did I hear you say you and your wife are expecting?
That's right. We've got our first one on the way, and it's due October 31st.
Oh, wow, congratulations.
Very, very excited.
Do you know whether it's gonna be a boy or a girl?
It's gonna be a girl. We're gonna name her Annie.
Welcome back from lunch. Hope everybody enjoyed their sandwiches. And we're now on page 11. Adjustment number 9, remove executive incentive compensation expense. And the hearing examiner has recommended denying that incentive compensation. And obviously Delmarva Power Light wants to include it, so we'll hear from Ms. Schultz again.
Yes, thank you.
Please proceed.
So, through this adjustment, Delmarva is looking to add $6.5 million to its test period expense level. And this is to reflect the portion of employee compensation that's tied to the achievement of safety, reliability, and customer service goals of the company. And this includes specifically the annual incentive program and the long-term incentive programs, what I refer to as the AIP and the LTIP. It does not include the Senior Executive Retirement Plan or the SERP benefits. Those costs are removed. It also does not include any portion of the incentives that is the compensation tied to the PHI CEO's performance. So the only thing we're dealing with here in this incentive compensation adjustment is that of those employees who are working for Delmarva, whose component of their overall compensation has within it, 15% tied to performance of Delmarva and achievement of the safety, reliability, and other customer service facing goals. So the DPA did not contest the inclusion of this expense in this case. This is solely an issue that has arisen between staff and the company. Though I would note that DPA did object to its inclusion in docket 13115 when the plan was different than it is today. Staff argued that these expenses should be disallowed since they're not necessary for the provision of safe and reliable service, they contend, and that they reflect extraordinary expenses. Staff, however, did not present any evidence to refute the company's evidence to the contrary, just arguments. And in this case, the company presented extensive testimony and evidence around the compensation setting strategies and the business judgment of the company in how it determines compensation levels for its employees, of which incentives are a part. And the hearing examiner disallowed this adjustment on the basis of his finding that Delmarva didn't meet its burden of proof. Because he said the AIP plan does not comply with the commission's standard to be included in rates. He further found the plan to be tied to capital expenditures, and from there he extrapolated that it was tied to earnings per share growth. None of these statements, I not call them really findings, are accurate. They all fly in the face of what the evidence showed to the contrary in this case, and so they're somewhat alarming to the company, quite frankly. What is the standard? We talked about it earlier. Just and reasonable. Delaware Supreme Court says in the context of a rate case, the commission is required to allow a utility to recover its normally accepted operating expenses in the absence of a finding of waste, inefficiency, or bad faith. These are ordinary operating expenses. These are not extraordinary expenses. Extraordinary expenses in the Chesapeake Utilities Court case of the Superior Court in Delaware, they said extraordinary expenses do not arise in the day-to-day operation of the business and are not, quote, ordinary operating expenses such as salaries and wages that the company uses for its day-to-day operations. Accordingly, these really are ordinary expenses. The evidence presented by company witness Mr. McGowan unequivocally showed how the employee's total compensation was set. In evidence, I'd argue, that's unparalleled as what's been presented before this board in the past. He walked through and explained how a portion of the base compensation is set and the other portion is at risk. But the entirety of that compensation is what's necessary to employ and retain Delmarva's workforce. And so he also talked about, and I'm going to equivocate a little bit here and be a little vague because this is the one section in the case where there's a little bit of confidential information. So I'm going to try and avoid that since we're live and broadcasting to I don't really know who. But ultimately, he explained the compensation setting methodology. He explained the survey tools and the database, the massive database that the company uses to determine how to set an individual's compensation and what the appropriate level of compensation is. There was testimony that every single one of the companies in that database, which include utility companies like Delmarva, have a portion of the compensation for the employee that's at risk. It is a natural and regular and routine part of the compensation that employees get these days. So, when Delmarva's trying to figure out how much to pay a lineman, for example, they'll look at this and it will tell them what's the minimum, what's the maximum, where's the average of the base, and then what's the minimum, what's the maximum, where's the average of the incentive portion. And from that, Delmarva determines how to create their package. And so what this evidence shows to the commission is that this is a true cost and a total cost of employing a particular person at the company. And these expenses are necessary to attract and retain talent. And I know this is evidence that's been before this commission before on this issue. And I don't actually think that anyone has disagreed with this in the past. In the past, the issue has been certain elements of the AIP program that have overridden what the commission viewed as the safety and reliability and customer service goals inherent in these plans. And those elements that previously confounded the commission or concerned the commission aren't present in this plan, and we'll talk about that in a little bit. But the bottom line is, if we find ourselves in a position where we can't recover the total cost and the true cost to employ our workforce, then we are going to be at a disadvantage. Because the company's disadvantage is going to be that it's either going to have to increase its base salaries to attract these folks, or it's not going to be in a position where it's going to be attractive when they could go work for another company where they're going to get an incentive. And quite frankly, we don't think it's the right idea to simply pay somebody a base and not have the incentive. The incentive is there for a reason. Company witness McGowan explained this when he told the hearing examiner and in his testimony, where he explained the fact that the company thinks it's important for its employees to be driving towards better performance for the company, for its customers. And that's what the incentive piece does, right? The incentive piece makes sure that Joe Smith is thinking about that component of his compensation that's impacted by the way that he does his job. And he's going to do his job better and for the employees because of that. There was much made about staff witness FAF and even DPA. You've heard it in Ms. Iwer's opening statement about the Exelon investor presentation with titles and headings that talked about earnings per share and capital expenditure growth. And the argument here that the hearing examiner appears to have latched onto is that capital expenditure growth is somehow driving the AIP payout and rewarding shareholders over customers. And it's simply not what the facts and the evidence in this case showed. Rather, Mr. McGowan explained during his testimony at the hearing how the 2 pages selected were taken entirely out of context, how capital expenditures were in fact driving improved performance and enhanced customer experience, how all of Delmarva's capital expenditures have been approved by the commission prior to going into rate base, and how Delmarva's customers have benefited from those expenditures. And you heard earlier in Ms. Ira's opening statement about the merger and the cap, and yeah, that's true. Delmarva did have caps in place for its reliability spend from 2016 to 2019, and Mr. McGowan acknowledged that as well in terms of the utilities capital spend, and further acknowledged in his testimony that Delmarva actually underspent during that time. And so he also explained how the earnings per share figures cited on the investor presentation included generation assets. So the sentence that Ms. Iori read to you earlier was taken from a slide in the investor presentation. And if you'll humor me for a minute, I'm going to read it to you, but then I also want to read to you what Mr. McGowan said about it, because I do think it speaks to the issue. So the bullet point taken off of the single page says, regulated utility growth, targeting utility EPS rising 6 to 8% annually from 2019 to 2023, and rate base growth of 7.3%, representing an expanding majority of earnings. And this is on Exhibit 53, and it's also in that packet that you have in front of you. And Mr. McGowan was asked about this during his cross-examination, and again on redirect. And one thing I would mention before I read this is that, growth is not a bad thing. There's benefits that are provided, and that's much of what his testimony supported. But here's what he said with respect to that exact sentence. He said, what this slide and this bullet point is trying to say is, when you look at the capital investment plans of all 6 Exelon utilities, these are capital plans that are designed to improve reliability, meet commission and customer expectations. When you add all of those up together, it results in the 7.3% rate base growth over that period of time, 2019 through 2023. So that's just telling you the amounts of investments we're making in our jurisdictions. And the last point, and obviously we talked about it earlier, is that spending capital does not necessarily generate earnings. But if we were to get recovery of those investments, it shows what the earnings per share of the company would grow to. Again, subject to commission approval of those investments. But I think, more importantly, the last part of that sentence, representing an expanding majority of earnings, that issue is a mixed issue between the generation part of our business and the regulated part of our business. I know when Exelon first merged with PHI, I believe the generation represented about 70% of the company's operating profits, and the regulated companies represented 30%. Because of the decline in generation revenues over the years, because of natural gas prices, the percent of the regulated business has taken a larger percent of the overall Exelon story. So that's what the bullet point was trying to communicate. So I think it's important to hearken back to that, because this is just one statement pulled out of the air and plopped into this rate case, and it's really not indicative of what the company has done in Delaware and what it is doing in this case, or the incentive compensation that is tied in to this case. The reason that it gets discussed is because of the AIP plan. So let's talk about the AIP plan. The AIP plan that was in front of the commission in docket 13115, with which it was concerned, contained an earnings trigger. You may remember this. The earnings trigger was such that even if all of the customer safety and reliability goals were met, the AI payout could be reduced to 0 if a certain earnings of the company weren't met. That's gone. There is no concern here for the commission that if the AIP metrics are met, the employees are still going to get a 0 payout. That disincentive isn't there. The reason that the focus on capital has come into play here and the earnings on share is because there is a new metric that is included in the 2018-19 and 2020 plan, and it's simply a metric, and I'm going to keep it really high level because, again, this goes into confidentiality, so I won't go into specific numbers. But all that this does is it essentially looks at the capital plans of the 6 utilities and says, okay, you have all forecasted that you're going to spend X, and we want to make sure that you're staying within your budgets and that you're adhering to the budgets because we think that promotes efficiency and operational excellence. And so if you miss that budget under or over by a specified threshold, then we could, we will, apply a curtailment, a specific reduction of the AIP. It's not a complete reduction, it's a minor reduction. And I would add that it's never been applied because each of the years, the company has met its targets, right? It has done what it's supposed to do. It has kept the budgeting and the spend in check. I think that there's 2 points I would just make about that. And this is part of the issue that I have with the hearing examiner's recommendation and the analysis with this particular adjustment. He seems to have taken a piecemeal approach and picked evidence and picked testimony, applied new numbers to stale testimony, and inserted different thresholds into different places. And the point is, the way that he mixed and matched it all together doesn't accurately reflect what the actual facts are in the case. And so I think you need to understand a couple of things, and really, most importantly, it is that we're dealing with the 2020 AIP plan. And that plan is different than the 2019 plan, which is the plan that staff witness Pfaff originally reviewed and his direct testimony speaks to. It's his surrebuttal testimony where he talks about the 2020 plan. And the change between those two plans that's most important is that threshold we just talked about was actually larger before. It gave the company more room to spend more or to spend less. In 2020, they said, we're not going to give you all that room. We're going to decrease it. Also, previously, the PHI CEO had the discretion of whether to apply that curtailment or not. 2020, he doesn't have that discretion. My point being, if the company's goal was really, as DPA and staff suggest, which is to increase capital spend at all costs, they wouldn't have these thresholds in place. They wouldn't have reduced the threshold. They would have increased it so that they could spend more. And even in the years where those thresholds were there, the company, the spend was minimal. They could have spent way more in 2018 and still gotten the full AIP payout. So, I think that that's just a little bit of background, and it may have been too far into the weeds here. But the most important thing to remember here is that it's important to look at the total cost here and the true cost. And this is not excessive, it's not extraordinary, it's not unnecessary. It is what is required for the company to provide reasonable, just and reasonable rates at safe and reliable service to its customers.
Thank you very much, Ms. Ivory.
Thank you, Chairman Winslow and Commissioners. The DPA did not take a position on this particular adjustment, although I must say I've never heard my name mentioned so often for an adjustment that my client didn't make.
Mr. Geddes?
I'm not sure where to start, but let's start at the beginning. As we set forth in our exceptions, the Eastern Shore case is a pretty important case in trying to determine what the Commission's responsibilities are here. As Counsel for Delmarva has indicated, the Commission's prior decisions, 13115 in the Artesian case, in 05304, have denied these types of expenses as unnecessary. So that's the base on which the, could I have the slide, please? Thank you. That's the base on which the Commission, or the context, or the overview, that the Commission should consider this issue. Sorry, what is it? I can't read that far, that's a problem. Oh, reliability. Oh, let's go to the next one, please. Thank you so much. I need glasses, obviously, because I barely see that thing. So this is the context on which the discussion by the attorney, which I would say could cross into testimony, but in any event, all of which the hearing examiner heard in this case, and decided was not of a sufficient weight to go against the Commission's precedent in prior cases, which is based on decisions that you have made in the past. So the first point I would make is that you have found these types of expenses, irrespective of whether they are tied to a trigger, as unnecessary to provide utility service. That's been your prior finding, both in Delmarva cases and also in the Artesian case. The hearing examiner, in his discussion on pages 48 and 49, goes through some of this analysis and does suggest in paragraph 139 that because of the COVID pandemic and its negative effect on the economy and overall job market, staff maintains that according to the Commission's decision in 05304, the Commission must consider the economic climate and ratepayers' financial condition. So that's an additional data point that was not in this case or in the prior in the prior Artesian case. But in both cases, these types of incentive plans were found to be unnecessary. So if the Commission wants to change its position, you would then be determining that the incremental costs associated with these programs, $6.6 million, which is a pretty big number, is necessary to provide adequate service. In the prior case, you decided they were not necessary. You would have to change that finding, and I always like to say you'd have to give us some breadcrumbs, i.e. you would have to tell us under Eastern Shore the reasons why you believe, in this case, that these types of expenses are necessary. Next slide, please.
And I might reply, excuse the interruption, I might reply that Mr. McGowan provided some factual background.
He did. And there's, I'm getting, hopefully
Okay,
getting
okay,
there.
Okay.
Slowly, building.
Okay, good.
I can read this slide, sir. In the prior case, you decided that SERP, which is not tied to any trigger at all, like AIP, is an extraordinary expense, not necessary to provide utility service. So that's your baseline. Now, in this case, there have been some changes. I would submit to you, hopefully I'm not going anywhere, but I believe council had suggested this, that some of this AIP, which is KPI, trial by acronym, but anyway, some of this is still tied to capital budgets. And so generically, you can at least understand that if some of it is tied to a capital budget, there could be incentives either way, but presumably to make that budget, i.e. a financial requirement or obligation, which Ms. Iori in her opening suggested was part of Exelon's overall strategy to grow its rate base, i.e. capital projects, et cetera, et cetera. So this is not completely devoid from some aspects of capital, which clearly is tied indirectly somehow to earnings. So I can't say, I don't think anyone can say 100% of this has no financial trigger at all. But irrespective of that, you previously determined that these costs are not necessary. And even though this is a new case, and council suggests that this is required to attract qualified employees, Mr. Boyle, who testified in the prior case, 13115, stated the same thing. As staff witness suggested in his testimony, in his supplemental testimony, Frederick Boyle claimed that the incentive compensation allowed the company to attract, Gloria, and retain skilled employees, and that it was a prevalent and well-established practice within the industry. That was the testimony in that case. Mr. McGowan, almost identical testimony in this case. But the commission considered that and decided that these expenses were not necessary for the provision of safe, reliable utility service. So what did the hearing examiner do? He listened to this testimony. He listened to Mr. McGowan. He listened to staff witness Pat. And he made the determination based on what he observed that it fell within the precedent and it was not necessary to provide utility service. He heard the evidence. You've heard a portion of the evidence through a lawyer. And I would suggest to you that this is the same. This is an extraordinary expense. You would have to find that this compensation that is paid in this way at the company's choice is required to provide utility service in Delaware. That the ratepayers in this environment should pay $6 million more in base rates to keep the lights on. And staff does not believe that the company has made its case on this adjustment to persuade you that you should change your longstanding precedent with regard to incentive compensation and make ratepayers pay for it. Thank you.
Do we really have a long-standing precedent against incentive payment, or do we really have a long-standing principle or policy about particular incentive programs?
Well, you have determined 05304. You've determined in the Artesian case 14193. You determined in 13115 that this category of expense is not an ordinary expense. It's an extraordinary expense, which under the Chesapeake standard cited to you by counsel has a different standard. And specifically, the group that makes that determination is this commission. You have determined this is not an ordinary expense in the past and not necessary. So you would have to decide in this case that the evidence is sufficient, that the hearing examiner heard and rejected, to overrule him and make a finding that it is a necessary expense. Thank you.
Ms. Schultz,
Sure.
are
if
the
I-
classes the same or different than the previous decisions we've made?
I'm sorry, could you repeat that?
Are the classes of incentive, the incentive classes, are they the same as in the previous cases, or are they different?
No, they're different, Chair Winslow, because, you read about SERP, but SERP is not here. SERP is not in this case. What's in this case is AIP, and this AIP plan that's before you today is not the same as the one that was before you in 13115. In 13115, and I will read from you from the decision in that case, what you said when you declined to include that plan was, we are not convinced that this plan can be analyzed without the earnings trigger that is contained within it. And that was the earnings trigger that zeroed out the award if earnings weren't met. That's not here anymore. It has nothing to do with the case. It's a different plan. You said, for the same reasons, that's why you believed it to be an extraordinary expense. You said, we believe this to be an extraordinary expense tied to an earnings trigger that protects shareholder interests. And you said, even with regard to that portion of the plan that is tied to safety, reliability, and customer service. And so if we look at the plan today versus the plan then, what we have only left today is that portion that is tied to safety, reliability, and customer service. And that evidence is in this record and was shown on this record. And that is the evidence that Mr. McGowan provided as well with respect to it being within the company's business judgment of how to structure its compensation. And the fact being that there is a base and there is an incentive, but that is the whole. It is not incentive on top of base. It is not that it costs $85,000 to employ Joe and we're just going to give him $15,000 more because he did a good job and he looked out for the company's interests. It's that the market's telling us that it costs $100,000 to employ Joe, but we are going to tie $15,000 of that to making sure that Joe's performing at his best for our customers and hitting these goals tied to safety, reliability, and customer service. And finally, I guess what I would say is with respect to, I think those are some of your breadcrumbs, if I may use Mr. Geddes' phrase. With respect to the economic environment and that finding by the hearing examiner, again, I'm going to have to go back to Mr. McGowan and his testimony, which he provided, and he said, we believe that these expenses represent the costs of doing business in all different types of economic situations. And recovery of these costs simply ensures that we recover 100% of the total compensation required to employ these individuals. As I mentioned before, not 80 or 85%. The company's total compensation is compatible with going market rates for payment of workers in a given job. The economy is never stagnant. It changes every year. And to disallow otherwise reasonably prudent costs due to the economy would not be reasonable. It's an ever-moving target. And so, Commissioners, respectfully, I would suggest that the record here is much different, that the PSC should agree with the company and with DPA, and should reverse the hearing examiner's flawed recommendation with respect to this adjustment.
Point of clarification, because I think council misspoke or conflated two concepts that were in my prior slide, which I was trying to get back up again. If I could get it, not the SERP. Which one? Not the SERP one, the one before, please. The one previous? Yes, please. Thank you so much. The first sentence. The commission found that these costs are not necessary. I misread the saying. We are not convinced that these costs are necessary for the operation of the company in providing utility service to customers. Full stop. No mention of triggers, no mention of anything. It's the same language that's in the SERP. If I could have that one, please, Rona. Where you found the SERP to be like AIP, an extraordinary expense, and not necessary to provide utility service. Third point and last. In this case, they removed SERP, which you found was similar to executive compensation, or incentive compensation, I should say. So I think it's pretty clear that the commission made, in the prior case, a finding, irrespective of triggers, that the expenses were not necessary for safe, reliable service.
Ms. Iori, please.
I was just going to say that at the end of Ms. Schultz's discussion, she said you should agree with the company and DPA. Again, I reiterate that the DPA did not take a position on this. We did not say that we agreed with the company. We did not take a position.
Thank you very much. We realize that. Commissioners, any questions? Commissioner Drexler?
Yes, my question is for Ms. Schultz. It says executive incentive, but you talked a lot about non-executive compensation. So this is an overall plan, and that's my understanding, and that's correct.
That is correct. The heading on the chart is
Okay.
not correct.
Okay.
This is executive and non-executive. This includes, people all throughout the company. This is not golden parachute type.
Right. And so
Stuff.
the 15% you mentioned, that's an actual potential for every employee.
I believe there are certain categories that may not be within that. I wouldn't want to tell you it's every single employee. There are unions that I believe may be separately dealt with, but
Understood. Yep.
in the general sense, yes.
Okay. And historically speaking, let's say it's 15, let's say it's 10, whatever. Is the maximum payout pretty much the rate at which it's been paid in the past? Is this, let's use 10% instead of 15. Generally speaking, is that a 10% number that's pretty much paid across the board, or is it unusual to get 15 or 10%, and typically people get 1 or 2% or something like that?
Okay, so if I'm understanding your question correctly, there is an exhibit in this
Okay.
case that will show you what the AIP payouts have been
Okay.
over the history, 2018, 19, and there was testimony from Mr. McGowan during this case that the 2020 targets were met and that the AIP payout was going to be made. So it's a bit amorphous and it treads a bit into some confidential ground, but I think what your question is, and what I can answer for you, is that the AIP sets thresholds for each of those customer-focused elements, KPIs. And those are routinely met or exceeded in many instances. And when they're exceeded, that can increase the amount of the payout. So I would say to you that I think if you look at that exhibit, what it will show to you is that historically, the payout has actually been above the target.
So the
Um,
payouts are consistent, not the amount or the percentage, but the fact that those payouts are made is a consistent.
They are, and consistently in the past, the payouts, as I mentioned, have been above the target. So let's say the 15% was the target, they've been above because the performance has been very good. And actually, what the company did in this case, and Mr. McGowan and Mr. Zeminski both explained this in their testimony, is they didn't, I mean, they forecasted in terms of what's included in this particular adjustment for those 3 months of forecasts. They forecasted as if the threshold was met, even though in the past it's historically been exceeded. So it's a lower cost in here actually than what you might expect to happen if you're looking solely at historical performance.
Thank you.
Mr. Commissioner Gray?
Thank you, Mr. Chair. So I'm going to, I have a question and 3 statements. Have you lowered the base salaries for any execs or employees already employed and made 15% contingent incentives? But new employees or execs will have a portion of the base salary and a portion of incentive comp?
I am not sure that there is any evidence in this record to be able to articulate to you whether or not current or existing employees have had their compensation lowered. I could tell you that absolutely definitively, the compensation set for every new employee uses this Exelon compensation methodology that Witness McGowan testified to, that looks at the industry. And that's been in use for a long period of time by the company.
Okay. Incentive compensation, from my experience, needs to be intimately tied to financial performance in order to be able to afford to pay the incentive. I mean, just principally speaking, otherwise you wouldn't have the means to make the payout. Incentive comp is usually contingent on risk, am I right? In other words, if you don't get the metric that is being looked for, you don't get the incentive comp.
Right, that's what we've called it, and we've deemed it kind of the at-risk portion of the employee's compensation, because their performance, as well as the performance of their peers, is driving whether they're going to get that other piece of their total compensation.
And it's above base compensation.
It is above the base annual guaranteed salary that they get, but in terms of the overall compensation, I would argue that it's not above the base. It is their total package of compensation. That I would tell you, we may view it differently, but I would tell you that, you know, $100,000 is the salary for John Smith. There may be 15,000 of that is at risk and 15,000 of that is guaranteed, but his base in the industry is $100,000, no matter which way you want to look at what's comprised of that 100, if that makes sense.
Not really to me. I see them as 2 separate categorical types of compensation. One is a base and guaranteed, the rest is on risk.
Sure,
Okay.
I would agree with that.
Okay, I don't have any further questions, Mr. Chair.
I have a
Just
question.
point of clarification.
Commissioner Correa?
Sorry.
You had say if we reverse the case, and suppose we are not accepting or giving this thing, do you expect, because it's not allowed, and you will change the this additional compensation, you expect that so many employees will leave, or will your turnover rate go up even at the executive level?
I think that is probably beyond the scope of what I'm qualified to opine upon, given what's in the record in this case. But what I can tell you is that the testimony that's in this record and what the evidence reflects is that, yes, the company does believe that this is necessary to attract and retain its executives. The LTIP portion of this, we talk about the AIP more, but the LTIP portion is really the long term. That's the one that's in play in addition to AIP, that is meant to make sure that, as you've talked about them, those upper level executives don't walk out the door tomorrow because there are 3-year or whatever the period of time incentives to keep them there, which is in the company's interest in not having to retrain or ingrain the knowledge of how to run the day-to-day operations of the company.
So what I was thinking was, and trying to, that can we tie it into the cost of service to the customer? And it doesn't seem to be that you already provide the base salary of, say, for example, $100,000. So that is the cost of providing the service, actual electric service. So additional, and that was I was hinting at, that the additional compensation is maybe directly related to financial results and other factors, but the basic electric service cost has nothing to do with that. That was my point when I said first.
Oh, well, then I would think that you maybe haven't looked at it in the right way, because what the testimony shows and what I thought I was articulating, but probably did so poorly, is that the 100 is the operational cost.
Yeah.
And that's the full cost to employ John Smith. And that is the cost that includes the AIP component. To me, it's the same as if the company said, here's my wages and salary, it's $100,000 for John Smith. But historically, people have looked at it differently, and so it's here in an adjustment as opposed to just being wrapped into John Smith's wage each year.
Okay.
Point of clarification, if I might, I'm trying to respond to Commissioner Gray's question to council, which I have a response to about the evidence in the record.
And it comes, yes, sir.
There was no evidence presented in the record that the compensation levels had been reduced as a result of the inclusion of incentive compensation.
I don't,
Yeah.
I'm not sure why you made that comment, but I agree with you.
Well,
But I
I
thought
believe he
that-
asked council, I was just trying to respond with what I had in the record. There is no evidence of that.
Well, what I gather, hopefully I'm right about the record, but from Mr. McGowan's testimony, is that they've made a business judgment that the best way to obtain and retain employees is to have a combination of salary and incentive program, and that the combination of both would be marketplace for that individual. That individual has got to earn and produce and satisfy the demands of the business and the consumers it delivers electrons to in order to actually get that last 15%, which I think the company has done in 2020, probably pretty intentionally because of our rulings in previous rate cases. And there's nothing wrong with that, because they've now, I think, refocused, according to Mr. McGowan's testimony, on the basics of operating the company. And they've also shown, I think, in the record, some pretty good results as far as the operation of the business is concerned. So I think there's an easy way to distinguish it between our previous decisions, and I'm mindful of the dollar figure. But then I reflect upon that dollar figure, and I think about Delmarva and all its employees and what they do and how well they do it, and I don't get nearly as upset about the $6 million figure, to be quite candid with you. So I'm supportive of the company's position. I was thinking, to be perfectly candid with you, why don't we cut the baby down the middle? Maybe Delmarva doesn't have it just perfected in terms of this salary structure, but no, I changed my mind. I think that it is really been proven, it's on the record through Mr. McGowan, that this is a competitive marketplace and that this particular incentive program is instrumental in their hiring and retaining people. And I think it's not extraordinary. Apparently it's done commonly in the industry. And so I'm going to be supporting the company's position. Somebody have a motion to make? I will move that the company's position be affirmed.
And I second that.
Is there any discussion on the motion?
Mr. Chair, I'm quite mixed on this issue, but I do believe companies will get the behavior and performance that they pay for and reward, so I'm going to support you.
No more discussion? All those in favor signify by saying aye.
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 Any opposed? Any abstention? The matter passes.
Thank you, Commissioner. Just for sake of clarity, the commission, to be clear, is voting to reject the hearing examiner's recommendation.
That's correct.
Okay.
And accept the company's position
Thank you.
for the reasons in the breadcrumbs indicated by Kevin McGowan.
Thank you.
Prepaid pension asset and other post-employment benefits liability, I believe, is next. And Ms. Schultz again?
Yes, we're rolling along here. This is great.
You're going to make your incentive this year, Ms. Schultz.
If only. I don't work for Delmarva. But anyway, prepaid pension asset and OPEB liability balances, everybody's favorite topic. One thing I will mention is, you'll notice from the chart you had, this topic as well as pension expense and OPEB expense are following each other. So I'm going to keep them separate as best I can. But I just wanted to reference that because you do need to think of them together. So what happened here? Okay. Delmarva included, I'm going to refer to the prepaid pension asset as the PPA, just for sake of clarity here. Delmarva included its PPA and OPEB liability balances in its rate base in its application in this case. These balances have been included in rate base for the company consistently by the commission since they were first established in docket number 05304. Staff did not oppose the company's request to include the balances in this case. And while the topic is no doubt complicated, I'm going to simplify it as best I can in the presentation here for all of you today. Now, without justification and based on facts and circumstances that are really no different than those presented in the previous cases, the hearing examiner has done a complete about-face, eviscerated the commission's precedent on this issue, and recommended that the PPA and OPEB liability balances be excluded from the company's rate base. He seemingly latched onto the same arguments that have historically been rejected by the commission, advanced by DPA, though the facts compel the commission to adhere to its precedent here and to reverse the hearing examiner's recommendation on this issue. Now, while it's not abundantly clear from the recommended decision, it appears as though the recommendation was based on the following facts and arguments made by DPA. First, that Delmarva's investors did not contribute to the plan. Well, that's not true. The evidence unequivocally and indisputably shows that Delmarva's investors contributed $167 million between 2009 and 2019 to the plan, and that in prior cases where these balances were included by the commission, no contributions had been made by investors in those years. And in some of those cases, it was unclear what the level of investment even was from investors. So that fact alone was not dispositive. But in this case, we actually have all parties agreeing that during the period from 2009 to 2019, Delmarva's investors actually put in $167 million into the plan. Customers have benefited by the inclusion of the PPA and OPEB balances in rate base since 2005. It's the resultant investment returns on the plan assets that have actually served to historically lower the pension expense. And that expense, if we look at it from the beginning of time until today, company witness Zeminski testified, is $230 million less than it would have otherwise been without recognition of those returns. Customers technically fund the OPEB liability balance. The company funds the PPA balance. And disallowing the OPEB balance, for example, prevents customers from earning a return on that. The second fact I think he found persuasive is that the resulting pension expense is positive, which actually increases customer rates. Well, this is a true fact, but it does not dictate recovery, and it never has for this commission. In the past, the PPA was included when the resultant pension expense was negative, resulting in lower rates. It was also included when the resulting pension expense was positive, increasing rates. Today it is positive, but simply because the asset or expense is going to increase or decrease rates, it doesn't have a bearing on the reasonableness or the justness of the item in particular. Third, he made a finding that the PPA was not, quote, used and useful. And this, I think, is really a misinterpretation of the law, and it's also the same argument that's been made in the past and disregarded by the commission as a reason for disallowance. The primary point here is that used and useful criteria relates to plant. And quite frankly, many other items are included in the company's rate base, though not used and useful, because they, like the PPA and OPEB liability balances, are not plant, such as, for example, accumulated deferred income taxes, which are included in rate base and included in this case, uncontestedly. Because this is simply an accounting entry on the company's books. We should just remember that. It's different. Used and useful is not the appropriate standard here, nor is it a reason to disallow this item. The final reason that we see from the hearing examiner's report is that he has determined that this balance is not investor supplied, and so it's not cash working capital. Again, it's not an accurate recitation or application of the law. Such a finding stands in stark contrast to prior commission decisions that expressly find the PPA does create a cash working capital requirement. The commission has expressly stated as much in prior decisions on this topic. Now, I can unpack that one a little bit for you. Again, it's complicated, but on a very high level, here's what happens. Whether the asset or the liability is funded by the shareholders or by the customers, the funding represents the cash working capital requirement. The customers or the company have to pay back that money over time. These assets that go into the plan, as the commission has historically recognized, can't be used for other purposes, right? There are laws out there that say Delmarva can't touch this money, but the returns that are generated by those plan assets, which in turn have been passed on to shareholders throughout the years, the company has to find another way to give that money. That creates a cash working capital requirement. That's the most simplistic way to put it. And I think that the commission has recognized the company's need to generate revenues to offset those reductions in the past when it has unequivocally included these balances in rate base. And so if they're removed, what it does is it creates cost-free working capital for customers. And so those are the four reasons that I could discern from reading the hearing examiner's report. None of them are any different than past circumstances. If anything, there's the most evidence the commission has ever had before it that investors have actually supplied cash into the plan than it ever has before. Simply because the pension expense is positive and would increase customer rates in this case is no reason to find that the balances shouldn't be included. Historically, they've decreased rates. It wouldn't make any sense to give it in one case but not in another. There are no reasons that have changed that would articulate making a departure from commission precedent on this issue. And so Delmarva would strongly urge this commission to reject the hearing examiner's recommendation and to instead side with its longstanding precedent of including these balances. I would mention there is an additional recommendation that goes along with this that relates to the pension expense. I think it's probably best addressed with the pension expense. I'm happy to take questions on it should they arise here, but the bottom line is this. In removing these balances from rate base, the hearing examiner acknowledged that it would not be appropriate to remove these balances from rate base because of the lack of investor funding or whatever the reason, and then allow those same returns to further serve to continually reduce the pension expense. So what he did is he took out these from rate base and then he said, but then, I agree with company witness Szyminski, you would have to go and increase the expense for pension and OPEB, because you can't include the investor component there, but not include it here. I don't think we need to get into that, because I think that it's important that the commission reject his recommendation and simply put them back in to the rate base where they belong, which is where the company proposed to put them in the first place.
Ms. Iori, I see what you're, no, go ahead, Ms.
I'm
Iori.
sorry?
Yes, please go ahead.
Thank you, Chairman Winslow, Commissioners. This actually is one of my favorite issues. I know everybody else hates it. And this is the third time that it's come up before you, and hopefully the third time is the charm. It certainly was for the hearing examiner. As you know, we first raised this issue in docket 05304. And in that case, the commission did accept the hearing examiner's recommendation to include the asset in rate base because the expense amount was negative, which reduced rates, and because he found there on the facts that were presented in that case, it was investor-supplied cash working capital. Now, the commission also accepted the hearing examiner's recommendation to include it in rate base in the last litigated docket, 13-115, but you really didn't substantively consider the issue. Here's the entire discussion on the issue, and I've included the relevant excerpt from the order at the 9th tab of the package that I gave you, and I direct your attention to paragraph 99. And I quote, "We agree with the hearing examiner that this issue is not as fully developed on this record as we would like. It is a complicated issue, and we appreciate that the parties have tried to enlighten us on the nuances of the arguments that underlie their various positions. But we note that we have allowed this adjustment in at least one of the prior Delmarva cases when it was objected to. And although we could remand this to the hearing examiner to develop the record further, as one commissioner suggested, we have decided not to do that and to include these two items in rate base." End quote. So the DPA set out in this case to fully develop the issue on the record. And to use a word from my colleague, Ms. Schultz, we developed unparalleled facts. Now, before I go into the details of the record, I want to point out that in the Delaware Supreme Court's 1994 Eastern Shore Natural Gas case, the court held that the commission can change its position on an issue as long as it rationally explains why it is doing so. And in fact, you just did that with respect to incentive compensation. Now, we're not saying that precedent is irrelevant. We argue that the commission's precedent should be followed in our argument on other contested rate-making issues. What we are saying, however, is that the commission can change its mind, and we are saying that the commission should change its mind here because the DPA presented undisputed evidence in this case to support reaching a different conclusion, which we had not done to either the hearing examiners or the commission's satisfaction in docket 13-115. Now, here are the facts that the DPA's witness presented in this case and that the hearing examiner found as facts. 1, Delmarva made no contribution to its pension plan from the time FAS 87 was adopted until 1995. 2, as of December 31, 1996, the balance of Delmarva's prepaid pension asset was $33.288 million. 3, between 1995 and 2008, Delmarva made no contributions to its pension plan. 4, by the end of 2008, the prepaid pension asset balance had grown to $184.098 million, with no contributions from Delmarva shareholders. 5, Delmarva incurred a total of $177.389 million in pension expense between 2009 and 2019. $153.839 million of that was due to positive pension expense between 2009 and 2019, and $23.550 million in 2009 was due to a transfer of employees from the Delmarva plan into other affiliated company plans. 6, however, Delmarva only contributed a total of $167.098 million to the pension fund between 2009 and 2019. 7, despite these contributions, the value of the plan assets fell by $10.291 million between 2009 and 2019. And finally, the pension plan balance cannot be used for any reason by Delmarva. It cannot be used to make up a shortfall somewhere else. That money is untouchable. Now, Delmarva didn't dispute any of these facts. It merely argues that circumstances haven't changed since 13-115. But the commission itself stated that a more detailed record would have been preferable. And the DPA established facts in this case that it had not established in 13-115. Based on these facts, the hearing examiner found that none of the pension plan's balance could be considered cash working capital under Delaware law because none of it had been contributed by Delmarva investors. And that's key, because to be cash working capital under Delaware law, it has to be investor supplied. That is, definition is 26 Delaware Code, section 102, subsection 3F, as in Frank. The hearing examiner also noted that the nature of cash working capital is to offset short-term revenue losses from seasonal fluctuations, decreases in sales, or cash flow timing issues, or to pay for capital projects. He also found that because Delmarva could not use the pension plan assets for any other purpose, it was not used and useful under Delaware law. And that's 26 Delaware Code, section 102, subsection 3A. The hearing examiner didn't consider the case law from other jurisdictions that either Delmarva or the DPA submitted, and while the DPA understands that that case law isn't binding on this commission, it is illustrative, and we believe it supports the decision that the hearing examiner reached here. Finally, the hearing examiner never addressed Delmarva's and the DPA's arguments regarding generally accepted accounting principles, or GAAP. Delmarva argued that GAAP requires it to record and report the pension balance as an asset, and so it's complying with GAAP. But the short answer to that is that the commission isn't bound by GAAP for rate-making purposes, and it has so held before. So Delmarva's compliance with GAAP is irrelevant. Delmarva argues also that the pension expense was positive in docket 13-1152, but the commission still allowed it to include the pension asset in rate base. And we don't disagree with that. But again, the commission itself said that the record in that case was not as developed as it would have liked. And I note specifically in docket 05304, the commission made a point, specifically pointed out that it was appropriately included in rate base because it was caused by a negative pension expense with reduces base rates. So that was an important part of your consideration in that docket. The fact that the expense is now positive, which increases the revenue requirement, should also be a consideration. The DPA respectfully submits that the hearing examiner's recommendation should be accepted, and we agree that rate base and operating expense will change as a result if the commission does accept the hearing examiner's recommendation. the amount will be pulled out of rate base, and the amount of pension expense will increase. But the fact that something is included or not in rate base or O&M happens whenever you make a decision on a rate base or O&M item. And rate base will increase or decrease, and O&M will increase or decrease. So that effect is not unique to this adjustment. Thank you. Oh, I'm sorry, one other point. Delmarva says that it was, including the pension asset previously resulted in ratepayers paying $230 million less than they would have. That is all in the past. And to us, that's not really a consideration at this point. Thank you.
Thank you, Ms. Iori. Mr. Geddes?
Thank you, Mr. Chairman, members of the commission. Staff did not take a position on this issue. Staff in the prior case did not take a position on this issue. So I want the record to be clear that, consistent with the last case, we chose not to take a position because we knew that Ms. Iori would take the position. I was going to say something smart. I decided not to, but that she would advocate for that position.
Commissioners, I'm sorry, Ms. Schultz, please.
Sure. I mean, I just, for a couple of points of clarification, yes, the company has proposed to treat this consistently as it has done in the past. As you heard, Mr. Geddes, staff has not taken a position in this case. They did not take a position to join the DPA, which they could have done as they collectively did on the ROE. I think that with respect to the development of the facts in this case, you do have a very fully developed record in this case. But the fact that the record is fully developed doesn't change the result. The result should still be that these balances get included in rate base. Because if you go back to docket 13115, which cites to the order from 05304, the quote from 05304 is, "The company has no access to this asset to use it for other operating expenses. It is precluded by federal law from using any of the money it has collected for pensions for any other expense." That paragraph in the order from which this comes from continues to say, "Furthermore, the prepaid pension asset and OPEB liability create a cash working capital requirement that cannot otherwise be accessed by the company." In paragraph 96 of Order 13115, it says, "Although noting the DPA may ultimately prevail on its contention that the funds comprising the prepaid pension asset and OPEB liability were not supplied by investors, the hearing examiner found that the prepaid pension asset should remain in rate base as the case law and pension plan evidence presented in this proceeding did not warrant changing established commission precedent." The same is true today. As I stated earlier, the fact as to whether or not investors have supplied the capital or not is not dispositive. Regardless, there is a cash working capital requirement. In the past, investors have not supplied that capital, yet it has been included. In the past, it's been unclear how much capital has been supplied, yet it's been included. In the past, each instance it's been included, and here we have unequivocal evidence that we did supply capital. So it would not be the appropriate time now to find that in the first case, where it is abundantly clear that investors have supplied capital, the PPA balance should not be included. In addition, sorry, I lost my trail of thought here. Give me 1 second. If you were to reverse precedent in this case, Ms. Iori suggested that the $230 million expense reduction is over, it's in the past, it's done with. But the fact of the matter is that the way that this has been reflected in rates and removing it going forward creates a lack of symmetry and an imbalance in the way that rates will be set. And it's unequivocal that the evidence in this case does not dictate a different result than in the prior case. Nothing is different here today. The same facts, the same evidence, the same arguments that this commission heard and rejected time and time again in '05 and '09 and '13, all trotted out again here today, and all should be rejected for the very same reasons. Nothing compels a different result, and I would urge you to reject the hearing examiner's recommendation on this issue.
Thank you very much. Commissioners, questions? Mr. Correa, do you want to say anything, Commissioner Correa?
I don't have a question.
No? Okay. I think a lot of commissioners like to be quiet on this issue. Commissioner Gray, any enlightening comments?
Unfortunately, Mr. Chair, I don't have on this issue. I'd be inclined to lean toward precedent in this issue. And on that basis, I would make a motion that we support the hearing examiner's position.
For point of correction, if,
Not the,
okay.
I think your motion is to reject, because
Hearing examiner.
I'm sorry, correct. One second, please. That's correct. I would move that we follow precedent and reject the hearing examiner's position.
And I second that.
Is there any discussion on the motion? All those in favor say aye.
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 Any opposed? No, I abstain. I don't know what good that does, but maybe Ms. Iori will feel better that she made some progress.
I'm sorry?
I said, I don't know why I abstained, but I guess maybe it's because I want to make sure you feel like you made some progress.
I would have felt better if you had voted nay.
It's a half step.
Okay, so, Ms. Schultz, the next one?
Sure. Next, we're moving on and capturing two adjustments in one argument. Adjustment number 7 and 8 relate to pro forma pension and OPEB expense. Here, it's going to be a lot less complicated than the last argument. In this case, the company recommended that, consistent with commission precedent, these expenses should be based on the actuarial determined levels for future level of the pension and OPEB expenses, as the commission determined was its policy in docket 13115. The DP argued instead that these expenses should be normalized over 3 years using historic and test expense levels from 2018 to 2020, and the hearing examiner recommended to use DPA's normalization instead of the commission's policy in favor of actuarial determined amounts. There was no evidence in this case of any changed circumstances that would make it appropriate to change the commission's policy of using precise, forward-looking actuarial determined amounts in favor of looking back at historical experience to determine these future costs. Given that the goal is to determine rates that will best reflect costs going forward during the rate effective period, and that actuarial determined costs used by the company are based on most recent scientific and empirical data available and take into account changes in actuarial assumptions and investment returns, it is those numbers and assumptions that should be used for these expenses. The commission should reaffirm its policy and reject the hearing examiner's recommendation, finding instead in favor of the company's proposed adjustments. Thank you.
Ms. Iori, thank you.
Thank you, Chairman Winslow and Commissioners. The DPA has recommended using a 3-year normalized expense level. I would note that this proposal actually gives the company a greater expense level than the 2020 actuarial estimate. The DPA's proposal acknowledges the volatility of this expense. The undisputed record evidence reflects that this expense has ranged from approximately $8 million in 2018 to over $15 million in 2019, back down to approximately $8 million in 2020. The DPA's proposal is based on the company's experience over the last 3 years and is more likely to reflect the future level of expenses. And so we would respectfully submit to the commission I'm sorry, I just had a brain cramp.
question.
You didn't say it.
I would also note that in the last litigated decision in docket 09, or in last time this issue was litigated, in docket 09419, the commission did normalize the expense rather than using just the one-year actuarial estimate. So we would respectfully submit that using a 3-year normalized amount is more likely to be representative of what the company can expect going forward and should be accepted. Thank you.
So you think that your calculations on using normalization will be more accurate than actuarial?
Well, we think that they will better reflect the level of expenses the company can expect to incur.
Mr. Geddes?
As with the other issue, Mr. Chairman, members of the commission, staff did not take a position on this issue in this case. Thank you.
Ms. Schultz, any comments?
I have a comment.
You can ask your, you want me to go first?
No, you go ahead.
Okay. I would just read to you from Order 13115, paragraph 89, quote, "By way of background, since the adoption of Financial Accounting Standards Board Statement Numbers 87 and 106, and pursuant to the Commission policy, pension and OPEB expense have been determined on an actuarial basis using the accrual method of accounting. The volatility of which Ms. Iordi spoke is dealt with by using the actuarial determined amounts, which are based on scientific empirical data and do reflect the best estimates of the future costs. Even though the company acknowledges we would be getting an increased expense level if we used the DPA's normalization and the hearing examiner's recommended normalization, we still believe that the policy should hold that actuarial determined results are the ones to use."
Thank you. Commissioners, any questions? Commissioner Korea?
I like the, and I agree with this, that the commission is not bound by GAAP regulations in rate making. Now, in preparing the income statement or balance sheet or notes for the shareholder, GAAP is very useful and is needed, is a basic. So if the commission is not bound by that, and if the fluctuations are as big as you just mentioned, then normalization is more appealing to me. So please convince me that you don't need normalization.
Sure, we don't need normalization because unlike other expenses we normalize, we don't need to look to the future in order to determine the best estimates. We don't need to look to the past in order to determine what the best estimates of the future will be in this instance. Unlike storms where you can't predict what's going to happen in the future, so you look to the past, here we have actuarial information. We have empirical scientific data which targets and pinpoints and looks at the data of employees in the pension funds and predicts when these employees might retire and how quickly they might retire. And so we would argue that using those actuarial tables that predict in the future what's going to happen is a better indicator for this particular expense than looking back and using the company's data for 3 years prior and normalizing it to look at the future. And that's been the position that I think this commission has taken in the past when it determined that actuarial forecasting was better than normalization for this particular expense.
This is another difficult issue as far as I'm concerned, but I guess I'm going to have to lean toward the company because I'm sort of trying to be consistent with respect to actuals or actuarial, and that the best method or the most just and reasonable method. And I have no real big problem with the normalization, but if I guess I have to pick, I'm going to 51% DPO on this issue. I don't know how anybody else feels. Mr. Gray?
I think I'll agree with you on this one, Mr. Chair, and specifically because I think it more relates, as council points out, to if it's employees, if it's retirements, if it's demographic information. they should have enough data and enough parameters behind the scenes to reach more actuarial decisions in this regard. So I would agree with the DPL position in this case.
I would agree. When I had read through everything, I was leaning toward the actuarial as well, and at this point, I'm going to stick with that. And I will make a motion to recommend rejecting the hearing examiner's finding.
I second the motion.
In agreement with the company.
And I'm sorry, I'm going to amend that. I'm going to reject the hearing examiner's recommendation and agree with the company.
Commissioner Korea, are you seconding?
I second the motion.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Number 9.
So, I'm not sure if we want to proceed in the same fashion on this one. Number 9, I think we're up to normalization of regulatory commission expense, correct?
Correct.
Okay, so in this one, the company proposed, like storm expense, like uncollectible expense, to normalize the regulatory commission expense over 3 years. In doing so, they've followed historical precedent. There's 2 components of this. There was the test period level of rate case expense, which got normalized over a 3-year period, which was done to account for the volatility of those expenses. And then there was also an element that reflected the test period costs of this filing, which were then amortized over 3 years. Importantly, no party opposed the normalization of the expenses over the 3-year period, and the hearing examiner recommended acceptance of the entire adjustment, including this component. The company does not take exception to this finding. I would note, as you've seen from your chart, the DPA proposed to cap some of the rate case expense for this case, for the cost of capital witness. That was rejected by the hearing examiner. The company agrees with that. DPA did not accept to that finding as well. So the only issue, I believe, that is sitting here has to do with staff's exception. And so I would submit that it might make sense to hear from Mr. Geddes on that, and then I can respond if necessary.
Mr. Geddes, actual expense,
Well,
$35,000 cap.
I think we've seen this movie before.
I think so.
And all we were trying to do was to capture the actual information that was known and available for the last quarter. So the differences between the forecast and the actual, we thought the actual was more probative, and that's why we made the adjustment. Thank you.
Ms. Schultz?
I understand where you're going based on this morning. I think that I still think that the company would take the position as we have here that we think the forecasts were appropriate. We think that the hearing examiner got this one right, and that his recommendation should be approved.
I don't think anyone's saying the forecast is not a good method or right. I think what we're saying is that the better one is the one suggested by staff in this particular circumstance. I also think the company has the burden of proof, so I'm not in favor of the $35,000 cap. I think that's part of the issue.
Ours is
Or not.
really, I'm sorry.
If it's not, then we don't have to worry about that.
No.
It's not.
Well, our issue is a simple one. As articulated on page 16 of the issue sheet. Specifically, we thought that the forecasted information for the last quarter with regard to non-base rate case expense should be based on actuals and not the company's forecast.
Okay, so that's the only issue then.
That's the only issue.
And I so move that we find in favor of that just Mr. Geddes just mentioned.
I second.
Any discussion? Hearing none, all in favor signify by saying aye.
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 Any opposed? Any abstentions? That motion carries. By the way, if people need a break at some point in time, please feel free to speak up, and then we'll come back at 10 minutes of 2. We're going to take a break right now.
We're coming back at 10 past 2 or 10 up?
Of two.
Oh, I was hoping 20 past 2, but that's okay. No, just,
Well, we want to get out of here before 5 o'clock. How's that?
all right.
And we want to try to finish today.
Yes, that is also agreed upon. 10 of 2, ladies and gentlemen. Is that where we are here for? Okay. Oh, absolutely.
I mean, according to mine, we're going cold, so that.
Oh, we got stuff already, huh? That's quick. He's got it already signed.
Yeah, right. First. Consent and the partial.
Oh, don't, careful now.
Oh, sorry,
This is the finish pile. It's very, very important.
You're gonna have to look through, make sure. Because I'm just making different files.
Thank you. Just, well, I didn't turn it off, no. Sure, try it again, what the heck? It seems like it might be a lost cause. I don't care what you do, to be honest with you.
Doesn't seem to be.
Okay.
That's what he meant.
One more time. This hasn't been signed by Harold, right? Harold got off and,
The conference center.
this has to be
Please enter
signed
your
by Harold.
moderator code or your participant code, followed by the pound sign.
Let's put it right on his computer.
Your passcode has been confirmed. Please wait while you are joined to the conference. You are the first caller to the conference. Please wait while others join. double checking the line.
Yes, we just unmuted.
Oh, okay, thank you.
Good, good. How are you, Commissioner Gray?
Trying to keep up.
Yep.
Got my traditional summer excursion to the Chesapeake done yesterday.
Oh, to do what? Go clamming?
No, I go rig a sailboat that doesn't have a motor. Take it out all day and sail it back to the pier.
Good for you.
Okay, one little mistake on my way back in. Got
Did you
to
hit something?
No, well, always go in and I can pull it right up to the pier. Hopped off as I was going to roll over around the beach. Wife is just
Oh, well, you'll appreciate this then, Chair. The reason, you know what I was coming here today, do you know where I was supposed to be today? At Oakmont.
Grabbed the
Oh,
rope.
my goodness.
Yeah.
I had to hop
I was
off.
supposed to
Still
be there
got a little
today
time.
and tomorrow,
Get
but
back to the pier.
that's okay. We'd much rather prefer to spend our time here.
You'll make it by tomorrow, I hope.
Yet another. So I did get her in the rope.
Yeah.
Pulled her
We'll
in.
see.
I said, I was waiting to see how well you would do, honey. So now,
Where is this? You say that it's somewhere in the Chesapeake?
yeah, I go to Annapolis.
Oh, okay.
I'm a graduate of the sailing school years and years ago. So I have to go to the charter as a 24.
I think my clients are interested.
This has a public action one day, but I have to read it,
We're here tomorrow, I'll be here tomorrow.
sail it away,
Are we signing this?
sail it back, and take off.
If that has to do with normalization of uncollectible expense, I don't think we should
Yeah,
sign
no
it.
motor. No, it has no motor.
Very nice touch.
I do it every year.
Too close to home.
Couldn't really get out back.
But is there gonna be an attachment to show what we did in this group, or?
How long have you been?
My wife is brave.
10 years in December.
Yeah, what'll happen is they'll sit down,
So the guy that used to represent me,
they'll sit down and figure out the revenue requirement, et cetera, et cetera, and that'll become part of it afterwards.
Okay, there'll be a settlement.
Not a settlement agreement, but
Steer around, steer.
an exhibit to the order.
So I come directly to the pier. And at the last possible minute, I do a steer. He works that right in.
oh, really?
Yeah, shortcut this next way.
Nice guy.
Good guy, yeah.
And if I had the rope in my hand and I jumped off to the deck, it would have been a perfect landing. I came home last night, I said, I felt a little rusty. She said, "Well, at least you got the rope. I couldn't see it was there because you wasn't on the side of the sail.
I forget what Mr. Watkins said on this.
You're back out on your own. And all that training over the years, it's been watching some of the movies.
There's an issue that the EPA has
A couple of years ago, I told her,
Yeah, yeah.
we ought to practice.
You have a better memory than I.
In my younger years, I could stay on the
Time out. Were you trying to get in here? Were you trying to talk to Commissioner Gray?
I do not remember.
Yeah, yeah, yeah.
So, I told her, practice rescue. I stood up on the side of the boat, back, you know, the jump over. Here's what she said, we're divorced. Yeah.
Were you
I'm lost
okay?
at sea.
All right, we're good, good. Oh.
Settlement.
I'm very excited.
Be pretty bad if we don't. Close now.
What did we just do? We just finished normalizing regulatory commission. Now we're on uncollectible.
I'm gonna ask Matt if it should be, Matt, should this be muted?
Yeah, that's a good point.
Yeah, okay.
Also, I like the P with P. It's not a
Right.
proposed, well, it's a promise.
It's not in my binder, so.
But, yeah.
Okay, but it doesn't, we're not going by my binder, we're going by this.
It looks like everyone's here. Mr. Watkins is here. And why don't we skip, give Ms. Schultz a little bit of a break and hear from Ms. Iori with respect to normalized uncollectible expense, 3 years versus 2 years.
Okay.
Please, go ahead.
I'm happy to lead off. Okay. I'll start out by saying that this is another item in which the DPA's proposal would provide the company with a greater cost of service amount than the company's proposal. The company normalized its uncollectible expense using expense levels from 2017, 2018, and 2019. But the DPA looked at those expenses and saw an anomaly in 2017 in that the 2017 expenses were abnormally low. In discovery, we learned that the abnormally low 2017 expense resulted from Delmarva's use of a different methodology to calculate uncollectible expense. In 2018, Delmarva changed its methodology to the Exelon loss factor approach. Using that loss factor approach results in higher estimates. And because Delmarva intends to continue to use the Exelon loss factor approach going forward, using the 2018 and 2019 results to normalize uncollectible expense will better reflect the level of expense that it is likely to incur going forward. So the DPA concluded that circumstances had changed sufficiently to abandon the 3-year normalization period for this expense in this case, because one of the 3 years included an expense level resulting from a calculation methodology that Delmarva wasn't going to use anymore. As we previously noted, courts allow agencies to change their positions as long as they rationally support their departure or support their reasons for the change, and the change in the calculation methodology that affected the 2017 amount warrants using just 2018 and 2019 to normalize this expense. Nevertheless, the hearing examiner recommended using the same 3-year normalization period that Delmarva proposed because Commission precedent was to use 3 years. A 3-year normalization period better smoothed out the volatility of the expense, and a 3-year normalization is a consistent recovery method for this expense. Now, that last explanation demonstrates a lack of understanding of what normalization is. Normalization is not a recovery method. It is a method of determining an appropriate expense level to include in the cost of service, which leads to determining a revenue requirement that the company will have the opportunity to earn. Moreover, smoothing out volatility is not the only reason to normalize expense. It's also intended to determine a more representative level of expense going forward for cost of service purposes. And there's no legal requirement that the Commission use the same normalization period for every expense. I should note that the DPA does not take any exception to the use of the Exelon loss factor approach. We think that that approach is reasonable. So because we think that our proposal more appropriately reflects the expense level that the company will incur going forward as a result of using the Exelon loss factor approach, we respectfully request the Commission to reject the hearing examiner's recommendation and adopt the DPA's position. Thank you.
Thank you. Mr. Geddes, no position by staff?
That is correct.
Ms. Schultz, would you just merely address the year 2017 and Ms. Iori's comments that it's an anomalous year and therefore we should change it to 2 years rather than 3?
Sure. I think the fact that 2017 was an anomalous year or that it used a different methodology isn't the relevant consideration here. The consideration is the fact that these expenses are volatile expenses, and as such, the Commission has decided that a 3-year period is as an appropriate time period as any other period over which the company should normalize them in order to best reflect an estimated best guess of what they might look like in the future. As the hearing examiner noted in his report, at least I'm happy she's an Eagles fan. I mean, we can at least share that.
I'm sorry, I thought I turned it off.
I think that what we need to look at here is that, you know, in past cases and what the hearing examiner cited, at least for, in partial support for continuing the 3-year precedent, is the fact that there have historically been expenses within the 3-year periods where one year has been lower than others. And that very well may happen in the future, regardless of which methodology is used. And so to us, it's not indicative simply that 2017 was an outlier year, as DPA might put it. What matters is we think 3 years is most appropriate. We think that the hearing examiner correctly credited Ms. McAvoy's testimony, where she made it pretty clear that this normalization is for purposes of volatility, but equally important is the company having some consistency when it is working through rate making and planning rate cases as to which periods of time are going to be considered by the commission for recovery of those expenses. So I actually think that it's really important, the last portion of the hearing examiner's comment, that it's a consistent means of recovery for the utility.
Thank you very much. Commissioners, questions?
Yeah, I would agree that it is a consistent means of recovery, indeed. However, in this case, and specific to this case, I have to agree with the DPA because of 2017 being using a different methodology, and the 2 years that we're looking at here, 2018 and 2019, used a different calculation that will be used going forward. In this case, I believe that we should reject the hearing examiner and accept the DPA's recommendation. And I will make that motion if there are no other questions.
I second the motion.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Are there any opposed?
One abstention, Mr. Chair.
One
here.
abstention. It's always a difficult person in the crowd, Ms. Schultz. And that's not Commissioner Gray, by the way.
I won't belabor the time to explain my abstention, but I'll have this conversation offline. Thank you.
Okay. Sounds like you're a normal person. Okay. These pages mixed up. Okay, next is Wage and Federal Insurance Contributions Act, the FICA expense. Gosh. I guess I got the word actual in my comments here somewhere, so. Okay, Ms. Schultz, go ahead.
Okay, so thank you very much. This one needs to be unpacked a little bit. So I'm going to talk about this largely in 3 buckets as we move forward. But this is necessary to understand why the hearing examiner's recommendation is erroneous. It's explained in detail in our exceptions, but this is basically what happened. The hearing examiner conflated concepts pertaining to this adjustment and to O&M expense matters. What he did goes outside the bounds of what any party recommended. He disallowed costs that no party objected to within this adjustment. And by removing the entire adjustment from Delmarva's revenue requirement, that was a decrease of $1.5 million worth of just and reasonable known costs. So let me explain that. Because while perhaps going forward in the next rate case, what we've all learned from this is we'll probably break this out into 3 different components, so it's abundantly clear what's being asked for and who's objecting to what. But there's 3 pieces. So I'm going to first start with what's out, okay? What really isn't a part of this adjustment at all. And this is where the hearing examiner actually got it right when he determined that staff's argument to replace test period wage and FICA expense levels shouldn't have been dealt with in this adjustment, and so he didn't talk about it here. And he also correctly determined, for the same reason, that DPA's argument about wages and salaries being capped at 2.7% also wasn't relevant in the context of that adjustment, because again, that goes to test period expense levels, of wage and salary and what's included in the test period O&M per books, if you will, company numbers. So let's go then to what's in. Here's where we have the three components. Component number one, adjustments that the company made to the 9+3 or test period O&M wage and FICA level. The first thing they did, they took two of the increases and they annualized them to make them reflective of what happened during the rate effective period. Why did they pick two? Because two of the rate increases happened during the test period. Okay, so two of the 6 increases at issue in this adjustment occurred on March 1st of 2020. And so the company adjusted the base O&M amount for wages and salary to reflect these increases as if they had been there the whole 12 months, because they knew they were going to be in place for the rate effective period, the next 12 months. No question about it. No party objected to this. No party raised an issue with respect to this annualization. This annualization of those two increases is worth about $800,000 of the $1.5 million that was excluded entirely by the hearing examiner. Second, bucket number 2. There's adjustments for 4 more increases. These are all post-test period, okay? They're known and measurable, but these are also in 2 buckets, if you will, union and non-union. That's how I'll break them up for purposes of the conversation. These represent about the other $700,000 of the $1.5 million. Now let's talk about where the parties stand with respect to those particular increases. So staff opposed only one, the non-union management increase in March of 2021. And they did so on the basis that it was not known or measurable or reasonably likely to occur. The company disagrees with that. Based on Mr. McGowan's testimony, he testified that the non-union management increase was going to go into effect. The board had voted to put it into effect, albeit it was going to be at a 2.0% and not the 2.36 that was estimated. But, case in point, it was not reasonably unlikely to occur because it was in fact occurring, and that's what he testified to during the evidentiary hearing in February. DPA opposed all 4 of the post-test period increases, not just the one, and that was based on the age-old position that they're out of period and they shouldn't be allowed. It's the same argument that time after time has not carried the day or held any weight with this commission, which has historically allowed these wage and FICA post-test period adjustments so long as the expenses are known and measurable and not merely estimated without support. All of the contractual increases for the unions were put in place, the last one being implemented in June of 2021, and each contractually required increase was coupled with evidence from company witness Barcia presented regarding the renewals of those union contracts, which would have required those increases to occur annually during the rate effective period and for some period of time thereafter. This is different than docket number 13115, where the commission disallowed them because there wasn't evidence of union contracts and they thought the numbers were estimated and not real. Not so here. These are real numbers. They actually took place. They are in effect today. They were in effect. There's been no indication in this case, unlike 13115, that the company is going to be filing annual rate cases, which was another basis upon which the commission said no to post-test period increases such as these, only in the last case when they had consistently previously included them. And on that point, I would note that historically the commission has approved post-test period increases where they are known and measurable. Docket 9120, 09414, 05304. In summary, DPA's argument that because they are post-test period, they're not reasonable doesn't hold water. It conflicts with the MFRs that expressly allow adjustments for known and measurable changes to test period expenses. It's routinely been rejected out of hand for the commission for that very reason. We're then left with staff's opposition, which would remove only one of the 6 increases, the one post-test period non-union increase. And if the hearing examiner were persuaded by staff's argument, which he doesn't say, then the appropriate result would have been to disallow that one increase, which is worth approximately $320,000 in the revenue requirement. And so on the basis of the overwhelming record evidence in this case, the MFRs and the commission precedent, the company's adjustment should be approved and the hearing examiner's recommendation should be rejected.
Thank you, Ms. Schultz. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. Delmarva included wage and FICA increases extending out to July 2021, more than a year after the end of its already partially projected test period. The DPA rejected this adjustment and limited it to actual wage increases that became effective during the test period, annualized. Now, the hearing examiner accepted the DPA's position. In docket 13115, which you've heard much about from Delmarva, they left out the part where the commission expressed concern about including increases in expense items occurring long after the test period ended without a corresponding adjustment to include revenues that would be earned after the test period ended. The commission said, "We do not believe that the relationship between historical revenue, investment, and expenses should be adjusted solely for estimates of future expenses." Now, the hearing examiner didn't address this point in his recommendations, but it should be noted that in the previous cases in which the commission did allow post-test period wage and FICA increases, the company used an historic test period. But again, here, it's used a partially projected test period. Thus, the expense level included in the company's initial filing already included a projected payroll expense level. Allowing the company to extend the adjustment as far out as it does essentially results in a fully forecasted test period for this expense, and the MFRs do not provide for fully forecasted test periods. Now, Delmarva claims that its proposed adjustments are known and measurable, but Delmarva's own witness admitted that they're speculative. When we asked him during the evidentiary hearing how many union and non-union employees Delmarva would have in March 2021 and June 2021, he didn't know. And he said, quote, "I don't want to speculate as far as an estimate," end quote. That's from the transcript at pages 1378, 1379. Employees retire or resign. Sometimes they're not replaced. And if they are replaced, it isn't always with someone with the same level of experience. And that's why it's important to match the time periods being used for adjustments. Going out as far into the future as Delmarva does, for adjustments that increase expenses, but not doing the same for revenue adjustments, skews the regulatory calculus. In fact, while the company went out more than a year for this adjustment, it didn't even use the actual numbers it had for residential customers and revenues. Instead, it used a forecast that understated the number of residential customers it had in April 2019, the beginning of the test period for which it actually had an actual customer count. Now, the company apparently believes that the hearing examiner rejected its entire adjustment, which included the annualization of test period increases. That wasn't how we read his recommendation, but if that is in fact what he did, then we agree with Delmarva that his recommendation should be modified to annualize the wage and FICA increases that occurred during the test period. Otherwise, we respectfully submit that his recommendation should be accepted. Thank you.
Thank you, Ms. Iori. Mr. Geddes.
Mr. Chairman, members of the commission, there are actually two issues here, at least from staff's perspective. I'll deal with the second one first, because that's what counsel for Delmarva and also Ms. Iori dealt with, and that's the issue about speculative wage increases. I do think it's a little rich that we're going out into June of 2021 to pick up a wage increase, which, if I understood counsel's argument correctly, was estimated at 2.36, but in February was reduced to 2.0, which sort of indicates that it was a little speculative. Without, picking up the other elements of the rate-making calculus. You can't go all the way out there. I mean, I don't think the commission has done that with anything. I might be wrong on a wage increase, but I don't remember the commission reaching out 15 months, 14 months beyond, it's my bad, I'm sorry, 14 months beyond a test period to capture a single union contract or a increase. I think that's pretty rare, but I'm sure I can be corrected on that. But the issue that was missed, and perhaps it was because we've dealt with it before, is the staff's correction to FICA information for January through March 2020. Because what staff did was they took the forecasted information and corrected it for actual information. So we think it's appropriate to at least make that adjustment as well, assuming you're not enamored with the hearing examiner's report. So there are two adjustments for us with regard to this issue. Two adjustments for us. One is to basically use actual information for the period January through March 2020. And the other adjustment is to remove the speculative wage increase, which council identified about $300,000, which occurs in March 2021, which we think is way beyond the test period.
June 21?
Well, there was a comment about the effective date. I might be helped with regard to that, but my understanding was the one that staff objected to was going to occur in March of 2021.
Ms. Schultz?
Mr. Geddes is correct. The sole adjustment that staff objected to was the contractual wage increase that was the March 2021 non-union increase. They did not have a problem with the June 2021 union increase.
Yeah, because it was
So
not.
that's 11 months after the test year.
It wasn't a contractual increase. That's why we had a problem with it, speculative.
Was I mistaken in saying that there's a union contract maybe at 621?
So there is a union contractual wage increase of 2.5% for Local 1307, effective in June of 2021 for 4 months.
Okay.
And if I may?
You may.
Okay. So the one, following up on the most recent point, the 12 and 0, you'll recall at the outset of my discussion, I said that's out of the bucket. That 12 and 0, the reason I didn't address it here is, and the reason the hearing examiner didn't address it here is because it's dealt with on the O&M side. The 12 and 0 update on the O&M is where staff's argument about 12 and 0 on wage and FICA belongs. So it's not a part of this adjustment, which deals strictly with annualization of the two increases, which took place in March of 2020, with which you just heard DPA agree, and the post-test period increases. Those don't relate to the 12 and 0. And with respect to the test periods, whether or not Delmarva has historically used a historic test period or a forecasted test period or the test period used today, the fact remains that Delmarva is able to use the test periods that the MFRs allow them to choose. And at least in my review of all the orders and all the precedent on this issue, it has not been a central tenet or a controlling comment about why the decision was made one way or the other as to whether it was historic. And with respect to the revenue offset component, it is something that the commission mentioned in 13115, but as we addressed here, the company doesn't think that that's a necessary consideration here because wages are not an expense that is driven by revenue. We need the employees to do the work, and they're not generating revenue. They're simply doing the work. And so that's why we don't think it's appropriate to consider a revenue offset as a basis for disallowing these costs. Finally, I think it's important, looking back at the precedent here, for the types of increases that have historically and routinely been allowed, they are the same as those are requesting here. Specifically, in docket 05304, the commission unanimously allowed the company's post-test period union and non-union wage increases, agreeing with the hearing examiner that they were reasonably known and measurable, and noting that 5 of the increases were encompassed in existing union contracts, and that 1 of the non-union increases had already taken effect. We have the same facts here. We have union contract increases, all of which have taken effect. We have a non-union management increase that took effect in March, and we have a non-union of 2020, and one that took effect in 2022, albeit at a different number than what was estimated. Finally, I would again, and this one comes straight from 13115, remind the commission that the commission has historically said, and I quote, "We are sympathetic to the position that several of the increases take place far outside the selected test period. However, this seems to be one of those adjustments that Delmarva Power decision would require us to consider in determining the cost of service. The wage increases at issue here are reasonably known and measurable, and their inclusion in the cost of service is more representative of the period during which rates set here will be in effect." And this is, I apologize, I misstated. It's not 13115, it is 09414. So apologies. But this is the wage and FICA determination in that case. And so I think that that is what the commission needs to be concerned with here. I think the hearing examiner's recommendation should be rejected for all of these reasons, and because the rates that the company has proposed more accurately reflect the costs that Delmarva will incur in the future to provide these benefits to customers.
Point of clarification, because I think, listening to this, I think if you're not confused, at least I am. Staff had 2 points. First one was the last quarter of the test period and making the FICA based on actuals versus forecasts. That may be assumed in the 12-0, as Counsel for Delmarva alluded to. And if it is, we'll sort that out, because of course we didn't know you were going to make that decision before this was, before you. So that may just go away, that issue. The second one, still for staff, is there, and that is March 2021 request for a speculative contract increase, not subject to a contract, not a union, but it was just thrown out there as a potential increase, not based on any documentation. So I do think that that's outside some of the cases that Ms. Schultz cited to you, and we would ask that you not allow that wage increase dated March 2021. Thank you.
Yeah, that was my question. I don't remember, but it seems to me that we've gone out 6 months. Once you get past 6 months, I can't remember anybody going a year out. Maybe Ms. Schultz could tell us those previous cases.
No, they have.
Have you really?
But under contract.
Over my vociferous objections, but you have.
But
No, I
it
do
was
ask.
subject to
I just
contract.
don't remember.
Contract.
No, I think.
Yes.
More than.
I think they have been out well, and they've been out, I believe, and I don't want to misstate it, but I believe we've seen them in at least 11, 12 months. But we had it in one of our briefs, see if I can find it for you, but they have been beyond 6.
No, I think everyone agrees that my recollection's not correct. Commissioners,
Chairman Winslow, may I make one very short comment?
absolutely.
Thank you. Delmarva seems to suggest that whether the test period is historic or partially projected is immaterial because the MFRs allow Delmarva to use a partially projected test period. And that's true, it does. The point that we are making with using a partially projected test period is that partially projected necessarily already includes projections, and it already goes out beyond what a company has already experienced. So while we don't dispute their ability to use a partially projected test period, basically what you're doing here by going out, and in this case it's more than a year past the end of the test period, is basically giving them a fully forecasted test period. And the MFRs do not allow that. Thank you.
If I may just briefly respond to that point.
Yes, please.
So Ms. Iori's correct that the MFRs allow us to choose our test period, but she's incorrect when she says that the MFRs don't also allow us to do exactly what we've done here, because the MFRs separately allow the utility to adjust the test period, which presumably the MFRs know can be partially forecasted for known and measurable changes up through the filing of rebuttal. So if the commission wants to take the stance that that's inappropriate, and Ms. Iori's argument is correct, that we shouldn't be able to create such a forecasted test period or post-test period expenditures, then the way to do that is not through a case like this. The way to do that is to change the MFRs so that there is no ability to update for the known and measurable past the end of the test period, which would require utilities to then select different test periods, or to have the MFRs require utilities to select different test periods. And in the MFRs say, hey, we, the commission, have said, we don't think it's a good idea to have partially forecasted beyond such and such a time. That can be done, but this is not the way to do it, and certainly not through this adjustment.
Commissioners? Commissioner Gray?
Thank you, Mr. Chair. So I have one question. Are the real adjustment numbers both known and equivalent to the estimated adjustment numbers used in the partially projected test period posting? I note you mentioned known and measurable. I'm interested
Yes.
if they're known and equivalent.
They are, save for one. And that is the one that staff takes objection to as being speculative and in the future. That is the March 2021 update. And in that regard, that was projected to be 2.36%. It is actual at 2%. And so if the commission wanted to stick with the theme today of replacing estimates with actuals, then the appropriate course would be to allow the known and measurable impacts that have taken place, all of the wage adjustments with which staff takes no objection, and to simply replace the 2.3 with the 2.0 for that single loan increase.
May I ask as a follow-up, Mr. Geddes, your reaction to that proposal?
I was once told in a jury trial, you have to learn to control your facial expressions. I'm afraid I'm in that pit again. I would disagree respectfully because it wasn't known during the test period, and it wasn't known, if I understand correctly, until recently, and it was a different number. So known and measurable, I don't think that standard applies to this particular contract. I mean, it was speculation. We don't know. And as the council said, it was a different number. So we're going to take a test period, go out a year, and adjust it for something that was not known and measurable that became known and measurable after the hearings. I don't think, well, excuse me. I would propose that the commission not do that. Thank you.
Thank you, Mr. Geddes. No further questions, Mr. Chair.
Mr. O'Brien, do you want to say something?
Well, at the risk of ruining my my history here of not having to speak as of today, I don't want to open the floodgates with this one comment. And the parties, of course, can correct me if I'm wrong, but as your legal counsel, I would caution against relying on the MFRs to allow for an adjustment beyond the filing of rebuttal testimony. My recollection of the filings are that rebuttal testimony came in October 2020. I've heard some reliance on the MFR to allow for this adjustment beyond rebuttal testimony. Now, I think from a legal perspective, there are reasons you might want to go beyond rebuttal testimony, but I would not want to be in the position of writing your decision or supporting your decision on appeal if your reliance is simply on the MFRs, because that was October 2020, and these adjustments came in well after that.
Thank you, Mr. O'Brien.
And if I may, just for sake of clarifying in light of that commentary, just so that I think we're all on the same page with what's where and what the numbers are, but what I've discerned from the argument just now is DPA, staff, and the company are all aligned that the annualization of the 2 test period increases should be included. That was in this adjustment, and that component of the 1.5 million, which I've stated is roughly 800,000, should be included. The hearing examiner got it wrong for that bucket A. What I've also heard is that staff and the company continue to be aligned on the post-test period contractual union increases. Those are known and measurable in that they are based on union contracts. The evidence shows those contracts have been ratified. The increases have already taken place.
Your Honor,
And-
I'm Chairman Winslow, I'm going to object at this point. This is going far behind just summarizing where we are, and it's just additional argument.
Well, I agree with every word you said, and I'd like to hear it if we could, and I'd like to hear if you have something to say. I just want to see if, the commission, I think, is sort of struggling on this issue a little bit, and so the input is appreciated. So if you have additional input, we'd like to listen to you as well. Yes, ma'am, go ahead.
So I think you have, at least what I've heard today is that staff and the company are aligned with respect to those union contracts. And those represent 3 of the remaining post-test period. The 4th is the outlier with respect to the argument today, and the 4th is the one to which I just heard your counsel discuss with you, and that is the March 2021 non-union wage increase, because that increase was not in place prior to rebuttal testimony. It's different than the union increases, which, while some may not have been in place, they certainly were known, measurable, guaranteed, required, contractual. And it's under that basis that historically the commission has allowed those increases. And so if you were so inclined, at least one way I see as a possible resolution here is reject the hearing examiner's recommendation on this issue, adopt the company's position on bucket A, the annualization, that's not contested. Adopt the position of the company and staff that post-test period contractual increases should be permitted because they're known and measurable. And if you're so inclined, reject the company's position on the single non-union management increase. And that one is, as I mentioned earlier, about $320,000 of the overall adjustment. That's just my summary. There was some argument in there, but I was trying to help provide some clarity so that the commissioners could make an informed decision.
Ms. Iori.
Thank you, Chairman Winslow. I'm not going to repeat anything I've already said. I would simply point out that if we're going to go well past a year, past the end of the test period for this particular adjustment, perhaps we should also adjust revenues. Delmarva's customers are growing at the rate of about 1% a year, so an appropriate adjustment out to where the end of revenues out to that same point in 2021 would be about 2.45 million.
I'm going to object entirely to just that statement. That's introducing evidence that we've not had. There is no evidence in the record as to what the companies would be or should be that far into the
Your
future.
Honor, she
And
doesn't understand
that's
sarcasm, apparently.
okay. Well, then it's inappropriate, Ms. Iori.
I didn't
Well-
even-
Okay, that is,
Well, as the tempers are getting a little warmer, I will just say I believe that you understand staff's position with regard to the 2 adjustments that it tried to make with regard to this issue. Thank you.
yes, sir, thank you. Okay, well, as I said, I guess we're all struggling a little bit, and a lot of good discussion, so I appreciate that. Anybody have any comments? I'm inclined to go with bucket A, B, and I'm inclined to go with staff's basic premise, which is not opposing 3 or 4.
Delmarva's counsel has accurately stated our position, and I believe conceded the last one.
well, I don't think they conceded anything, but they gave that as a possible resolution, which of
Excuse
course
me,
we
better
recognized.
phrased.
Of course, we recognized already, but, so I'll put that on the table then to see what my fellow commissioners have to say. I move that we do buckets A and B and leave off the outlier, which is a 621 non-union.
The March 1, 2021 non-union management increase.
Okay, that one. So that would have, it would reverse the hearing examiner and approve 3 of the 4 as were stated. If there's no second, we can try another.
Question on a point of clarification, Mr. Chair,
Absolutely.
please. It looks here, as I read from staff, the request that's January 2020 through March 2020 forecasted wages be replaced with actuals. Is that a part of your motion, or?
That's a very good question. I would like that part of the motion as well. I think that what Mr. Geddes argued was that there are actuals that are available for January through March of 2020.
Right.
And I think that should be included as part of the, that's included as part of the motion.
To the extent, in fairness to council, they are not included in what she refers to as the 12 and 0. Because remember,
Yes.
the O and M has been adjusted by 3 million. And the issue is whether this particular sub-issue, if you will, the 900,000 associated with the actuals between January and March is included in that number or not. And I can't tell you today, but I think council may be right, it may be in that number.
In which case, the parties will inform us, as part of the workup after all the decisions are made, you will come forth with that and make it part of the, right? And then we-
Yes, that's a fair representation. We're just concerned that it not be double counted by
Right.
being expressly included here and what we believe it to be included there.
Okay. So was that a second, Commissioner Gray?
Mr. Chair, I'm not sure what the wording really is for the motion.
Okay,
I'm inclined
so-
to agree with you, however, but if we could clarify the wording, it would certainly make me feel much better.
Can I draft that?
Okay, so number one, the motion is that the 3 months be actual, not forecasted. You've got those figures, were actuals. And then all but the March 21 contracts will be included, and the March 21 will be excluded as the outlier.
And I'm sorry, I'm not trying to interrupt you, but just to be clear, there are 2 March 2021s, so just to be clear, we're talking about the non-union
Non-union.
management.
Right.
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 On that basis, Mr. Chair, I'll second your motion.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Aye, aye, aye.
Any opposed? And any abstentions? We have one person who's absent. Normalization of storm restoration expense.
So this one, again, is one of the ones that was erroneously still in the chart. There were actually no exceptions taken to the hearing examiner's recommendation on this issue by DPA, and it was not contested by staff. So, I mean, we can certainly, I mean, the company's position obviously is that the hearing examiner's recommendation should be adopted.
Well, okay, everyone, do you want us to vote on that?
Sure.
Okay, let's do that then.
We can do it as a cleanup because there are several other uncontested adjustments. And usually what we do at the end is just have a motion to accept accept the uncontested adjustments.
So number
The
21 will
numbers
be our
that fall out
first,
of them.
so number 21 will be our first uncontested adjustment.
21, sorry.
I believe it'd be our second.
Second.
The
Okay.
first
The first
being
one is
the actual revenues,
forecasted
customer count.
revenues.
Number 10, isn't it? Yeah, he said adjustment.
Right.
Oh, yeah, no, not that.
We accept the hearing examiner's report, subject to clarification.
So someone, Madam Secretary, someone keep track of those for our last vote.
All right,
Yeah, it's
Could
an
I-
uncontested adjustments.
could I just interrupt?
Oh,
The way historically I conferred with Ms. Iori, so I know this is correct, is that, on some things we agree, that historically the commission has, one way to go through this imbroglio is to adopt the hearing examiner's report, subject to the modifications, the adjustments, and further clarifications that the commission has made during this meeting. That way you pick up all the uncontested, you pick up your changes as you went along, rather one or two, and the only thing that then really has to be articulated are the positions that you've made here today by your votes.
Okay. So I believe that we're on page number 25, adjustment number 21, reflection of 5-year average inflation on non-labor O&M expense.
that comports with my understanding as well, so I'll proceed there. So for this adjustment, the company requested a 1.03% general inflation adjustment to its test period non-labor O&M expense. And this percentage was based on the 5-year average inflation factor, or more commonly known as the CPI, for the Philadelphia, Wilmington, and Camden area. The hearing examiner recommended that this adjustment should be disallowed, agreeing with staff and the DPA that such an adjustment was never allowed by the commission before. However, the evidence in this case shows that the commission has allowed inflation adjustments in the past for specific expenses, albeit this one is more broad than that, but there is not a blanket policy against inflation adjustments. They have been given in the past, as I said, and where they were not allowed, for example, most recently in docket 13115, the company sought an inflation adjustment for its medical and dental expense. The reasoning, therefore, was because the CPI that the company had used then was not locally based. And so in this case, with this non-labor O&M expense inflation adjustment, the company remedied what it saw to be the fatal flaw in the last case and based the CPI for these expenses on the Philadelphia, Wilmington, and Camden area. And so it's the company's position that the hearing examiner's recommendation should be rejected and that this adjustment should be approved, as implementing this adjustment to the test period level of expense will be more reflective of costs in the rate effective period.
Ms. Iori?
Thank you, Chairman Winslow and Commissioners. The Commission has consistently rejected a general non-labor O&M inflation adjustment over the years. We thought this was so well established that utilities had stopped even asking for them. It's been 25 years since the utility asked for a general inflation adjustment, but the company asks for one here, claiming changed circumstances warrant it. No facts and circumstances have changed, and the company's attempt to manufacture changed facts and circumstances is unavailing. The passage of time by itself is not a changed fact or circumstances, nor is the fact that the commission gave the company an inflation adjustment for medical, dental, and vision expenses in a previous case. In that regard, we note that the commission reversed itself on the inflation adjustment in the Delmarva's next litigated case. The commission should maintain its policy of rejecting general inflation adjustments. The truth is that nothing has changed to warrant abandoning this longstanding policy. As the commission observed, allowing a general inflation adjustment would institutionalize inflation and remove an incentive for the utility to control expenses. That longstanding policy is even more relevant now. This adjustment is worth $600,000. Delawareans continue to suffer severe economic effects from the pandemic. Many of the company's customers have lost their jobs, and small businesses that have had to comply with social distancing requirements fight to stay alive. The commission has in the past considered the effect of utility requests on ratepayers in times of economic hardship. We suspect this provides even greater justification to reject Delmarva's adjustment here. We respectfully submit request the commission to reaffirm its longstanding policy of rejecting general inflation adjustments and accept the hearing examiner's recommendation. Thank you.
Thank you, Ms. Iori. Mr. Geddes?
Mr. Chairman, members of the commission, could I have the next slide from that? It'll be the one after that, and that one. Thank you. As Ms. Iori indicated, it's been a long time since the company has granted a general inflation adjustment. And I believe, and again, this was in her brief, not mine, referring to the old Suburban case in 1987, where the commission was pretty clear what it thought about inflation adjustments in general, and specifically stating that, and I don't think I wrote this, the company's adjustment is pure speculation, since previously in its filing it had specific adjustments for known and measurable changes. This inflation adjustment is clearly not something that's known and measurable and is a forecast. And we can debate about whether it's high or low, but it's definitely a forecast. It is not an actual number, and we have gone through this before with other issues. So staff supports the hearing examiner's resolution of this issue, and we would request that you affirm his decision on this point. Thank you.
Thank you, Mr. Geddes. Commissioners, any questions?
I do,
Mr. Gray?
yes, I do. I note that by heading, it's non-labor O&M. Could you please just briefly describe what's non-labor in this
It just
context?
doesn't have to do with wages and salaries and labor expense.
Well, I know what it, yeah, I know that's the negative
So
side.
it's all the
I was-
other expenses in the O&M categories, just not the labor expense itself. So
Okay.
we just dealt with
Co-
wage and FICA and those
Cost of goods and
costs.
services, for
This is
example.
cost of goods and services. Think of it that way.
Mr. Chair, I'm inclined to agree with the hearing examiner and so move to adopt his recommendation on this point.
I second.
It's, I'm going to vote for the motion, but I have to confess that after listening to all the fears about inflation in the last couple of weeks, and knowing that the CPI is probably meets the standard of, accuracy that I would probably approve of, but I think because of the previous precedent, and I'm going to vote and support the motion. So, if there's no further discussion, all those in favor signify by saying aye.
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 Any opposition and any abstentions? And one absent. The motion carries. Okay, number 23 on page 27, Delaware additional subtraction modification.
Okay, that's me, I'm up again.
Okay.
Here we go. So I would note first that the hearing examiner recommended a different amortization period than the company recommended, and also a different amortization period than the DPA recommended. The staff did not take a position on this issue, and DPA did not accept to the hearing examiner's recommended length of the amortization period. So, I want to explain to you what this adjustment is for, because I think that dictates the reasonableness of the company's proposed amortization period, which is 32 years. So the company proposed this adjustment to flow back future tax benefits that it will receive when it retires assets that give rise to those benefits. So this tax benefit is arising out of a Maryland tax issue that Exelon and Delmarva lobbied for a long time, finally got the treatment that they wanted, and it will ultimately result in $6.6 million of tax savings to Delmarva as allocated to Delmarva, Delaware. But those tax savings won't be realized by the company until each individual asset is retired. And so what the company did here was they said, well, we're going to make a proposal whereby we put this in a regulatory asset, and we propose to distribute it to customers over a period of years. What period of years should we choose? We're going to go with 32 years. Why? Because that's the period of time that most likely reflects how long it's going to take us to realize those savings. Because the assets that will drive the tax savings have a remaining useful book value life of 32 years. And so that's where this comes from. The DPA argued that these savings should be flowed back over the same period of time as the cash tax benefit that the company received under the Tax Cuts and Jobs Act. But the company's position, and I think the hearing examiner also realized, is that that wasn't a reasonable position because those tax savings were in the company's pocket. And so that was a settled, determined amount of time that those tax savings would be flowed back to customers from a different case. These tax savings are not in the company's pocket right now. They will be realized at some future time, more than likely over the course of 32 years. And so that's the period of time that the company believes is the most reasonable period of time. And so the company would ask that you reject the hearing examiner's recommendation for a 19-year period and instead adopt its proposal.
Thank you, Ms. Schultz. Ms. Iring?
Thank you, Chairman, Chairman Winslow and Commissioners. This isn't a regulatory asset, it's a regulatory liability. And the difference is that regulatory liabilities are monies that are due back to customers. Now, Delmarva is correct that the hearing examiner recommended an amortization back to ratepayers that was shorter than Delmarva wanted and longer than the DPA wanted. The Delmarva extrapolates from that to say that the hearing examiner found that the DPA's recommendation wasn't a reasonable position. But that is an inaccurate description of what the hearing examiner actually found. In paragraph 196, the hearing examiner said that he found both Delmarva's and the DPA's arguments in support of their recommendations equally persuasive. So he split the baby. We're okay with that. We'd rather it be shorter, but 19 years is better than 32. Now, Delmarva claims there is no evidence in the record to support this recommendation, but there is. And you recall, the commission is required to support its decision with substantial evidence. Substantial evidence does not mean a preponderance of the evidence. It has to be more than a scintilla, but it's less than a preponderance. So the record in this case supports anywhere from a 6-year amortization period, supported by the DPA, to a 32-year amortization period supported by the company. Delmarva's affinity for the matching principle here is curious, given its almost complete indifference to that principle in other areas of this case. But in any event, the matching principle actually supports the DPA's original 6-year amortization proposal because ratepayers have already paid for the assets that gave rise to the regulatory liability. Amortizing it over 32 years means that the ratepayers that paid for the asset will not be the same ratepayers that will get the benefit of the tax break. Additionally, Delmarva's proposal is inconsistent with the 6-year amortization that it proposed for the FISCO, that's PHISCO, deficient deferred income taxes, which is a regulatory asset. Regulatory assets are paid back to the company. Now, both the regulatory liability and the regulatory asset arise from changes in tax policy. Whether it is a state or federal tax is immaterial. And Delmarva itself acknowledged that the DPA's originally recommended 6-year amortization period was based on the amortization periods the commission approved for non-protected property-related EDIT and non-property-related EDIT balances. So we believe the hearing examiner's decision is supported by substantial evidence, and we respectfully submit that it should be accepted. Thank you.
Mr. Geddes. So now we're at 19 years and 32 years, right? And by the way, I expect you to be around
Yes.
for the whole 32 years.
I'm sorry?
Did you get it?
Your Honor, are you finished with your colloquy with Ms. Iori?
Yeah,
I
I'm
just-
sorry,
I want to make sure I don't get into 25
apologize.
years or somewhere in between. Staff, fortunately for you, did not take a position, so you don't have to hear from me on this particular
Okay,
issue.
thank you. Commissioners? Ms. Schultz, I'm sorry, you had something to say in
I
response?
was going to thank Ms. Irie for correcting me. She's right. It's a liability, not an asset. But I think the important point to hit is that all of the 6-year timeframes that were referenced were all approved by the commission, but in a settlement. So it was not based upon the commission's determination after reviewing competing positions. It was based upon a proposed settlement. And these, while I think the matching principle is important, and yes, it is a rate-making principle that we strive to get to when we can, I think in cases such as this, yes, you're going to have customers who might pay for an asset on day one who will not be around when it retires, 75 years. Maybe they've moved, maybe they've passed on. So, I don't think that's a compelling reason in this case to not go with the book lives of these assets with respect to tax savings that will not be realized until those assets are sold or retired.
She wants you to pay the money back 26 years earlier than you get it, right?
Right.
One question, Mr. Chair, please.
Certainly.
I may get this wrong, but over what period of time does the utility get paid back for a regulatory asset?
That depends on the regulatory asset.
Is there a range estimate?
No, because, for example, in this case, as I've just said, the assets that have been cited to you are assets where the time period was determined based upon contested positions in a rate case and then an agreement between the parties.
So you could ideally have 32 years for which the utility will wait to be paid back for a regulatory asset?
You could in the appropriate circumstance.
Okay, fair enough. Thank you. No further questions, Mr. Chair.
Ms. Iori, can Mr. Watkins tell us why Delmarva Power and Light should pay back the money 26 years early?
Well, we're not. We agreed with the hearing examiner, which is 19 years.
Oh, 19 years, excuse me, so that'd be 13 years early, wouldn't it? In other words, they're not getting the money until they file their tax return, claim the deduction, and get the refund.
It's a question of intergenerational equity. The ratepayers that have paid for the assets that are giving rise to this will not be the same ratepayers that will be getting paid back over 32 years. Intergenerational equity or inequity is a well-recognized concept in rate making, and is, that is a concept that has guided commission decisions in the past.
I agree. Come on, Mr. Watkins, please speak up. This is if your counsel lets you.
Sure.
We always love hearing from Mr. Watkins.
The truth be known, Your Honors, because it's a liability, it's deducted from rate base. So to the extent that there's a longer amortization, that means ratepayers will be receiving the benefit through rate base. And to the extent it's shorter, they'll be receiving the benefit of a faster amortization. During the evidentiary hearings on the witness stand, I said there is no right or wrong answer necessarily, and 19 years is a fair compromise. That was my opinion. The company may not agree, but definitely doesn't agree with it. But the truth be known, there is no right or wrong answer necessarily. It's somewhere in between, if you will. Ratepayers receive benefit one way, the company gets benefits another way, and vice versa, because of the way that the amortization and the offset to rate base works, if that makes sense.
Mr. Chair, if the amortization is allowed by the tax authorities, maybe we should train them in intergenerational fairness. What I would do is make a motion that we go with the hearing examiner's recommendation of 19 years, which seems to have been a compromise between the parties.
I second the motion.
Well, did you say that was a compromise between the parties?
I think I heard the DPA say that the hearing examiner had
I
established 19 years as a compromise between 32 and 6 years.
Yes, the hearing examiner established it. The parties did not compromise on that because Delmarva's still objecting. The
Okay.
DPA has accepted the hearing examiner's proposal.
Yes,
Or
that's what I meant to articulate, Mr. Chair. If I got it wrong, I apologize.
Is there any discussion on the motion? Is there, first of all, is there a second?
Yes.
I
Okay,
second
Commissioner
that.
Creasy, okay. Is there any discussion on the motion? I don't like the fact that, I already expressed myself, I want the money to go back when the company gets the money. And I understand the intergenerational thing, but when they set up the amortization for a piece of plant, you know, that lifetime of that, they're gonna obviously write it off as quickly as they can, but it's still gonna be, I think, substantially in excess of 6 years if it's a substation or something.
We're not looking at 6 years anymore. It's 19 or 32.
And the difference is 300,000 a year or 200,000 a year, when you break it down between 19, I believe, and 32. Did I do the math right? So we're talking about a $100,000 difference per year for, it's 6 million over 32 versus 19.
Yeah, hold on a second. Just that we're,
Okay,
We need a slide.
okay, I have no more discussion. Everybody want to vote now? All those in favor signify by saying aye.
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 Are there any noes? No, there's no noes. And one person who's absent. So 19 years it's going to be. That case will go down in history. Mr. Geddes will be talking about that in the halls of justice for years.
I may still be around.
You should be. Okay, we have,
Landed a puck over my head.
I believe next on page 29 is modification of excess deferred income tax, famous EDIT balances. And I guess, do we have Ms. Schultz again? Okay.
okay. So, with this particular issue, which is not an adjustment to the per books expenses anymore, we're in a different realm at this point. What the company is requesting in this case is simply to modify the amount to be returned to customers as a result of the cash benefits received from the TCJA. So, Chair Winslow, to the point you just made, the company is seeking to align the tax benefits that it actually received and to flow that back to customers apart from the estimated amounts that were included in the settlement agreement when that was done in 2017 or 2018 out of the 170977 case. Staff claimed that the company should not be permitted to do so and that it was bound by the estimates in the settlement agreement. The DPA did not take a position on this issue. I would note that DPA was a party to that settlement agreement, yet did not oppose the company's request to flow back the actual amounts in this case. The hearing examiner recommended that the company should be allowed to update its balances because he felt as though a reading of the language in the settlement agreement and the evidence presented by the company was that it was always the intention of the parties to return only what the company received, no more, no less. And just to be clear, the company has not changed the amounts that it's currently providing. It currently is providing to customers what it is required to provide pursuant to the amounts in the agreement. It is specifically asking this commission to adopt the hearing examiner's recommendation that it be permitted to update those amounts to the actual tax return amounts that were not known until its 2017 federal tax return was filed.
Mr. Geddes.
Thank you, Mr. Chairman, members of the commission. I will tell you that this is a very important issue for the staff. And when you argue on principle versus numbers, that usually is a problematic, state of affairs. This is not a big adjustment compared to some of the other ones we've talked about, but it's a very important one, and it could affect every settlement agreement any party enters into with Delmarva or another utility if it can be unilaterally changed without agreement of the other parties. Now, the hearing examiner, in his final paragraph on page 72, suggests that the numbers were incorrect. And that was part of his, I have the slide if you want. Could we put that up on there? The next slide, please. Next one, please. Yes, that one. That's paragraph 209. That statement is not correct. The parties negotiated this settlement in good faith in my office, I remember, over several days. The language is difficult. The issue was complex. But we came to the numbers, settled numbers, not estimates. There's no language in the settlement agreement that suggests the numbers that are currently being paid back to ratepayers were estimates. These were numbers. Now, we believe that was a promise, like a promissory note. There was a promise to pay. There was no except under these circumstances, except if our taxes say something else, or, you know, it's Tuesday and it's raining. It was a promise to pay without any modification. Those are the numbers. That's a commitment on the part of Delmarva to pay those numbers. If they were concerned about them as estimates, or that the actual tax returns would reflect something different, they would have put in true-up language to reflect that. They would have said, these are estimates, and these will be trued up when the actual information comes in. But they didn't do that.
And you
And
didn't, you guys didn't either, right?
We didn't agree to that. And when you have, I think you know where I'm going with this, having some legal background. It's a commitment. Now, yes, did it prove to be more than what they really are forced to pay? But we've gone through all these issues today on estimates, forecasts, actuals, or whatever. This is not an actual or a forecast issue. This is a settled number that has no caveats. The word estimated is not even in the agreement. If you look at the hearing examiner's report on page 70, it's a portion of it. It doesn't exist. And this is where staff gets its back up. If the company had wanted to modify a settlement agreement which you agreed to in an order issued by you, they should have brought a motion. You know, motion to the commission, settlement agreement. I'm being a little pejorative now. I'm sorry it's late in the day. The settlement agreement should be modified by subsequent events, and we want you to consider it. But that's not what they did. This one page in work papers, I won't use the other verb I was going to use, or adjective, I guess, is the only basis on which this witness here was able to determine, because he was at the settlement table, that the numbers that were in the case were not the ones that were agreed to. These are different numbers. And I think, I've been around a long time, don't need to go through that all over again, but I think this is pretty unique, at least in my experience, that rather than bringing and saying, look, we have a problem here, or we think we have a problem, or we should be able to do something here, can we look at this, modify it, change it, a work paper in hundreds of pages without a motion asking the commission to seek relief from an order you entered, I don't like it at all, and I would request that you not agree with the hearing examiner, since the information was not incorrect. Nobody made that argument in front of the hearing examiner. Everyone agreed the numbers were the numbers. It's just a question whether they should be modified by subsequent events. But just think about it. If settlement agreements that do not have caveats, true-ups, escape clauses, or whatever, can be unilaterally changed without the other parties either, hello, Joe, we want to change this. I mean, I don't think the commission wants to go down that road. And so I do feel it's a very important issue for the staff. It's a principal issue, and it potentially could make other settlement agreements subject to the same kind of after-the-fact modification without notification to the people who were at the table and signed it. Thank you.
Ms. Iori?
Thank you, Chairman Winslow. I understand while I was out that Delmarva indicated that our taking no position on the issue means that we agreed with them. We do not. Thank you.
Ms. Schultz?
So I want to just clarify a couple of things. First of all, the same arguments, not verbatim, were put before the hearing examiner in the 4 days of hearings on this issue. There was testimony in the company's pre-filed testimony on this issue. There was testimony from company witness Zeminski during the hearings on this issue that the company never intended and had no purposes of trying to hide this change from the commission, from the parties. This was simply a matter of something that was overlooked in terms of the case. I could go into the many reasons for that, which Mr. Zeminski articulated on the stand, but suffice it to say, it's my view in reading the hearing examiner's recommendation on this, that he took what he heard and he believed that it was most appropriate, based upon the testimony that Mr. Zeminski gave, that in his view, these were estimates in the settlement. Now, we're obviously never going to know what every party intended because all we know is what's on the page. And it would be improper for the hearing examiner or for anybody else to rely on, somebody's recollection of what went down in a meeting, because that's why we put the words on the page. And to what we've heard here today, there could have been a true-up clause, there could have been this clause. There wasn't such a clause, but there could have been on either side. I don't know that we will ever know whether the parties even thought about that when dealing with the complex and complicated issue they were trying to put to paper. But I don't think this is a slippery slope where we need to worry about this happening all the time. To my mind, if this is something that the commission adopts with respect to what the hearing examiner recommended, it becomes yet of one of 20 other paragraphs that always go at the end of settlement agreements. But I think that on the facts and the circumstances in this case, it's most appropriate to allow the company its request, which it has properly and is appropriately before you in this case, to update its estimates to its actuals. That's what I have.
2 quick points.
Yes, sir, go ahead.
You discern what the document means on the 4 corners, in the 4 corners of the document. There's no word estimate, and there's no carve-out. So if you're looking specifically at the document, and the numbers were correct, you're looking at a document, you don't go outside the document unless it's unclear, and it's not unclear here, and so therefore the document should be enforced as written. Thank you.
I remember this particular situation really pretty clearly. And I want to commend Drew Slater for the fact that he got himself and his staff together, and they got in here and they started to put pressure on the utilities about the tax situation. This was a nationwide problem. And people were running around scratching their heads going, how do we figure out to get this money back to the people that need the money because of the pandemic, et cetera? And to the credit of the staff and the credit of the DPA and the credit of the companies, they came to some agreements with respect to the tax situation. Now, fast forward, and we're coming to this rate case, and I'm inclined to side with Mr. Geddes with respect to the fact that perhaps there should have been more overt, open, transparent, and hi, we got this little issue that's contrary to a previous order. Can we talk about it and get it resolved? That should have happened perhaps in this situation. But I can't make a decision because staff gets their back up about something. I think what's fair is that the companies give back their actual, that word actual. I think we should be consistent with that word actual. And I don't think the company had any nefarious intent in this particular matter. They came to the table quickly and got this thing resolved. A mistake was made. I mean, Staff could have asked for a true-up, and because the tax, the amount of money in the document could have been less than what they got as a tax return, right? The company could have asked for a true-up, but the bottom line is that they made a mistake with respect to what amount of money was going to be going back to the taxpayers. And in my opinion, it should be resolved in the amount of the actual amount of money that's owed to the taxpayers. And I'm not, in my humble opinion, setting any precedent for people to back out of separation, or not separation agreements, but agreements because they want to. There's got to be some sort of substantial reason to do it. And I think paying the actual taxes back is a good reason to go outside of to change the agreement. That's my personal opinion. I welcome any other, Commissioner Gray.
Yeah, Mr. Chair, yes, I concur with the chair on this matter, and I propose, if you're looking for a resolution, that I propose that the staff situation or staff recommendation be accepted.
That's the opposite of what the chair said, I think. Are we, okay.
Commissioner Gray?
Thank you, Mr. Chair. I think I do remember the discussions around this issue and the terms and conditions that were cast, and I'm empathetic as well to Mr. Geddes' contribution on this issue as well. I guess what I read at the end of every order is that the commission keeps the jurisdiction over this matter and can change it, moving forward in the future. I guess my preference would really have been to see a motion somehow to change the terms and conditions of the agreement. So I'm more settled on process decision as opposed to what's right in this matter. And I'm less inclined on the fly to adopt a change in the terms and conditions. I seem to remember lots of different faces around the table who were interveners when we were actually structuring those terms and conditions. And I just don't know what we're going to do in terms of the fact that they weren't informed and they're not engaged in making a change to that contract. So I haven't decided how I'm going to vote yet, but I'm more on process in this matter than anything else. Thank you, Mr. Chair.
Mr. Geddes, what happened to the water companies?
I'm sorry, say that again?
All the water utilities, Artesian, Tidewater.
Well, I know there's some ongoing investigations, but this was treated specifically.
Taxes, I mean.
I'm sorry?
The same issue, taxes.
Taxes, yes.
Yeah.
But again, we tried to create agreement to get the case resolved. And we knew it was a thorny issue, and we made the settlement agreement. And all the parties agreed to it, and it was better as well as anyone. If this term changed, then something else might have changed. There might have been a concession or whatever, but it's the agreement. And when we have numbers, and we illustrate some in our briefing materials, where there have been tax issues before, and we have used different mechanics to fix them. Sometimes we use a regulatory asset, sometimes we use a true-up, sometimes we use something else. But none of that is in this agreement, and so, yes, I can understand that the actual tax liability is different, but there's in the regulatory calculus using forecasts and all kinds of theoretical assumptions for things, wait till we get to cost of capital. I mean, it's just plain on its face. Yes, it's unfortunate that it came to you this way. It should have been brought by a motion so that you could consider it. But having said that, I think the document's pretty clear.
Now, my question is, Artesian.
Yep.
They entered into an order, said they would pay back the taxes to their customers. What happened to Artesian? Did they get it exactly right when they did theirs? Did they change
I
it?
think Ms. Iori can answer.
Chairman Winslow, actually, Mr. Slater has been very involved in these cases, and he can tell you exactly what happened.
Okay, I
Or what is
appreciate that.
happening.
So we treated the water utility separately than we treated Delmarva. It was done in their rate cases.
Well, that's right.
Those are still ongoing and pending and are not final yet.
So,
Mr. Chairman,
Yes, sir.
I do have one other question. Is there anyone who can quantify the amount of the impact on this decision? In other words, what's the magnitude of the mistake here we're trying to fix?
About $980-some thousand, give or take a few dollars.
oh,
I think
sorry.
that's
I'm just
close.
trying to look it up as well.
It's 996,442.
So not an inconsequential error by the parties.
No, and Commissioner, I think that the additional point to realize here is twofold. This is simply a flow-through. I mean, all we're looking to do is to return exactly what we got, nothing more, nothing less. And if it's being dealt with in the water utilities, in the water rate cases that are still ongoing, they're at the advantage of having their actual numbers now because they're beyond the point where they would have filed those tax returns in those cases.
Yes,
Your
but,
Honor,
go ahead.
with all due respect, Delmarva chose to do it in their rate cases because they had rate cases going on at the time.
Yeah, it was specifically,
Okay.
Delmarva was carved out from the other utilities in terms of how this would be treated.
Okay. And as a result, we're here talking about it still. Is there a motion on the table? I don't even remember. Okay. Well, I'm going to be consistent. I think they should pay the actual taxes to the consumers. And the consumer shouldn't get almost $1 million windfall because of the error made, I guess, in combination of all the parties who signed the agreement, thinking mistakenly that they had the right figure, apparently. So I move that the company's position prevail. And there's a silence in the room, so if there's no second, then it means somebody else will have to make another motion.
I second the motion.
Is there any further discussion on the motion? All those in favor signify by saying aye. Aye.
Aye.
That's two people. All those opposed, nay.
I'm opposed.
Nay.
That's two people. We have an impasse, and we'll go on to the next matter. Okay, we have next, page 31, it's the cost of service.
I'm going to yield to Delmarva's in-house counsel, Mr. Brian Jordan.
Mr. Jordan, welcome. Please proceed.
Thank you, Your Honor. May it please the commission, Brian Jordan for Delmarva Power. What we have with this issue is the jurisdictional cost of service study. There are three topics at issue. The first one has to deal with what I'll call the FERC Form 1. The second one involves the removal of storm damage, and the third one involves is a little trickier, Your Honor. As we had pointed out in the briefs and the exceptions, the hearing examiner's final ruling on this it could go either way on this Empower Maryland surcharge. Now, with these topics, it was a mixed bag for Delmarva and for staff, and I think in order to keep the record clear, it might make sense to go through them. As I've mentioned, we'll do FERC Form 1 first, and the commission can take a vote on a motion, and then we can discuss the storm damage second, and then the Empower Maryland surcharge third. And with that, Your Honor, I'll start with the FERC Form 1. And in this case, the hearing examiner found in favor of Delmarva that it did not need to update the FERC Form 1 T&D labor allocator. A little bit of history with this one, Your Honors. The FERC Form 1 is filed annually in April. It was filed after the company filed this rate case. And so what that means is that the company filed this rate case using the data from the FERC form it filed the previous April. Now, the company did not update the labor allocator after it filed the FERC Form 1 in 2020. That's consistent with the company's policy, is not to update these allocators unless there's been a commission order or some other legal authority has said to. And in fact, we will see that with the next topic when we get into storm damage. And Mr. Zeminski testified that that's been the practice that he's known, not only for Delmarva, but for the sister utilities and the way that they operate. And that's the way that it was followed here. The hearing examiner agreed. We did not need to update that material. And, you know, the one thing to point out here is that this allocator is one of many. But it's one that staff had singled out against all of the others to highlight as one that Delmarva should have updated. The one thing missing from this is a citation to precedent, a citation to case law, a regulation, a rule, an order, something like that, requiring that Delmarva do that. So it didn't. And what we're asking, or what we believe, is that the hearing examiner heard the evidence, was satisfied that Delmarva had met its burden, and was satisfied that the data included when the rate case was filed was sufficient. And that's where we are now. And so it's Delmarva's position that as to this specific part of the jurisdictional cost of service study, the commission should adopt and it should accept the hearing examiner's recommendation.
Thank you, Mr. Jordan. Ms. Iori?
Your Honor, the DPA
No
did not
position.
take a position on this issue. Thank you.
Thank you. Mr. Geddes?
Mr. Chairman, members of the commission, this is an interesting issue, and I think that it's one that should be addressed, especially in the context of our discussion earlier today about actuals and forecasts and having rate calculuses that are based on real information that is as most accurate as possible, including one of my benchmark principles, known and measurable, which I put up early on in my opening comments, so that we understand the issue. What was used to support this application in March of 2020 was information that was from calendar 2018. The test year in this case, not test period, but the test year in this case, so the 12 months ending December 2019. So the information that is being used to support the application is a year behind the test year information. The more current FERC 1 form, as council properly stated, was filed in April, a month and a half, maybe 2 months if you want to be charitable, after they filed their application, in this case, March 6, 2020. So the question is, why did the company, as they went through their case and they were asked about these allocations, why, when they filed rebuttal, when they updated other things in their rebuttal case, brought more current information, we've talked about many issues, why didn't they update this? It was available, it was known and measurable, and it reflects information in the test year, which is used to base the application on and forms the basis for the test period, which goes out, as we've talked about, 3 months past the test year. So the question is, why didn't they use it? Well, pretty clear that FERC had already changed the allocations based on the 19 filing, and that if you use that filing, less cost would be distributed to Delaware ratepayers, and their rates would go down by approximately $1 million if you use the more current information. So the question is, why didn't they do it? And Mr. Zeminski, I had a slide on this, but I don't think I need to put it up, stated that the only justification to update an allocator after the application is filed is to accommodate something specific. Well, that's his opinion, but that's not the commission's position. That there is no precedent that states that. That's just the way they've done it. Well, we have spent much of today talking about new issues, new resolution of issues, and as you know, staff has consultants. Sometimes they have the same consultants, sometimes they have new consultants. And Dr. Blank was looking at this in a prior case in 170977 because he thought the allocations were incorrect. And the irony of this case, of course, is we had a big argument about how you allocate plant in this 170977 case, predecessor case. And Dr. Blank wanted to allocate it on O&M factors, and the company insisted on doing it on labor allocators, the same labor allocators that they haven't updated for the FERC 1 2019 information. So it seems that we should at least use the current information that is available to the company and is consistent with the test year. Now, the company continues to say, well, if you do that, you're taking it out of sequence because we haven't updated everything else. Well, that I don't believe is true. They update their other allocators on a quarterly basis. This is a big allocator, clearly, and as a result, there's a potential for over-collection because Delaware is being charged $1 million more. Still have to use this hand, this one. $1 million more, and in the FERC, they're using different allocators, which for other purposes have different, mix and match. I mean, obviously, they have 3 or 4 jurisdictions. They have the Fed jurisdiction. They try to make it all work so that they're whole. But here, you've got a mismatch between what FERC is using, based on the more current information, and what is being used to set rates in this case. It just doesn't seem right. We should use what we have, what's known and measurable. It's there, it's available. It should be used in this case to reduce Delaware ratepayers' burden with regard to distributed plant. Thank you.
Mr. Jordan?
Thank you, Your Honor. A few points on that. I mentioned in the beginning that this is one of many allocators, and some of the other allocators that staff did not identify to be updated include those in A&G, O&M, plant allocation, revenue allocation, that sort of thing. And that really highlights the difficulty with staff's position. It has singled out this one allocator, and to have the company update it without having a requirement to do that, it not only makes it has an effect on other aspects, but the difficulty is, right now the company has the policy that Mr. Zeminski identified. When the commission issues an order to update an allocator or take some sort of action, it does. That's easy to apply. It provides the company with the sort of consistency and predictability that's required, and that's what happened here. And so I think ultimately what this comes down to is the hearing examiner was right for this case. If the commission is not satisfied with that for some reason, the solution would be to apply this going forward. Not to say that in this case we have to follow Dr. Blank's approach and update the FERC Form 1 with the more current numbers, but rather in the next case, for example, something like that, and not take it out of this case. And I think, again, though, I think that's sort of Plan B, because I think what the hearing examiner had in front of him was enough to be satisfied with Delmarva's decision in this case. And so we would ask that again, the commission adopt the hearing examiner's recommendation.
Just one sentence?
Yes, sir.
I think it's a little bit of a misnomer to say that O&M, which we've talked about, has been updated for 12 months. And the sentence in our exceptions states, like the reliability plant, which we've talked about, which is being adjusted outside the test period, have been updated for the test period and beyond as known and measurable changes. So too have O&M sales revenues, wages and salaries. We've talked about all those things today. All of those have been updated. The one allocator that has not been updated is the T&D, which was available in the FERC Form 1 for 2019. So we're not even close to being to the test period. We're almost 2 years behind it. And I think it should be done in this case. It's clearly articulated as why it should be done. And that's our position. We take exception to the hearing examiner's resolution of it. Thank you.
He said he was gonna say one sentence.
It was a runoff.
I stopped counting, so you have your one sentence too.
Very well, thank you. Thank you, Your Honor. I guess then it leads into, here we are now, August 2021. There's been another FERC Form 1 filed. The case is still proceeding.
Test years. December.
I mean, there's
pretty
got to
clear.
be a point where, again, the company's policy comes in, and the company should be able to rely on that, unless the commission has said going forward, we're going to change it. That said, we would ask that the commission adopt the hearing examiner's recommendation, Your Honor. Thank you.
Thank you, Mr. Jordan. Commissioners, any questions? Commissioner Gray.
Thank you, Mr. Chair. I have a question for our counsel, please, Mr. O'Brien. Is it, we've heard this witness suggest that the commission place an order to update the allocator. Is that the only or best practice way in which to get that done?
From a legal perspective, the commission can go either way on this, based on how they think the appropriate policy should fall. If what Mr. Jordan is saying, and I did not hear him say this, and the parties can certainly respond to it if they wish, but if what he's saying is that because the company has been following this policy that has been accepted in the past, they've allocated certain costs between jurisdictions that recover all their costs, and if the commission now changes an allocator for this case, that means that there will be certain costs that aren't picked up by either jurisdiction, but if you give them an order going forward to change the allocator for the most updated information, then under that argument, I would answer your question that perhaps the better way to do it is to tell them how to do it moving forward so that there are no costs falling through the cracks. But either way, I feel would be supported legally by different arguments and policy considerations in the record if you wanted to do it in this case. It may be appropriate to ask Mr. Jordan if my synopsis of his argument is accurate, that by changing the policy now, you risk having costs fall between the jurisdictions and not allocated to either one, or whether that's just not a consideration in this case.
Is that a risk for which you are concerned, Mr. Jordan?
Yes, yes.
And Mr. Geddes, do you have any comments on this dialogue?
Well,
share?
it's always a potential issue, but on the, in trying to get the allocations between the various jurisdictions correct. But in this case, we believe that there is some double recovery because the allocators have changed in one district or one jurisdiction, I should say, not district, and they haven't been changed in others. So I think this issue is going to be prevalent whether you do it today or whether you do it in the next case. But just remember that as long as these rates are in effect, ratepayers are paying more than they should be paying based on the most recent FERC 1 allocators.
Thank you, Mr. Chair. No further questions.
Want to make a motion?
I'd like to make a motion to accept the hearing examiner's recommendations as stated.
I second the motion.
Is there any discussion on the motion? All those in favor signify by saying aye.
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 All those opposed, nay, no. Motion carries.
Mr. Chair, for clarification, did you vote no?
Yeah, I'm an actual guy. I think I made that clear. And I
Sorry,
think
I
that the
didn't.
company should have provided the actual figures for 2019. Simple as that. Okay, the next one is cost of capital.
Your Honor, it's actually.
Oh, I apologize. The second shoe, I apologize.
No, there's a third, too.
Oh, okay. Obviously, the day is getting on, and, please.
Yeah, yes, very well, Your Honor. The second leg of this, this race is about the storm damage. And in this instance, the hearing examiner decided against Delmarva in this. And what I'll point out to begin with is this is the second time that storm damage has come before this commission. It was last before the commission in May of 2020. And what happened in May of 2020 is the commission issued Order 9546. What's significant is the commission did not accept a recommendation at that point to remove, quote, storm damage expense. Instead, what happened with Order 9546, the commission first says that it is going to modify that hearing examiner's recommendation. And it did. What it did is it added the word major into the order. Major storm damage. So it went from a categorical, unreserved concept of storm damage to major storm damage, which implies that there is minor storm damage as well. Based on that, what the company did is they went through and it identified major storm damage using a definition in the administrative code for a major event. Separated those, took them out, and retained what would be called minor storm damage. Staff's witness instead went through and removed all storm damage expenses. And this is where the hearing examiner got it wrong. There's two mistakes in his finding. First of all, what he did is he went beyond this plain and unambiguous text of Order 9546. It plainly says major storm damage. The problem is the hearing examiner in his report mentions that he was providing a clarification to the commission's order. No clarification is needed when text is plain and unambiguous like this was. But the second mistake he makes is he gets the whole context wrong. He notes that he went and looked at documents that were not part of the record at the hearing, or in this case, transcripts from previously and pleadings in that previous case. But the problem is, again, that gets the context wrong. When the commission dealt with this, it's clear as crystal in its words. It was entering a modification. The only thing it modified was that storm damage by adding the word major. Now, the fact that the word major storm damage does not appear in the administrative code does not make this ambiguous or unclear, because there is language in the administrative code about a major event. And a major event can certainly encompass major storm damage. The real focus there is not on the mechanism of the major event, but what we had used was that 10% or more of outage, right? Whether it's a tree that falls, or a big rig hits a pole, something along those lines, or a storm that knocks out power to that amount of people. So that's what the company did. And what we're asking for now is that the commission correct the hearing examiner's recommendation and, in fact, go back to what the commission ordered. And it creates these two categories of major storm expense and minor storm expense. And by leaving in the minor storm expense, the company was complying with Order 9546. Thank you.
Thank you. Ms. Iori?
The DPA did not take a position on this issue. Thank you.
Thank you. Mr. Geddes?
Mr. Chairman, members of the commission, briefly, this is just another attempt to try to get apples and apples, rather apples and peaches or pears. Delaware and Maryland treat these expenses differently, these categories of expenses. Delaware makes no distinction between major and minor storms. Maryland does. And in an attempt to make this comparable, we removed all storm expenses. Now, the company suggests that there were no major storm expenses in the test period. Well, that's not completely, well, it's true on its face, but the treatment in Delaware is we normalize storm expenses over 3 years. So there may have not been any in the test period, but there certainly were in the normalization. So the only way to make this work is to remove all storm damages, which is consistent with the order that council referred to, and make sure, since major storm damages are treated differently in Maryland than they are here, that we have, as I think is the essence of the commission's previous decision, is not to have this mismatch between how storm-related costs are treated in the two jurisdictions. And major event is not the same as storm damage. We've treated storm damage historically over a 3-year normalization period, and we've taken all storm damage and put it in that category. And in fact, as testified by one of Delmarva's witnesses, there is a portion of major storm damage in the 3-year normalization, even though it didn't occur during the test period. This adjustment should be approved as the hearing examiner suggested.
Mr. Jordan? Mr. Jordan?
Just briefly, Your Honor, what the company is confronted with, again, is that language in the order that specifically says major storm expense. And so if it's put on the horns of a dilemma to say, well, if we take out all storm expense, well, that's not major storm expense because we still have minor storm expense. On the other hand, what we have to do, obviously, is comply with the words that are on the order. Those words are major storm expense. That's what the company removed, and we would ask again that the commission reject the hearing examiner's recommendation on this and bring this back to what it is in the order.
But point of clarification, that is not what happened. In the test period, yes, you move major storm expense because there wasn't any. But that didn't get, this major storm expense didn't get removed from the normalization, which is 3 years. So it goes behind the test period to the year before, to the year before. There's $1.5 million of major storm expense in that normalization. That's the problem.
Do you see the problem he's talking about?
I do, Your Honor, but the difficulty, again, that we run into is this very specifically says, quote, that in Delmarva's current Delaware Electric rate case, major storm expense shall be removed from the cost of service from both Delaware and Maryland, end quote. And so the situation that the company is in, I mentioned the horns of this dilemma, by modifying that recommendation to remove storm expense, by adding the word major, creates this minor storm expense category. So it puts the company on the horns of this dilemma of having this category of minor storm expense that it included with this study.
I'm not going to...
Commissioners, any questions of the parties? Anybody like to make a motion?
I'll move to adopt the staff's recommendation.
I'll second.
Is there any discussion on the motion? I would just say that I support the staff's argument and for the breadcrumb issue. All those in favor of the motion signify by saying aye.
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 Are there any opposed? Are there any abstentions? There's one person absent, no abstentions.
Thank you, Mr. Chair. The final issue with this jurisdictional cost of service is the Empower Maryland surcharge cost. And I mentioned in the beginning the difficulty with this because we've got this section of the hearing examiner's report, and it says, quote, "The company reasonably excited the Empower Maryland surcharge costs from its jurisdictional O&M allocator because they are not distribution-related expenses," end quote. However, after reciting the testimony presented to him, the hearing examiner concluded that based upon the foregoing, staff's proposed adjustment to the JCOSS should be approved. Those two sentences cannot both be true, and so it leaves us in the position of saying the hearing examiner got it right when he says the company acted correctly, and he got it wrong when he says that staff acted correctly. I've got to make the double argument that if the hearing examiner was saying that Delmarva acted correctly, then we agree. You know, it's like eating corn on the cob from two sides here. On the other hand, if he is saying that Delmarva did not act correctly, then we obviously take exception and filed our exception to that finding. And I think it's probably smart to start there and explain why we think the hearing examiner's recommendation is wrong if it's in favor of staff. Because first of all, what we're talking about here are not distribution-related activities with this Empower Maryland surcharge cost. So in that sense, they shouldn't be there. And this was an issue that was discussed previously in the 17-0977 Phase 2 case, where the same witness for staff, Larry Blank, did not raise an issue with Delmarva's action to remove these surcharge costs. And you know, one of the things that staff had mentioned is that you end up with this mismatch, and it's apples and pears and apples and oranges. And I think the response to that, of course, with these kind of things is that there is no such thing as complete symmetry. And you know, even the law recognizes that. Even the most onerous burden does not require 100% certainty in these topics. In other words, there will be mismatches with these kind of costs between two states, but the reality is we're not talking about distribution-related activities. And so therefore, we think the hearing examiner was right when he wrote that the company reasonably excited these surcharge costs from the jurisdictional O&M allocator. And so, again, that leaves me in the position of saying if he's right, he's right. If he's with Delmarva, then he's right. If he's taking staff's position, then we would ask the commission to reject that.
Same argument, different issue. In Maryland, these costs are collected through a rider. Historically, they have not been collected through a rider here. They are related to distribution because they're related to A&G costs. Recently, subject to a commission order, these costs will be treated going forward in a rider. But for this case, they're in the cost of service on one side of the equation and not on the other. They need to be removed. So we have apples and a fair playing field. It's not that complicated. You have one collection mechanism in Maryland. You have a different one here for this case, but it will be the same going forward, so they need to be removed. Thank you.
Commissioners, anybody have any questions?
Mr. Geddes, what do you mean by removed on one side of the equation but not the other? Can you be more specific, please?
Sure, because in Maryland, they're not in their base rates or in their allocation system the way that we have ours. They are subject to a rider. Here, going forward, we are going to have a similar mechanism, but for purpose of this allocation, for determining what the appropriate distribution rate should be in Delaware, those costs should be removed. Otherwise, they are not apples to apples, because in Maryland, they are not in the base rate, so you're over-allocating costs to Delaware as a result of that. They're not comparable. If you take them out from Delaware in this case, then you have cost of services in the two jurisdictions that match up, and this issue is not part of that analysis. That's why the hearing examiner agreed with us.
How do they recover that expense or that cost?
Say again, please?
How do they, you're taking out some expense from Delmarva's claim, right?
No, this is about jurisdictional allocations between the two states. You're going to change the allocators by saying that you're going to treat them outside the jurisdictional cost allocation system. You're going to let Maryland do Maryland's thing, and you're going to let us do our thing without them, so that your allocation system, your allocation, let me try it again. Your allocators are matching up, and these costs aren't on one side of the equation and not in the other.
Okay. I went beyond, okay.
We support the hearing examiner's resolution.
And Your Honor, I mean, what, if I may,
I thought you were deliberating, I'm sorry.
He can speak.
just the final point I'll put is that what it does is it traps costs. And again, I guess the commission has to sort out the hearing examiner's recommendation here. But again, we support the idea that the company reasonably excluded these costs.
Okay, I move that the commission support staff's position on this issue.
I second.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Are there any opposed? Are there any abstentions? The motion carries. Okay.
Chairman Winslow,
Yes, ma'am.
might we have a break?
It's been a long time. I think that's a good idea. Would you suggest maybe 5 after 4, about 13 minutes?
Yes, I would also, I've also been told that there is a potential resolution, maybe of the issue that you've split on, and the parties would like to discuss that amongst themselves.
How much time would you like to have? Because we want to accommodate you if you need time.
You think 5 minutes? All right. I'm told 5 minutes, and like all forecasts,
It'll be wrong.
Why don't we make it 4:10?
4:10?
That gives you 15 or so minutes.
Thank you.
Yeah,
We'll take-
updated with
thank you.
actuals, as Mr. Walsh said.
Gina?
I'm getting tired.
Okay.
The EDIT?
Yeah.
Which one's next? That should be quick. No, it won't be long. It won't be long. Well, I have some, I got some tea as well, I got mints. My allergies. I know, I dropped them all with it.
Yeah, so you want to give back more than you did.
That way it's,
What's that?
In fact, it is getting cold, it is getting cooler.
Yes, yes, I can turn, I can.
Well,
A
there's
couple of degrees.
a lot more issues in this rate case than there usually is.
But I don't know about other people, so that's why I didn't
Usually you can't
mention it
agree
to
on
you,
this,
but
you know,
if other people
return on
feel
equity.
okay, then I'll survive.
And, you know,
But I think two degrees up, everyone likes it because people were putting on, Andrea and everyone were putting on covers.
Well, if you have an agreement, they'll stay. Yeah. I mean, you know, he's gonna stay.
I mean, how many cases, there are tons of cases out there.
I heard that. It's on the record somewhere. We'd be happy to know on that next issue, I'm the only one arguing, so shouldn't take that long.
What is that, the ROE?
Get on with our
Well, the ROE should take like 2 minutes.
Yeah, well, it's gonna take longer for me to flip the slides.
How many slides are we talking about?
Go. Oh, it'll be long. You'll be out of here by 5.
We have four more issues. Four more issues.
Oh, we don't, we have just 2.
Yeah, we've got, grade design billing determinants.
Oh, yes, I forgot about those.
We have determinants, residential monthly charge and staff
Ah,
discovery.
oh, yes, oh, billing determinants, I love that. I forgot about all those good issues. And our discovery issues last, didn't it? Rate design, yeah, rate design residential, that's not gonna take that long. Although the monthly charge might be controversial.
That's gonna be a little, yes, it will be. Question for you, Jim. Usually you guys huddle and figure out all the figures and this and that, and so when's that gonna happen?
Oh, I'm just got on exit mode at the moment. You are correct. Usually we prepare a minute order and we put the numbers in it.
Yeah,
And that takes a while to figure out.
I'm going to France on Monday, so let me know soon, okay?
Well, it's up to the commission, obviously, but we could come back for it tomorrow, but, or could we do it some way virtually with one commissioner here? If it were just talking about numbers and not issues.
Yeah, I think that sounds reasonable.
Because it's just, we'll have to get, I mean, it takes a while. And, I mean,
Commissioner Korea's right around the corner, so he can come over.
here. He's in Dover.
What did you say? I was,
We're
So, but-
talking about the final order and how we're gonna be here to sign it. And Mr. Geddes has recommended that one commissioner be here, and I volunteered you because you live nearby.
you are the chairman, so
And the other commissioners could be at Zoom distance, and we can vote that way.
yes,
Day are we talking?
I'll stay here.
Tomorrow.
Tomorrow?
Yeah, we would, well, like, without talking to other representatives, I mean, it won't take long to do the order, it's just plugging the numbers and having the consultants agree these are the numbers based on the decision.
When do you go to France?
I think the 12th.
They're allowing you to go to France?
Yes, they are.
Well, my grandson is now in South Africa,
I'd love to go to
going
South
into
Africa.
Johannesburg.
Ew, not Cape Town? Did I hear you're going to France?
Mhm.
But no, they
Guess
changed
who I'm
the
going
trip,
with?
so they stay at the Intercontinental at the airport, which
I'm going to
is,
ride with Roger and Paul and
and then they
Roy.
go out on safari. So his grandmother stayed
Dick
here.
and Linda Cathcart. Oh, really?
We did a little bit of, South Africa.
Very
and
well,
then
yeah.
Botswana. We went into Zimbabwe.
You've got a new place in
Victoria
the-
Falls and then Craig.
Victoria Falls.
Oh, just Normandy, Paris, Normandy, Provence.
That was the most amazing thing in the world.
Normandy's really spectacular.
I spent
Yeah, I've
3
never
months when
been
I
there.
was
I've been to
sailing
Paris
in,
before, Provence before. but I've
because
never
we had to
been
wait for the
Normandy.
weather to change, so we came into Cape Town in November, we didn't leave till
I was not planning to feel the
middle
way I did when I
January.
saw it.
Yeah, it's pretty impressive.
Some of
what
the
he's
best
doing.
food I've ever had.
It's hard to comprehend the number of people injured and killed, and when you see a scene like that, it really brings it home.
Oh, and that cemetery is just,
Pristine, yeah.
and then when you see the bunkers and you see the beach and you see the cliffs and you're like trying to figure all in your mind how everybody did this.
Right. Pretty incredible. Men scaling the cliffs. Oh, he has a house? Well, he gave him a house. You told me he's not gonna be over, because he hasn't been appointed yet, he hasn't been confirmed yet.
Might be the fall.
Yeah.
It's not healthy, but
Well, I can go to Paris and. It would be presumptuous to go over without being confirmed. I think the Senate might get ticked off on it. Or move it in, or leave. It would be.
Couple cities. My neighbors moved yesterday, so of 9 homes.
Is Paula still there?
No, she sold her house.
Really?
So I think she stays at the beach. I think she may be on Greenville Met Place or something. She sold, now there's nothing on the market. She sold another neighbor's house. Lovely. So they what? February? And then the house downstairs. But anyway, she said she moved in February. She wasn't under any. Yes, these people moved. This moving van. Was the largest thing I've ever seen. As I was leaving, they were putting coffee bags on motorcycles into this moving van. That's how ridiculous, but it is. And I said, I asked the homeowner, like, are they just driving to your new house in Arizona? And they said, no, they have to pick up more stuff. Storage unit. It's a lot.
Yeah, that was from everything I've heard, that was.
But I mean, up close, a big moving van. Floors everywhere. Oh my gosh.
So if they don't settle that issue, we need to talk procedurally about what to do with it. We need to circle back.
Do you not
Can
have
somebody
someone
just
ask?
change their vote and make it easier?
Bill, can we ask you a question?
Somebody who voted,
Again,
how's it work?
Yay, can vote nay.
you can reconsider.
I don't forget how Robert's rules are on that, but someone who voted, I guess, against it can vote. I don't remember what the issue is. The issue is the tax money, right? Well. Yeah, there's a, I understand. I made a mistake. I thought they were right for me. I just remember very vividly. Political rush. Get utilities to kowtow and give the money back. It wasn't a simple calculation.
You're going now, sorry.
The utility can't know its income is going to be. The best you can do is estimate what the. Because neither the state, nor the TPA, nor the company, they were confident they had the right parameters.
Yeah, he comes up, right? It's kind of like Courtney trying to send you a message and your husband's in your head.
I've seen any number of squabbles between lawyers over who's slighted or this or that. And, those things happen. Like Ms. Schultz said, it wasn't done intentionally or nefariously.
Like you have clients.
I understand.
You got 4 minutes, I can go too.
That's what I said to Dr. In my opinion, there's no default position. Like if this isn't a appeal, if you're using a decision.
Love to go to South Africa. I've never been to Africa. Well, I've been to Africa. I went to Uganda once.
Oh, it's beautiful. It really is. Cape Town's one of the most beautiful cities in the world. Table Mountain, amazing. Yes, sir.
Right, well, I will suggest on the record, if this was about to end, nobody brought it back up.
I'll take it under advisement. I'll take it under advisement.
But I think we always circle back to it.
I hate those things. I always get
It's on our list.
Another bottle of water somewhere.
And Gina's response, which I will mimic, is, and on the horse you rode in on.
No, I did not say that. You said that.
I'm sorry. I heard you say it.
No, you didn't. I said nothing of the sort.
Do we need to separate you two?
Yeah. Now, we've gone along for a while, but it's about time to get to work.
Totally.
So it's a little bit different than Virginia.
It's a little different, and I apologize for speaking. I said saying sir rather than Mr. Chairman. It's just-
No problem.
It's definitely,
So,
we don't do this at all. Commissioners certainly don't. You're going for individual.
Well, I skipped that.
It's completely different than a legal job.
Oh, thank you.
Yes,
It's very interesting.
I can fly back on Friday.
The sheets on the.
I was just thinking how pleasant it would be to actually hear some of my arguments that sometimes the commissioners just say like, nah, I'm just not even gonna address it in my order. So at least not always, though. I mean, I'll tell you, there's a lot of times where, especially as the industrial group, they'll just, yeah, I'll make a whole thing, and then they'll be like, oh, and a footnote, and like, yeah, we rule against them on this one. I'm like, I didn't even hear, like, why? Yeah, I mean, what's funny is, at least in Virginia, what happens a lot is that when I wheel out to like when the industrial groups win, they tend not to like quote the industrial group.
10, Gloria. Okay, we'll be back in, to the meeting, please. The next issue to be resolved is the cost of capital. I believe that is Scott going to do this one?
I am.
Please
Thank you.
proceed.
Thank you, Chair Winslow.
Thank you.
And I know you've all been waiting for this one because this is one of the most interesting, exciting issues as part of this rate case.
That's correct. That's,
So, in connection with the cost of capital, the company accepts, with an A, not an EX, accepts the hearing examiner's recommended 9.6 ROE. We believe that this is a fair recommendation based upon the evidence that was presented and is consistent with the holdings in both Bluefield and Hope. That it is reasonable, sufficient to assure confidence in the financial soundness of the utility, and it is adequate to maintain the utility's credit and enable it to raise money for capital and operational expenses. As you are aware, the company's witness recommended a 10.3 ROE in this case, and staff and DPA's witness in this case recommended a 9.25 ROE. Duke did not have a witness in connection with this particular issue and did not participate in the argument on this particular matter. We believe that the hearing examiner did fully and carefully analyze the parties' positions. Over the course of 19 pages, I think he set forth his particular findings with respect to this matter. I think he did a very nice job of trying to balance some very competing interests here. Cost of capital is not an easy thing. That's why the parties retain witnesses that have a significant amount of experience in this field, and they develop through the various models their particular recommendation with respect to ROE. I think you will see, or you have seen in reviewing the testimony that was submitted, that our witness, particularly Mr. DeAscendis, talked a lot about what is going on in the capital markets, what has been happening in the capital markets during the period of this particular rate case. Specifically, he noted that utility stocks were more risky than the market indices and underperformed both the Dow Jones Industrial Average and the S&P 500 during the period of January 31st, 2020 through August 31, 2020. He also noted that the current market tumult is worse than the Great Recession, and that there was a record drop in GDP in the second quarter of 2020. This all came out during the course of his testimony, and I refer to the transcript from February 11th at pages 646 and 647. He also talked a lot about volatility in referencing the relationship between volatility and interest rates. And from his perspective, when volatility rises tremendously, there's a corresponding decline in interest rates. And he also noted that investors, because of the market conditions, investors were looking for higher returns. I think that in terms of his findings, the hearing examiner's findings specifically, that there was sufficient evidence to support his conclusions in this case. I think that he tried to find sort of that fine line between where company witness DeAscendis was and where company witness Gorman was, and I don't think that's always easy to do. I think he did appreciate the fact that there have been significant changes in the market that impact the rates in terms of the ROE in this case. And I think he specifically felt that COVID had an impact in terms of the ROE. He relied in parts on both witnesses' testimony, and he clearly makes that comment in the course of his recommendations.
And I think there was some sense that perhaps he misspoke when he talked about the company being able to finance sufficient capital for transmission facilities. I think he meant distribution facilities. I think he just kind of misspoke and made that statement. But I really do believe that his findings are consistent with Bluefield and Hope, and therefore we would recommend that you adopt those findings in this matter.
Thank you very much, Ms. Scott. Ms. Iori.
Thank you, Chairman Winslow and Commissioners. The GPA is pleased that the hearing examiner appeared to give Mr. Gorman's studies and testimony the same credence that this commission gave his testimony and studies in docket 09-414. He performed the same ROE studies using the same models in the same manner as he did in that docket. The DPA does not accept to the 9.60% recommendation for purposes of this case only and urges the commission to accept it. We believe it is sufficiently close to the 9.25 ROE that Mr. Gorman's studies and judgment produced and is certainly more in line with the continued expectation of a low capital cost environment than Delmarva's originally proposed 10.3%. However, there are a few statements that the hearing examiner made that simply are not supported by the record and should be corrected in the commission's final order. First, as Ms. Scott noted, the hearing examiner stated that a slightly higher ROE than those produced by the DCF model was warranted because it, quote, through the construction of new transmission facilities, aids an electric utility like Delmarva to comply with its statutory duty to provide safe and reliable service and helps the utility to access capital markets, unquote. As we noted in our exceptions, the commission doesn't have jurisdiction over transmission facilities, so their costs are irrelevant to the determination of an adequate ROE for Delmarva's distribution operations. Second, the hearing examiner states that Mr. Gorman didn't take into account the full extent of the COVID-19 pandemic on the market in general and utilities specifically. That statement is flatly incorrect. Mr. Gorman did in fact account for those effects such as they were. The hearing examiner apparently overlooked his testimony on this issue, which appears at page 14. Furthermore, any market volatility in 2020 due to COVID-19 was reflected in the market data that both Mr. Gorman and Mr. D'Ascendis used to perform their ROE studies. The only evidence of market volatility was the VIX, it's VIX, but the hearing examiner apparently did not rely on that to support his finding, and that is not surprising because this commission has never relied on it either. Moreover, Standard & Poor's issued a report in January 2021, which was part of the record, observing that the utility industry had generally performed well through the pandemic, that lower deliveries to commercial and industrial customers had largely been offset by higher residential deliveries, that the industry generally worked well with regulators to defer COVID-related costs for future recovery, market returns improved, and the industry generally had consistent access to the capital markets. That same report attributed the weakening of credit quality in 2020 not to the effects of COVID, but rather to environmental, social, and governance factors, regulatory issues, and the industry's practice of continuing to manage its financial measures with little or no financial cushion from the downgrade threshold. So frankly, the effect of COVID on utilities was minimal at best. Regarding Delmarva, neither S&P nor Moody's downgraded its credit ratings. The commission approved the creation of a regulatory asset for COVID-related costs for its regulated utilities, and Exelon actually increased its dividend in 2020. Third, the hearing examiner stated that Mr. Gorman did not present a, quote, detailed, comprehensive analysis of the effects of bond investments, inflation, and debt investments on the relationship between equity risk premiums and interest rates, end quote. Again, we believe the hearing examiner overlooked Mr. Gorman's detailed and comprehensive testimony on this very issue. His direct testimony contains a lengthy discussion of why the claim that equity risk premiums are inversely related to interest rates is inaccurate. That discussion appears at page 74 of his pre-filed testimony. Specifically, he testified that if such an inverse relationship did exist, then ROEs should have declined to much lower levels than they actually have. But reductions in authorized ROEs have lagged behind declining interest rates. Finally, the hearing examiner stated that he considered other recent commission-approved ROEs, but he apparently considered only the approved ROE for Delmarva's gas distribution operations. We note that the commission approved 9.5% ROEs for Suez Water and Sussex Shores. So, while we do not accept to the hearing examiner's recommendations and believe that they are supported by substantial evidence, he did fall down in a few places in the analysis. So if the commission approves the 9.6 ROE, it should do, though, without the erroneous statements identified above. And you can get there by saying that you adopt Mr. Gorman's testimony and analyses, as you did in docket 09414, which gave primary consideration to the DCF's study results, and are exercising your discretion to increase the proposed ROE to 9.6 based on the results of his CAPM study. Thank you.
Thank you, Ms. Iori. Mr. Geddes.
Thank you, Mr. Chairman. Could I have the first slide, please? The next slide. Yeah, 294. 294, please. Back, I think. Yes, that one.
That's it.
I'll try not to repeat what Ms. Iori said, but unfortunately, we didn't coordinate on this. It's our joint witness, and she did not file exceptions to the hearing examiner's report. We did, because I don't think that, for several of the reasons that Ms. Iori quoted, the hearing examiner's analysis holds together very well. But by way, and I will go through these quickly, and I'm not going to take too much time. Obviously, this is the 09414 case that Ms. Iori referred to. Commission relies on DCF for 20 years, and Gorman was a witness, and I can say that in my long experience with the commission, I'll try to slow down. I can see those eyes. My experience with the commission, it's one of the few times that the commission has pretty much adopted one cost of capital witness's testimony. And of course, in that case, it was sponsored by DEUG. And the commission found Mr. Gorman's testimony persuasive and relied on it heavily in making its decision in that case. In the most recent litigated case, next slide, please. Next, thank you. Language, paragraph 264, confirm again, relying on the DCF. You consider other things, but you're not necessarily going to consider ROEs in other jurisdictions. Delaware is unique, and we analyze these cases based on factors that are pertinent to Delaware, not necessarily pertinent to other utilities in other states. Next slide, please. Thank you. This is one of the charts in Mr. Gorman's testimony that on a macro basis shows you what authorized returns on equity have been doing over the last few years. The litigated case 13115 was decided in August of 2014. You can see what's happened to interest rates, not interest rates, but returns on equity. Since then, I would point your attention to the end of the chart, which has the most recent information at the time Mr. Gorman filed testimony.
Mr. Geddes, sorry, Mr. Geddes, can you read the top max and then the min where you're coming down to, please?
Okay. This is authorized returns on equity, and the numbers on the far right-hand side are 9.47 and 9.40.
Thank you.
Next slide, please. This is the DCF results from using different ways of calculating DCF. the constant growth DCF, which Mr. Gorman used in conjunction with these others, was between 9.12 and 9.07. Next slide, please. So he concluded in his testimony that he thought a reasonable return on equity was between 9 and 9.4. Those should be 9.0 and 9.40%, and came up with 9.25. So 9.25 is his recommended equity. Next page, please. Now, Ms. Iori suggested that the CAPM gets you closer to 9.6, but in this analysis, it only gets you to 9.5, and that the DCF is lower as well, the risk premium based on Mr. Gorman's testimony. Last slide for this, please. So I won't repeat this. Ms. Iori picked up on most of it, but these are the 4 or 5 points that the hearing examiner made in supporting a 9.6. Our argument is he really doesn't tie his analysis to anything. He just sort of puts that out there and then says some comments about Mr. Gorman. So starting with Mr. Gorman, which is 9.25, look at paragraph 261 of the hearing examiner's report. Ms. Scott referred to this, but he says that he accepts Mr. Gorman's slightly higher DCF findings, which we reviewed, and that ROEs are difficult to determine. Everyone in this room who's an attorney will agree with that, and understand your witnesses is equally as hard. And then through the construction of new transmission. Well, as she suggested, maybe he meant something else, but that's not in the document, and speculating on what he meant versus what he said are different things. So I'm not sure that's a reason to support his 9.6. Ms. Iori hit on 263, which he indicates we didn't present detailed comprehensive analysis on the effects, as she indicated. Well, he did. Pages 39 through 40 of Gorman, and that's illustrated in the DPA's brief on exceptions on page 28. The next one, 264, Mr. Gorman recommended 9.5. Well, he didn't recommend 9.5. He recommended 9.25. So that's not as close to 9.6 as he indicates. And then the last one, which is, this is sort of a big one, because the hearing examiner seemed to put a lot of credence on it, but Mr. Gorman went through the whole COVID analysis, S&P, how he thought it would affect rates of return, utilities, and in essence still recommended 9.25. So our biggest complaint with the hearing examiner is that, as I always like to say, the breadcrumbs between 9.25 and 9.6 are a little hard to follow if that is the basis of the analysis, because most of it's incorrect. Obviously, 9.6 is a number that Delmarva, having filed for 10.3, and the DPA can accept. DPA with the caveat that these various isolated comments, remarks, or should be corrected, not relied on by this commission. But it's staff's position that we support Mr. Gorman's testimony. He's a qualified witness. He has had prior support by this commission, and we would ask you to consider his recommendation seriously as you try to resolve this issue. Thank you.
Thank you, sir. Ms. Scott?
Thank you, Chair Winslow. I would note that if you were inclined to simply go with witness Gorman's 9.25 ROE, you would be reducing Delmarva's current ROE by 45 basis points because it's currently 9.7. I would also note that, as Mr. Geddes would like to point out flaws with some of the testimony, Mr. Gorman certainly had some issues as well. I would note, for example, that in his CAPM analysis, he failed to use the 2020 yearbook to determine his high-M CAPM result. claimed he didn't get it in the mail, that's why he didn't use it. Somehow our witness was able to determine what it was and used it. But in any event, the impact of that was to increase the result to 9.9%, moving his ROE recommendation from 9.25 to a 9.45. And I think that's significant because that does take you closer to the 9.6 that we're talking about today. I think, in addition, there were a number of other things. Yes, Mr. Gorman has been a long-term witness in this field and has such stature. But, you know, our witness as well has had a number of years in this field and has been doing this for a very long time. We believe that while Mr. Gorman did look at the impact of the COVID pandemic, I think that likely he didn't look at it to the same level of detail that our witness did, because we did have a lot of information in our testimony about that, and also during the process of the proceedings before the hearing examiner. We spent a lot of time talking about that and what impact that we thought that had. You know, and Mr. Gorman claims that the ROEs are declining. We specifically pointed out that that was not accurate during the course of our proceedings. In fact, the analysis yielded no meaningful trends in terms of ROEs. The use of a 1986 to 2020 timeframe for analyzing returns for his risk premium analysis was not sufficient in our opinion. So we had a number of issues with respect to how Mr. Gorman arrived at his final results. And in terms of this overall, we think the hearing examiner got it right in terms of where he ended up, in terms of what he looked at. I think there is sufficient evidence here to determine that there's sufficient evidence to rely upon to determine that he, in fact, made the right decision in this case. Thank you.
Just a short rejoinder, because staff is taking the exception. Clearly, the commission can decide what the appropriate number is, but I would just tender that Mr. Gorman, if you do not believe 9.6 is the number, you could use Mr. Gorman's testimony, notwithstanding the shortcomings that I don't think are that significant. But anyway, to perhaps lower the number between 9.6 and 9.25. As we all know, this is the zone of reasonableness, and the commission has a lot of expertise on this issue, and you can use Mr. Gorman's testimony, should you choose to do so, to further reduce that return on equity, if appropriate. Thank you.
Thank you.
May I just briefly, sorry, I don't mean to prolong this, but at the same token, you could also look at increasing above what the hearing examiner recommended.
Ms. Scott, you didn't take an exception to the hearing examiner's report. Now you're suggesting that maybe the commission should go.
I'm just trying to make sure the record is clear about what the commission has the ability to do here. Thank you.
Thank you all very much. Commissioner Correa.
So we are working on, and am I correct, Mr. Gillis, that we are working from 9.25 to 9.6. Am I correct in understanding that?
I'm not sure I understood exactly what you said. Can I read it or give it back to you? Our witness is at 9.25. And the hearing examiner is at 9.6. My comment was there's a range there, and if the commission chooses to go below 9.6, there is evidence in the record to support it.
Yes, I understand that. And Ms. Ivory, you more or less agreed to 9.6 in the first sentence of your presentation?
Yes, we do not take exception to the 9.6 recommendation.
Okay. It seems to be like a most acceptable type of figure, 9.6 and what have you, right? For a capital intensive industry, and under the current market condition, which foreseeably future will be same, um, the rate of return or ROE is closer to 9.25. But if you're accepting 9.6 and then you are also concurring with that figure, and the hearing examiner also has the same thinking or recommendation, so to say. So the only difference in the calculation is Mr. Gorman's is using one method, right? And CAPM, Capital Asset Pricing Model method, is little more modern, like little more closer to today than discounted cash flow and what have you. So why is not Mr. Gorman accepting or working on different calculations or different models and different model out of those four pricing models, and work on that difference which you were saying it is very close to his, one of the methods was 9.50, which is close to 9.6 and what have you. Am I correct in understanding all these things?
Yes, let me try to give you a specific response to it. You remember this morning when I started out with 8222, which was decided sometime at a date because I didn't put the date on the order. But there was a return on equity in the order. It was 15.1%, relying primarily on the DCF. So the commission has relied on the DCF in, depending if you're a ratepayer or the company, good times and in bad, i.e. we went up the curve using the DCF, we being the commission, as interest rates spiked, as we all know who were trying to get mortgages or were paying mortgages during those days, and it has come down. And Mr. Gorman, consistent with the commission president, I believe, puts perhaps more stock on the DCF. But he did consider CAPM. I don't think this commission has ever relied exclusively on the CAPM to determine rate of return. And its primary and its focus point in most decisions starts with a DCF analysis, which I gave you, and then it moves depending on other factors. And so in Mr. Gorman's analysis, he did use a CAPM earnings premium on the one slide that showed, you know, the variation up to 9.5 using the CAPM. 9.4 DCF, 9 risk premium. I said earnings, I apologize, risk premium, and 9.5. So he did weight some of those. The commission can weight them differently, but I think if you're going to move away from relying on the DCF in this particular environment, I think it needs to be a little clearer than the way the hearing examiner analyzed it. Does that answer your question?
Yes, it does.
Thank you.
And you
Thank you.
explained it well. And I agree with you that most companies or most calculations are still on DCF. So discounted cash flow is an accepted, commonly understood technique of calculating the rate of return or rate on equity.
Well, it's better than using the price of Bitcoin, I guess.
I move that the commission accept the hearing examiner's recommendation of 9.6 with the changes as suggested by the DPA. The breadcrumbs will be as suggested by Ms. Scott, and also some of the evidence of Mr. Gorman, any other economists involved.
I second the motion.
Any discussion on the motion? Hearing none, Commissioner Gray.
The breadcrumbs, I'm just confused a little bit. Maybe it's getting late. I completely agree with the motion that we're adopting 9.6. I'm not sure the conditions that you stated otherwise, Mr. Chair.
Well, I stated them, and I guess if you have others you want to state that will buttress that motion, I'd appreciate it. Otherwise, I'm content to leave it the way I said it, stated it.
Okay, that's fine. Yeah, I would support that as well. I think that the landscape, you know, we've got some things outside the record coming, maybe the infrastructure bill are going to impact this, so there's a lot of guesswork on the table. But I think that there's a lot of homework underneath of the recommendations that are here from the hearing examiner, so I'm supporting your motion, Mr. Chair.
Any further discussion? Hearing none, all in favor signify by saying aye.
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 Are there any opposing? Any abstentions? The motion carries. I believe we're on the residential monthly charges is next.
I believe it's
Did I skip one?
Billing determinants.
Yes, Your Honor.
Billing determinant. I was eager to get out of here, I guess.
You've only got 3 to go.
We're close.
I know.
We're doing good.
Very
Does
close.
that mean the other matter was settled?
No, we'll come back to that.
No, we have to come back to that.
Fortunately not.
All right, 4 to go.
Somebody start.
All right, well, I'll start.
What page are we on, people? 36. Okay, billing determinants,
36.
I guess, Ms. Scott again?
Yes. Thank you, Chair Winslow. The DPL accepts as an CEPTS to the hearing examiner's recommendation in this regard. And the reason we do that is because with respect to billing determinants, and the decision here was as to residential billing determinants only. From the company's perspective, when you're looking at the billing determinants, and in particular revenues at a class-specific level, it's important to look at all the customer classes at the same time and not just a subset of these classes. Some classes could have growth, while other classes may have decline. And we just, from that perspective, we believe that it's important to continue to use the practice that we have used, which is to look at the billing determinants for all the classes for the same period of time, rather than take one subset out, which is residential, and use the most current for residential only.
Thank you very much. Ms. Iori?
Thank you, Chairman Winslow and Commissioners. Delmarva's argument comes with more than a little ill grace on this. We asked for the information for all the customer classes so that we could make a decision on that. And Delmarva didn't have the information for all of the customer classes. That is the only reason that we limited our adjustment to the residential class. Had we had all the information, we would have made adjustments for all of the customer classes. Now, billing determinants is just a fancy public utility industry way of saying customers. And Delmarva used billing determinants or customers that didn't match its test period in this case. As you've heard today, its test period was the 12 months ended March 31st, 2020. But it used billing determinants or customers for the residential class for the 12 months ending December 31, 2019. The DPA argued that the commission should use Delmarva's actual numbers of customers for the class during the test period. Those numbers were available to Delmarva during the course of its case, and in fact, the DPA used them to calculate its own adjustment. The purpose of a test period is to evaluate cost of service, rate base, and revenues at the same time. Using billing determinants or customers from a different time period skews the analysis. And that's certainly what happened here. Delmarva used significantly fewer residential billing determinants, that is, customers, at the end of December 2019 than it actually had at the end of March 2020. Now, Delmarva has contended that the commission has not historically required Delmarva to update its billing determinants, and requiring them to update them to actuals would create a moving target. But as we've discussed earlier here, we see that it has updated some rate base and O&M expense items to actuals. But the fact is that the commission has not addressed the issue. In this case, Delmarva submitted 8 different pre-filed testimonies in this case that discuss the billing determinant issue, and not one of them cited a single commission decision blessing the company's practice. Secondly, Delmarva's very own witness on this very issue stated in his pre-filed testimony that, quote, "As-billed electric delivery billing determinants should be adjusted for any known and measurable billing determinants that are likely to occur in the rate effective period." I've included the pertinent pages from Mr. Norman's pre-filed direct testimony in the package. It's the next to last tab, and it's page 8 of his testimony. That admission alone belies all of Delmarva's arguments and complaints about the DPA's position and the hearing examiner's recommendation. The commission should hold the company to its own witness's testimony. The DPA is not suggesting extending past the end of the test period in this case, let alone going out into the rate effective period. We are simply saying that the billing determinants or customers should be those existing at the end of the test period because they're actually known and measurable. And the DPA respectfully submits that the hearing examiner's recommendation be approved. Thank you.
Thank you, Ms. Iori. Mr. Geddes, no position?
No position, Mr. Chairman.
Ms. Scott?
Thank you, Chair Winslow. Again, the hearing examiner's recommendation was with respect to residential customers only. And again, our position is that you just can't look at this as a subset. You have to look at all of the classes together, all at the same time, to determine how the billing determinants should work in order to determine the revenue impacts. And that has consistently been our practice as we have done rate cases over the years. Agreed, there is no commission decision on this anywhere because I suspect the issue has never come up. But this is consistently how we have done this particular adjustment.
Thank you very much.
May I have one brief rejoinder? The issue has come up, but Delmarva has had the information to provide to us. So it hasn't been an issue in a case because we were able to confirm that, confirm the information for all of the rate classes. In this case, Delmarva did not have the information to give us for the other customer classes. And frankly, it's a little bit of a, most of Delmarva's customers are residential. Delmarva Electric has, about 320,000 customers, and 290,000 of those are residential.
Commissioner Gray, did you have a question?
Well, it sounds for me as though one argument is about the date range and the other argument is about the completeness of the customer classes. But in principle, I would lean more toward the accurate information if it's known and measurable, Mr. Chair.
Make a motion, please.
I move that the commission adopt the hearing examiner's recommendation.
I second.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
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 Are there any noes? Are there any abstentions? The motion carries with one absence. I believe the next is the residential monthly charge. And on this, I think we should have Mr. Jordan speaking.
That is correct. Thank you, Chair Winslow. This is the residential customer charge, and Delmarva is asking that the commission adopt the hearing examiner's recommendation approving the company's proposed fixed customer charge. The current customer charge is $11.70. That was last changed in 2013, several rate cases ago. And with this case, the company seeks to change that charge to $13.49, which is a $1.79 increase or 15.3%. When it was changed in 2013, the customer charge went from $9.35 to $11.70, which was a $2.35 increase or 25.1% increase. With this charge, what the evidence was that the hearing examiner heard is it's necessary because currently there are these intra-class subsidies that exist. And among these residential classes, an above-average use customer is currently subsidizing these below-average use customers on the recovery of fixed costs that are located closer to the customer premise, meters and services, for example. And so the company's proposed change in this customer charge would go towards relieving those subsidies first. And it would do it much better than what the DPA has proposed, which is just a 21-cent increase. And part of what the DPA argues in this case as a reason for this 21% increase is based on a list of various Delaware laws that have been passed over the years that the DPA believes this customer charge is inconsistent or contradictory to Delaware's energy policies. And the second exception has to do with the various customer charges that exist in some of Delmarva's sister utilities. And I believe that Ms. Iori included a graph here on her last page. The problem with both of those arguments is that there wasn't any other evidence that connects them or provides any kind of cause and effect relationship and how they apply to the customer charge. So, for example, with this chart that Ms. Iori provided, this is what the hearing examiner had. This is just a list of raw numbers. There was no evidence showing that any of these jurisdictions are similar to what we have here in size of, in terms of size of geography, size of customers, and so on. Same thing with the laws on the energy policy. There was no witness, no evidence presented to the hearing examiner that would tie the customer charge as it currently exists or any of the increases to any state energy policy, any violation of any energy policy, or any of the other theories that were floated during the hearing. Another one of those was the effect it would have on lower income customers. And Delmarva's witness, Lance Schaefer, testified that in his experience in other states, there was no connection, in fact. That was not rebutted. And that's the problem, the underlying problem with the DPA's exceptions is that there was never any evidence, then or now, connecting these to the monthly charge. On the other hand, as I mentioned in the beginning, there are these intra-class subsidies that need to be resolved. It's been 8 years since this customer charge has been increased. Mr. Normand for the company testified that this is pegged to inflation. And in fact, what the company has asked for and the hearing examiner has recommended is a smaller increase than the last time, both in terms of numbers and percentages. And with all of the evidence in favor of that, we believe that the hearing examiner got this one correct, and we ask that the commission adopt his recommendation.
Thank you, sir.
Thanks.
Ms. Iori?
Thank you, Chair Winslow and Commissioners. I'm going to go, if this sounds disjointed, I apologize because I'm going to address some of what Delmarva's counsel had said there's no evidence of. First of all, there is evidence of where these sister utilities are located. They are in the Mid-Atlantic. They are Atlantic City Energy. That's in New Jersey. They are PECO. That's in Pennsylvania. They are Delmarva, Maryland, and Pepco, Maryland. They're in Maryland, and there's Pepco, DC. So they're in the Mid-Atlantic. Secondly, the issue of you don't know how much it costs to serve each customer, so you can't rely on any of these. I would suggest to you that's a red herring. It depends, certainly Delmarva's rate design took what they claim to be the cost of serving a customer and extrapolate from that. But in their case in Maryland, they had the same $20+ customer cost of serving customers. So, there's evidence, and that was in the record. So there is evidence of that. Third, I don't think you need an expert witness to tie the fact that an increased unavoidable residential monthly customer charge will have a negative effect on customers who may try to, otherwise try to reduce their usage or to invest in energy efficiency. Why should they? If much of what they are doing is unavoidable anyway, there's no incentive to, spend good money investing in energy efficiency or to even try to reduce your own usage. Moreover, as I said, you don't need an expert to tie Delmarva's energy policy to, Delaware's energy policy to Delmarva's customer charge. Delaware's energy policy is very clear. Investments in energy efficiency, energy affordability. Excuse me. And I beg your pardon, and conservation. Those are all in the statutes that we identified. Those are what the General Assembly found as goals to which Delaware they want Delawareans to achieve. So, the hearing examiner seems to have based his recommendation on the following. Delmarva's testimony that its class cost of service study demonstrates that the cost of serving customers exceeds $20 per month. 2, that Delmarva has not increased its customer charge since docket 13-115. 3, Delmarva currently recovers 88% of its revenues from volumetric charges, which sends a strong price signal to customers. And 4, an unsourced statement that customer usage and sales are declining as a result of energy efficiency, net metering customers, and conservation. Increasing the fixed monthly customer charge sends the wrong signals to customers and is inconsistent with state energy policy. And it's also too high, as shown by the comparison to its sister Mid-Atlantic utilities. Don't be fooled by their $20 per month customer cost calculation. That calculation contains many costs that the DPA argues should not be assigned to the customer function at all, or if they are assigned to the customer function, should be in a lower percentage than Delmarva actually assigned. While the class cost of service study is a starting point, it's not the sole consideration. There are other considerations, such as public policy considerations. And we've identified those public policy considerations as reflected in Delaware statutes. Higher unavoidable customer charges discourage conservation and investments in energy efficiency, and they also shift a larger proportion of system costs to lower volume consumers who just happen to be residential and small business customers. These are also exactly the customers that have been hit hardest by the pandemic. The DPA believes that the Commission's policy should be customers who use more energy should pay more. That can only be accomplished if more revenue is recovered through the volumetric charge than through the unavoidable fixed monthly customer charge. Finally, the last tab of your package contains 2 charts that we prepared from the record evidence and was included in our exceptions. The first chart shows each utility's fixed monthly residential customer charge, and every one of Delmarva's sister utilities, except for Pepco DC, has a lower monthly residential customer charge than Delmarva. And Pepco DC has riders that provide credits to low-income resident or customers, seniors, and disabled customers that in many cases eliminate the monthly customer charge for those customers. Delmarva doesn't have any such riders. And all of those utilities' fixed monthly residential customer charges were approved long after this commission approved Delmarva's current residential customer charge. The second chart shows how much Delmarva collects in a month and a full calendar year from customer charges alone, compared to its sister utilities, using 290,000 customers, which is the approximate amount of Delmarva's residential customers, as the basis. And we would suggest to you that these charts demonstrate that Delmarva's fixed monthly customer charge has been too high for far too long and should not be increased at all now when so many customers are struggling. Finally, we note that although the company's cost of service study in Maryland produced customer costs almost identical to those produced for Delmarva, over $20 per month, Delmarva, Maryland only asked for a 50-cent increase in its customer charge, and the commission adopted the hearing examiner's recommendation in that case, the Maryland Commission, to reduce even that to a 21-cent increase. Delmarva says there is no record evidence supporting this, but there is. The record supports anywhere from the zero increase that the DPA recommends to the $1.77 that the company recommends. Now, it has been said that rate design is an art and not a science. It is wholly within this commission's discretion to determine whether an increase in the unavoidable residential fixed monthly customer charge should be approved at all, and if so, the amount of such increase. The DPA respectfully submits that no increase in the residential monthly customer charge should be approved, and the hearing examiner's recommendation should be rejected. But if the commission believes that any increase is warranted, we would ask the commission to limit it to the same 21 cents that the Maryland Commission found warranted on customer cost evidence that was nearly identical to the evidence presented here. And lastly, Mr. Jordan referred to unrebutted testimony from a witness. As the commission knows, we don't get the opportunity to file rebuttal testimony, so there wasn't much of an opportunity to rebut it. Thank you.
Thank you, Ms. Iori. Mr. Geddes?
I have nothing on this issue, thank you.
Thank you. Briefly?
Yes, thank you, Your Honor. A few points. One of the things that Ms. Iori had mentioned is the study, and what that showed was that the actual costs that are involved here, $20.55 per month for residential non-heating customers, and $21.63 per month for residential heating customers. And I agree with Ms. Iori that that does not determine the rates, but as the company's witness testified, that helps inform the number that we're seeking here, this increase to the $13 and some change. And one thing that the commission did not hear, and the same thing that the hearing examiner did not hear, is how to resolve these interclass subsidies that currently exist. And the only way to do that, based on the evidence, is through this increased customer charge. There was no evidence, no witness who testified about price signals on behavior or anything of that nature. And that's an issue if you're going to say that a charge or an increase is going to change behaviors. There was no testimony on that, at least not that supported the DPA. When I mentioned unrebutted testimony, I was speaking about the live cross-examination that Ms. Iori conducted on Mr. Schaefer, in which he had testified that in his experience in other states, there was no connection between low income and energy consumption or behavior. And that was not challenged. There was no contradictory evidence to that. There was the comment, too, about what was happening in Maryland. That's a 3-year rate plan. That's not what we have here. And I appreciate where these places are located geographically, but again, what we don't have are the evidence showing that these jurisdictions are similar in terms of policy, in terms of the number of customers who are out there, or even what those customer class studies are. And so when all of that gets put into the blender, what comes out of it is the hearing examiner's recommendation, and it is the correct recommendation, and we would ask that the commission adopt it as recommended. And that would, as I said, would change the customer charge from $11.70 to $13.49, the first time in 8 years and less than the last increase. Thank you.
Thank you. Commissioners, any questions? Mr. Gray?
Yes, just for clarification, I think I heard that the driver from DPL, the goals here are to correct for the interclass subsidies. Am I correct?
That is, yes, Your Honor. So one of the things, some of the evidence that was produced during the hearing, and I believe this was from Mr. Normand, although it may have been from Mr. Schaefer, is that you've got these intra-class subsidies that currently exist. And the reason for the change here, the increase, is to try to get those subsidies resolved.
Okay, just wanted to make sure that I understood that. I'm a little concerned with the increase in the fixed cost to residential customers at 15.3%. I don't remember hearing earlier in our considerations what percent inflation driver the company was going after, which the commission rejected, but does anybody have that figure?
Yes, it was 1.03%.
Okay, so if the company was interested in that type of a range, I would be more amenable to applying that percentage if you're looking at an increase on the ratepayer. So that's just my position in terms of the way I'm looking at the issue. Mr. Chair, I have no further comments or questions.
My only comment to Mr. Commissioner Gray is that the 1.03 was forward-looking, wasn't it? Not backward-looking, and we've gone 8 years without an increase, so I'm not sure how that logically plays into this particular situation.
Well, point of clarification.
That wasn't a question. That wasn't a question. I'm sorry, Ms. Iora.
Sorry.
It's after 5 o'clock, so we're not as nice after 5 o'clock. So,
That makes an
my-
assumption about earlier than 5.
I mean, there's no makeups for unrecovered costs that weren't previously recovered. So that sounded like that's kind of where you were going.
No, not really, not really. I'm concerned about the increases too. I mean, in energy policy, you bring up good points about energy policy, but, this customer charge has been around for a long time, probably before most of the energy policies of the state of Delaware. We've had quite a few energy policy changes in the last couple of years, and this commission and the DPA has successfully gotten changes made in the legislature. This hasn't reared its head as to be one of those things to be considered by the commission as something of merit to send to the legislature. Perhaps that's something you should do to make sure that we have to take that into consideration in future cases with respect to this issue. But if you haven't had an increase in 8 years, that's over 8 years, that's 15.3 is under 2% per year. So I don't know what the inflation is. It's probably not in the record anyway. I'm sure it's not in the record. Just my comments and thoughts. Yes, ma'am.
I'm looking at the chart that you provided, Ms. Iori, and this is page 39. And I'm really having a hard time with, apples to apples here. I understand there are separate variables, but, we're already at the high end. You're looking at, for example, PECO, $10 a month approximately the same amount of customers. So annually, $34 million from this charge. You're proposing here $13.47. That's $46 million. That's 30% higher in a flat rate. And I'm having trouble determining why it's 30% more expensive for fixed monthly costs for Delaware customers than PECO customers, right over the border. Equally, you can look at DP&L Maryland, same sort of numbers, and they're at 851. It's a really big number compared to our neighbors. And I think explaining that to Delmarva customers is going to be difficult because it is so much higher. I mean, we're talking about over 30% higher than PECO on a monthly basis. So those are the numbers I'm having a hard time getting my arms around. At 46 million versus the next highest collection of 34 million, with a with an equal number of clients or customers, and so that's a troubling situation for me.
I have questions also.
Commissioner Korea.
You had mentioned that it is 8-year increase. The last increase was 2013.
Correct.
Now it's 21, so 8 years. My question is that what took you, Ms. Delmarva, to go that long? If you were losing money on the fixed cost, then wouldn't you have come 4 years, 5 years, or what have you? And that doesn't, I can't understand it, number one. And number two is that consumers' behavior is affected by the fixed cost. You mentioned that you have not seen it, or the evidence is that consumer doesn't change because the fixed cost has gone up. But consumers are not very reactive, and they accept things. Say, okay, what can I do? I'll pay. That kind of a thinking is embedded in most of the consumers, unless you are really, really counting pennies. And they know that it is out of their hands, so to say. And that will change if you cross the limit. Like up to certain point, they will say, well, what can I do? What can I do? And then when you go to $13.49, maybe that will change, and because you are on the top of the curve or line rather than below the line so far, and what have you. So why? And then, the apples to oranges comparison is not there. It is all mid-Atlantic. Atlantic City and Maryland and Pico, and they are like right here. So those are the 3 points which I have very, very hard time to understand.
Thank you, Commissioner. Let me start with the first one about the length of time since the last increase, because there have been rate cases that have been filed, but they did not get litigated. There were settlements, and it's my understanding that this would have been considered a bargaining chip that would have been used during these settlements to hold off on this in order to get something else. And the next settlement, well, let's hold off on this so we can try to resolve this issue. And so it was an issue that did not get, I would say, well, litigated until this case. So in between those two litigated cases, there were these settlements. There were the settlement negotiations where, as I mentioned, you give a little, you get a little, that sort of thing. That's my understanding as to the length of time that it would take to get something like this. The second one about the consumers' behaviors and that sort of thing, the difficulty I have here, and this is more of a process question with what was presented at the hearing, there was no study, there was no document, there was no testimony from a witness who could say, for example, the current $11.70 customer charge is more likely to lead a consumer to do this. And if you raise it to $13.49, a customer is less likely or more likely to do this. There just wasn't, that evidence was not presented. What was presented was the testimony about the current intra-class subsidies, where you've got one paying for another, that does exist, and that this customer charge would go towards equalizing or resolving that issue. The last issue, Your Honor, about the geographical location of these, I'm with you. I mean, I get that. I know, I'm born and raised in Delaware. I know that these are all, touch our borders. But that's not enough, because you've got to be able to show, if you want to make the argument that Delmarva Delaware's residential fixed monthly customer charge is higher than others, that's fine. If you just look at these numbers, but that doesn't prove the case. Because you've got different sizes, you've got states with different policies, different regulations, that sort of thing. And what we missed here was something saying, for example, PICO is just like Delmarva because X, Y, Z. They have the same this, and this. And if that's the case, then Delmarva's customer charge should be lower, and because we have PICO to compare it to, we have a benchmark. Again, just presenting these numbers like this does not tell the tale, or, as I said, does not create that cause and effect relationship to say one thing is like another. This causes this. We can compare Delmarva and PICO because of these similarities. The only similarity we have, these are sister jurisdictions, they're nearby, and that's part of the puzzle, but that doesn't get you to the end of it. And so that's the problem that we have here, is DPA did not present the evidence saying, here's why you should treat Delmarva like PICO. Here's why you should treat Delmarva like Atlantic City Electric.
Mr. Chair, may I?
Yes, sir, go ahead, please.
I have a question for our counsel, please, Bill. In this matter, must the commission up or down these options in front of us, or do we have the flexibility to make a recommendation for a different margin of increase?
You do have discretion to set your own level of the fixed customer charge. You would need to point to evidence in the record in order to get to that, in order for it to be supportable from a legal perspective. But you aren't tied to the positions in front of you. As long as you can support your decision with record evidence.
Thank you. I want to ask my colleagues, because I heard it stated earlier from one of the other testimonies, that the baby was split, if you will, down the middle. And I'm just curious to know if that 15% could be split in half, and if my colleagues would support that. Driver is of concern for that one margin of increase on top of the ratepayer for fixed fee, as well as the testimony from the public advocate with respect to motivating efficiency, affordability, conservation with respect to energy usage.
I would support a figure less than 15.3%.
I also would support that one. I think that splitting comes to $12.70. Our accountant can work it out, but I think it's $12.70.
I got 12.58. I don't know.
Good.
Can we split it?
Help me understand how you got your numbers, because I don't understand your math.
I took Miss Ivory's figure in 1191, 20 cents increase, and I took Delmarva's figures 1170 to 1314. So 1191 plus 1349 divided by 2.
Okay, I'm sorry. You were speaking in dollar units. I was looking in percentage units.
Oh, okay.
I understand you now.
Yeah,
So,
yes.
so
Understand.
splitting it would be $12.58. If you split the $1.77 difference.
Your Honor, I believe it's $1.79, not $1.77.
And a half. I get 88.50, and if you take 88.50, you're going to get 12. You're going to get 1258.50. Did I say 1260?
I have a calculator.
Yeah. That's 88.50.
May we go off the record for a minute?
Yes.
I thought your request was 1347. Is it 1347 or 1349?
49.
49.
Okay, then there was a,
Okay, I'm using your.
then there was a typo
Sorry.
in our, okay.
Because I'm using your bad number.
Sorry.
Sorry about that, Mr. Jordan. I was using a bad number.
I'm sorry. Bad typing.
I move that the hearing examiner's recommendation be approved at 50%.
Great.
And that the reasons therefore are those stated by Ms. Ori in her presentation, both oral and written.
Clarification, Mr. Chair. The amount of the increase is 50% of that recommended? Is that what you're saying?
That's correct.
Okay, thank you.
We need a second, hopefully.
Sorry, I second that motion.
Is there any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Motion carries with one absent. Okay, I think that we have a staff discovery proposal on the table, and I would just say that I would agree with, I move that we agree with the hearing examiner with the understanding that the staff is directed to consider the issue resolving or revolving around discovery issues at the hearing examiner level, and to come up with recommendations to the commission to expedite those matters so that matters aren't delayed and information gets provided to the parties who require it.
Could I be heard on this, or not?
Absolutely. I'm just putting a motion on the table, then we can discuss it.
And if I could be part of the
It hasn't been
discussion?
seconded yet.
It
I'll
is getting
second-
late, isn't it?
I'll second your motion, Mr. Chair.
Okay, now everybody can talk about it now.
Discussion.
Go ahead.
I just wanted to point out that perhaps the hearing examiner didn't like our proposal, but we also indicated that perhaps this should be taken up in the minimum filing requirements
MFRs, yeah.
that are being worked on, because I just want to make this point. The company has a burden of proof. Everyone agrees with that. You heard today a lot of problems with discovery and getting information. The problem with the way it's set up now, if you don't like the information, they have the books and records, we're trying to get it, then we have to file a motion. So the burden's on us to prove that it's ineffective. And I think that needs to be addressed in the minimum filing requirements and an expedited way to resolve the issue.
And all that obviously is incorporated within my motion.
I'm very happy to hear that.
Which
Now-
process the company would be able to comment on as
Correct.
in any other fashion,
We
so.
would value the input from the company, absolutely. Anybody have any discussion on the motion? All those in favor signify by saying aye.
Aye.
Any opposed, any abstention? Motion carries, one absent. And we have one issue left. Mr. Geddes is the person who's going to resolve this issue for us.
All right, well, for some of you will recall that at the conclusion of the last litigated case, we sent Ms. Iori scurrying back to type us up an order, a minute order, so that the rates could go in as soon as possible. Anticipating that this might be the same request this time, staff's in a position to circulate, which has not been seen, but it just spins off what was done before, a minute order. The only problem with it is it doesn't have any numbers, so it's not particularly useful in its current format. I would propose is that the parties break, we spend the overnight recess to work on the numbers, and that we try to get something to you in the morning that has the exact numbers based on what occurred today, and that virtually one commissioner is, well, in reality, one commissioner is here, and the rest of us could potentially participate in a Zoom call or by telephone just to verify it, and the commission could vote on it, consistent with the governor's instructions as Secretary of State or whomever.
Mr. Hardigan, do you agree that that can be done tomorrow morning?
And we have the 2-2 thing, too.
Well, I was going to say,
We-
can you even do rates without that issue being determined?
I jumped the gun. I
was going to
apologize.
suggest that we still need to revisit the E EDIT balance issue on which there was an earlier 2-2
I agree.
vote
I misspoke.
before we conclude.
But now you have my second position after you resolve EDIT. I forgot about E EDIT.
I think we do need to resolve it.
And if I may, perhaps I could add another fact here which might help with a
Please.
renewed vote. As you all know, Delmarva's position is that you should adopt the hearing examiner's recommendation to reflect the actual tax savings that the company has received as a result of the TCJA. Commissioner Gray, your concern, as I understood it, was about process.
That's correct.
And during the break, I took a look at Exhibit 63 in this case, which is the settlement agreement from the case where the values were put into play. And all of the parties that signed on to that agreement, staff, DPA, Duke, and Delmarva, are all present and participating in this case. And so I think there need not be a concern that somebody is left out without an opportunity to comment. Duke did not contest this change. DPA did not contest this change. Staff is the only party that raised the issue. And so with that, I would again respectfully submit that Delmarva should be permitted to use the actual tax savings in place of the estimates.
Thank you very much for that update, Mr. Geddes, for staff.
Our position is as articulated before. The fact that the parties are here has little relevance to the give and take that was negotiated several years ago. Staff did have a laboring oar along with the DPA in trying to hammer out this agreement, and staff is not prepared to change what it thought was settled numbers. Thank you.
Okay, but there's no controversy with respect to the process issue that I was
I'm
just...
sorry, say that.
There's no disagreement with the update on process as submitted by Ms. Schultz? Or the members present?
There's no dispute that DUG, DPA, staff, and the company are here today.
Okay, thank you. That's good.
That is different than what I just said about the process. Thank
All
you.
right, Ms. Iori, you have a comment?
I guess I just have a perplexed look on, we didn't take a position on this, but I guess as I've heard, both sides talk, the DPA was a party to that agreement too, and we negotiated things in that agreement. Everything went together, and if one piece of it gets changed, that affects the other pieces of the agreement. And so I guess that and there was a specific provision in the agreement that if any party wanted to change, if the commission had to adopt it in its entirety, and if it didn't, all bets were off. So changing it now, I kind of see as problematic.
Do you see, are you saying to me that you empathize with my process concerns here?
Yes.
Okay, thank you. So I've got two separate opinions on that matter, still standing in front of me right now.
Well, respectfully, Commissioner Gray, I would also just remind the commission that, as you've stated earlier, regardless of what the settlement agreement says, the commission retains the authority to modify a term of that agreement. All of the parties are here in this case, and this is an issue that has been presented in this case that is before the commission properly and upon which the hearing examiner has made a recommendation. There is nothing that prevents this commission today from stating what this number should be in this case.
No, that's completely inaccurate. What happened, what the final order of each commission, or what the final paragraph of each commission order says is, the commission reserves the jurisdiction and authority to enter such further orders as it may deem just and proper. That was also in the order that the commission approved the settlement agreement. But the settlement agreement itself contained a provision that said if the commission did not approve it in its entirety, that it was that it scotched the deal, basically. So
So-
what the commission would be doing now by unilaterally changing a term of the agreement that, I'm going to say DPA didn't agree to, to change that term, that whole settlement is scotched.
I would also remind the commission that DPA did not take any of these positions in this case. This is the first time
Well,
that
we're-
DPA is taking a position with respect to this issue. I respectfully don't think that it's the right, it's not an issue that's been briefed and argued. Perhaps it's a question for your counsel as to the authority
That-
you have, but hold on, Mr. Geddes, I'm almost finished. But I think the critically important issue here is this is properly before the commission. In this case, you can make this decision. All of the parties are present and accounted for. And by agreeing with the hearing examiner here, you are being consistent in the actions you have taken throughout the day, which is to use actual numbers where they are available. And this is simply flowing through tax benefits that are actual to the customers.
So
have to
Mr.
respectfully
Geddes, just a
disagree.
second,
Mr.
please.
I
Just a second.
apologize.
I understand the principle. I am not yet comfortable with the process. I hear different points of view coming from different parties in the matter, and I don't think we came here specifically today to unbundle the agreement that now is under discussion.
And if it had been appropriately presented to you with a motion, with the opportunity for everyone in writing to give you our thoughts on cases, precedent, and whatever else was relevant, you'd be much more informed. As I've said many, many times, our obligation on this side is to give you the tools to make the best informed decision. And I don't think that you have those tools, and I am sorry that you do not. It should have been brought before you on a motion. It should not be in front of you this way.
To be fair, I think there's been a very full opportunity for all of the parties to advance their positions on this issue throughout the pendency of this case. And if the commission would like, I could make an oral motion at this meeting presently to have this commission reflect the actual costs of the tax savings, if that would be
Okay,
helpful.
I think we've had,
And
I
I
think we've had
will
enough.
ask for an opportunity
we've
to
had enough
respond to that in writing.
I think that we have had enough discussion on this issue. My perception, and it's only a perception, is that the reason we're having this argument back and forth is because of the manner in which this issue got to us. I don't think there's any process issue at all. I mean, we're here, and this issue is on the table, and people have been able to discuss it. If the staff didn't have their backup, because they were upset about how the company comported itself in this situation, we wouldn't even probably be having this discussion, because you would have amicably resolved it, and life would go on. So my experience over many years is that lawyers can get themselves in a turmoil over these issues, and sometimes, and I agree in this case, I don't have any problem with Mr. Geddes getting upset. And I'm sure that the company didn't intend to cause any problems, or they had no nefarious intent, but we do have that elephant in a room, and that seems to me to be driving this issue. And my position is we should make the correct decision, which in my humble opinion is to let the company pay what they're getting back and correct the mistake that was made by all the parties at that time. But of course, my feelings didn't seem to prevail, so we've got a 2-2 here. So my question is, if we were to take this out of this rate case and permit you to file a motion and resolve this, would that resolve the issue for all the parties?
Respectfully, I don't think that would make a difference. I think that would be inefficient and a waste of resources, because we would make the same arguments, we would have the same discussions, and it's probably before you today. I would respectfully ask that perhaps we could take a second vote and see if that gets us anywhere.
Your Honor, I would just like to disabuse you of the notion that there was a mistake made. There was no mistake made. And we did not make a mistake by settling on that number. We settled on that number because of give and take on other things. We made no mistake.
So, just to follow up briefly, if you did pull it from, because I was thinking about that as an option when you suggested it, and it came before you on a motion, we could adopt all these same things that we've said, you might have 5 commissioners.
Right, exactly. That's what I was thinking. And Ms. Iori, you know, I don't think that the parties came up with the correct tax number. That's all I meant.
Okay, I was gonna say, we did, well, that's, that wasn't part of the negotiations. The negotiations back and forth were to get to a final number that everybody was comfortable with in that docket. We got there by doing this and doing that, and no, I don't like this, no, I don't like that. All I'm saying is there was no mistake. There was no, there was no requirement, for lack of a better word,
So you
that
have,
numbers be exact.
so you have no opposition then for a motion being filed?
Oh, no, I'm going to oppose it.
Okay, okay.
No, I
Okay.
will oppose the motion to
Okay, then
amend.
we're here. We're here until someone, I guess, wants to change their vote.
No, Mr. Chair, I would recommend on this matter that this would be tabled. I'm not
I'm
prepared to
sorry,
change.
I think maybe you might have misunderstood me. When I said I would oppose a motion to amend, I mean when it is filed.
Yeah, no, I think that the chair is asking if there's anyone here prepared to change their vote the way we have already voted on this matter. And from my standpoint, I would say no. I'm uncomfortable that the full story is not on the table by all of the parties, which is my process issue to begin with. So I'm not prepared to change my vote.
Okay, so we're in a stalemate. I'm willing to, if it doesn't have any repercussions in the actual rate case, and I don't know that it does, but I'm willing to support the idea that this go its separate way and go through a routine process to have this issue decided outside of the rate case.
You want to say it?
Is there opposition to that?
No, no, I said I am not opposed to that procedure. That's what I was trying to make clear.
Okay.
I am not opposed to that procedure.
Okay, fine. that's
And
good.
neither is staff, because I think with 5 commissioners, you perhaps can come to a better resolution than a 2-2 tie and then forcing somebody to try to change their vote. Also, there may be some additional information that makes the decision easier for the commission. But it's a difficult one in the current status that we are at. And I think it can be pulled from the right case, and we go on and deal with it on a motion.
Doug wouldn't be opposed to that procedure either.
I mean, it seems to me that we don't really have another option. I don't think there's going to be a vote today that is going to be able to resolve this issue. And so if it has to proceed by separate motion or be taken out as a, quote, phase 2 of this case, however the commission wishes to do it, I guess that's what needs to be done. It's unfortunate, but
Okay, I move that the matter be severed and that it goes forward by properly filing a motion with respect to this issue, and it'll be heard in due course and come to us appropriately, and we'll make a decision.
I'll second that, Mr. Chair.
Yes.
Any discussion on the motion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. We will reconvene in this room with Chairman Correa as the chair, acting chair, at 10 o'clock tomorrow morning. Other commissioners may appear by Zoom. I mean, not Zoom, but
Just telephone.
telephonically.
Telephone would be fine.
Now, I hate to, first of all, I said 10 a.m., that might not be a time. I don't want to put you guys under a gun. If 11 o'clock in the morning would be better, I mean, 1 o'clock in the afternoon. We're scheduled to be here all day tomorrow.
Chair, just point of order, what do we have left? Is this the last issue?
All the issues are resolved, but they now have to put it in the calculator, and it's not as easy as I said of pushing a button on this particular.
Okay, so just so everybody's on the same page, what you're expecting is that they would come forward tomorrow with a minute order reflecting all your decisions, and on the decision that wasn't made, and I'm just throwing this out there, it sounds like the $900,000 difference would not be in rates for the minute order until it comes forward on a more appropriate procedure as discussed. And then at that point, if you side with the company, then rates would be changed again to reflect the removal of the $900,000.
Point of clarification. My understanding of it is that the issue is not resolved in this case. The settlement agreement remains in effect until it's modified by motion. So it's not being approved, I'm sorry. But it's still there. It's just not going to be decided in favor of the company at the moment. It's still in the case. The numbers are still the same. A motion's going to be filed by them. We are going to consider it and bring it in front of you as to whether the settlement agreement should be modified to the actual tax returns filed in 2017.
That's how I described it also. If you want to keep going tonight on that issue, you can always ask me my opinion on this from a legal perspective. My colleague here is urging me to weigh in, but I usually just wait for the commission to ask me. But the only thing I would be prepared to do is to give my independent legal opinion on how you would decide one way and then how you would decide the other way. And if that's helpful to you, great. If it's not, then we can move forward.
I so ask, please.
All right. Now, just to be clear, I'm going to go both ways on this, on how I would see an opinion potentially being supportable. In staff's favor, we've got the fact that the settlement agreement, and apparently all the parties agree that the settlement agreement on its four corners does not provide for a true-up, it provides for an absolute number. When that was approved as part of a settlement agreement, the commission relied on Section 512 of Title 26, where settlement agreements are to be encouraged, and they can be approved if they're simply in the public interest in their entirety. So that means that the commission didn't scrutinize each and every term in the settlement agreement. Now you couple that with the clause in the settlement agreement that says that this is not severable, meaning these parties are pulling out of the settlement agreement if the commission does not agree with every single term in the settlement agreement. So if you do change an item in the settlement agreement, then that calls into question your entire decision approving the settlement agreement because you applied Section 512 and that no longer applies because the other parties have now pulled out of the settlement agreement and there's no settlement agreement. So from a legal process perspective, to change it now without all the parties agreeing to the change, we've got some issues there. From a legal perspective, that's how I would decide in favor of staff. On the other side, if you look at that term now and you say to yourselves, that's an absurd result, not to allow the actual true up. We could not have meant to allow for that. It shocks the conscience. We are now, and again, this is a slippery slope, but we are now saying that that term is so absurd, we're not going to follow it. We're going to change it here and now and move forward. In that sense, I certainly agree with the company that the commission has the authority to change things moving forward. It's just that since you relied on Section 512 the first time around and didn't go through each item issue by issue, it really does call into question that entire decision. But on the other hand, if the equities are so far in favor of the company, then it would probably be supportable for you now to say, those equities shock the conscience. We are not going to follow a settlement agreement that we earlier approved when we didn't realize the repercussions that could occur if the actual numbers are so far from that absolute number that we agreed to. If one side sounds better than the other side, you can take a vote. If not, we just move forward with a motion.
Thank you, Mr. O'Brien. I guess with that, then the response was thank you.
Thank you for flying United.
We're not getting those 10 minutes back.
So I guess the pending question is, what time do you want us to assemble tomorrow? So we don't put too much pressure on the good people who are putting the minute order together. Yeah,
Could we go off the record?
absolutely.
Where's Mr. Zeminski?
He's talking to Mr. Watkins.
Mr. Watkins.
Those two, plus this gentleman here, have the answer to your question. I will speak for my learned counsel over here, and this learned counsel over there, but not for Mr. O'Brien. We do not have the answer.
Not that you're not learned.
Well, you're just counsel now.
11 o'clock?
11 o'clock it is.
All right. So I've seen this movie before, and a hypothetical, a forecast. If we are not ready at 11, and we know it by 10:30, say, do we have a plan B? Because I think unless people have a very full, presumably, everyone has tomorrow blocked.
Hang on, Jim. I've been informed that the notice, that the public notice
Yeah, we have to open it.
says 10 o'clock.
Yeah,
So
I figured we'd just do that as a matter of.
What, I'm sorry, can you clarify?
Okay,
Somebody has to be on time.
We're going to open the meeting at 10 o'clock and adjourn until 11 o'clock.
I understand, okay.
And then we'll just do it further, because I assume Commissioner Correa is going to be the representative of the commission, given comments earlier by
He
the
lives
chair.
close by, so he's volunteered to be present.
All right, so if at 11 o'clock we are not ready, then we will contact Commissioner Correa and inform him of that.
And all of us, because we're going to get on the telephone at 11 o'clock.
So how are we going to, can we just have a call-in number or
Matt
something?
Hardigan, you
Just
tell
get
Matt
Matt,
Hardigan,
just
he'll
get Matt
make
to
sure
tell
we're all
us, yeah.
talking.
Yeah, I mean, given our technical difficulties today with the phone, hopefully we'll be able to figure that out, and I'll shoot everybody an email with a number that'll work.
Okay, thank you all very much. If there's nothing further,
Mr. Chair, just one comment I'd like to make. This is the first time, I think, in 6 years on the commission that I think we've been at an impasse. It's been an exciting day, a long day, but I appreciate everybody's forbearance. Job's well done. Thanks.
May I just ask one question before we wrap? I just want to make sure this is clear, and I perhaps just didn't hear it earlier when Mr. Geddes was talking about what we would be doing with the minute order. But the two issues that you did not vote on today because either party did not accept to them, was there a vote at some point that the hearing examiner's recommendation would be adopted for those two? The customer revenue and the storm normalization? I think we still need to do that.
Well,
And then it can go, or,
Can I,
and
we could do
everything
this
else.
tomorrow. I thought we'd just do it tomorrow, but we'll do it today.
Is
if
that
that's
what you
better.
suggested?
Let's-
I'm
Let
sorry,
me
that's-
just suggest that what the commission should do
let's do it now before we forget.
is adopt the hearing examiner's report, subject to the discussions, the analysis, and the commission's decisions on the contested issues. That would mean that any uncontested issues should drop through to the hearing examiner's report.
Save for EDIT, which has been removed.
Well, say,
So that's a contested issue.
Well, but I'm
We're
just,
talking about uncontested.
it's fine.
yeah, does
Okay.
that work for you?
That works for me.
okay,
I'm about to send
I
it
so
in.
move that.
Second.
Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. So thank you for reminding us a second time on that.
I'm just trying to keep us all here one time.
And so everyone, I think, because I always try to remember, Gloria, no,
Yes.
no breaks, no whining, like some of our former quarter reporters, all day. How many pages? 450? Ah, off by 50. I hate that. Well done. I forgot we started at 10.
Mr. McCormick, Mr. McCormick? You can attend telephonically if you like.
Sure, I can attend telephonically, that's fine.
I don't think it says the word adjourn.